We'll hear arguments in number 18, Roe against Wade. Mrs. Weddington, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court. The instant case is a direct appeal from a decision of the United States District Court for the Northern District of Texas. The Court declared the Texas abortion law to be unconstitutional for two reasons. First, that the law was impermissibly vague, and second, that it violated a woman's right to determine to continue or terminate a pregnancy. Although the Court granted declaratory relief, the Court denied appellant's request for injunctive relief. The Texas law in question permits abortions to be performed only in instances where it is for the purpose of saving the life of the woman. The case originated with the filing of two separate complaints, the first being filed on behalf of Jane Roe, an unmarried pregnant girl, and the second being filed on behalf of Jane and Mary Doe, a married couple. Jane Roe, the pregnant woman, had gone to several Dallas physicians seeking an abortion, but had been refused care because of the Texas law. She filed suit on behalf of herself and all those women who have in the past, at that present time, or in the future, would seek termination of a pregnancy. In her affidavit, she did state some of the reasons that she desired an abortion at the time she sought one, but contrary to the contentions of appellee, she continued to desire the abortion, and it was not only at the time she sought the abortion that her desire was to terminate the pregnancy.
When this case was in the district court, the case of Vuitch against the United States had not been decided here.
That's correct.
Now, do you think that has disposed of some of the questions raised now?
Your Honor, I do not. In the Vuitch decision, this court was working with a statute which provided that an abortion could be performed for reasons of health or life. Our Texas statute provides an abortion only where it is for the purpose of saving the life of the woman. Since the Vuitch decision was rendered, the Texas Court of Criminal Appeals, which is our highest court of criminal jurisdiction, has held that the Texas law is not vague, citing the Vuitch decision, but saying that the Texas law is more definite than the D.C. law. So obviously the Court of Criminal Appeals doesn't feel that the two are the same. And in the Vuitch decision, the justices of this court emphasized continuously that a doctor, as a matter of routine, works with the problem of what is best for the health of his patients. We submit that a doctor is not used to being restricted to acting only when it's for the purpose of saving the life of the woman, and that health is a continuum which runs into life. And a doctor in our state does not know whether he can perform an abortion only when death is imminent or when the woman's life would be shortened. He does not know if the death must be certain or if it could be an increase in probability of her death. So here in the district, doctors are able to exercise their normal matter of judgment, whether or not the health of a woman, mental or physical, would be affected. But in Texas, we tell a doctor that unless he can decide whether it's necessary for the purpose of saving her life and for no other reason, that he is subject to criminal sanction. I think it's important to note the range of problems that could be presented to a doctor. The court, for example, cited the instance of suicide. If a woman comes in alleging that she will commit suicide, is it then necessary for him to do, or can he do an abortion for the purpose of saving her life? Or is that a situation where he has to have something more? I think all of those questions cannot be answered at this point. This brings up the married couple in our case. The woman in that case had a neurochemical condition. Her doctor had advised her not to get pregnant and not to take the birth control pill. She was using alternative means of birth control, but she and her husband were fearful that she would become pregnant, and that although the neurochemical condition would impair her health, evidently her doctor did not feel that she would die if she continued the pregnancy. And certainly they were very concerned about the effect of the statute, and her physician seemed uncertain about its implications. The doctors in our state continue to feel that our law is vague. Certainly we introduced affidavits in the lower court to that effect. Since the time of the lower court ruling, the district attorney in Texas has said that he considers the federal court decision there not to be binding, and he is, and we do have a letter from him in the first thing in our appendix to the brief, stating that he will continue to prosecute. So the doctors in Texas, even with the federal decision and even after the Vuitch decision, do not feel free to perform abortions, and instead 728 women in the first 9 months after the decision went to New York for an abortion. Texas women are coming here. It's so often the poor and the disadvantaged in Texas who are not able to escape the effect of the law. Certainly there are many Texas women who are affected because our doctors still feel uncertain about the impact of the law, even in light of the Vuitch decision.
Well, then, of course, Mrs. Weddington, you make many additional constitutional attacks upon the Texas statute, and only one was before us in the Vuitch.
Yes, Your Honor, we do.
Only the claim of unconstitutional vagueness. And the court explicitly didn't reach
Did
any
not
of the
do
other
it.
claims, and you make many other claims. But of course, before you get to any of those, there are a good many threshold questions, are there not?
Yes, Your Honor, there are. I think it's, of course, important to point out to the court that in my reading of Younger versus Harris and the companion cases, all the court was concerned about in those cases was a situation where there was an attempt to interfere with a pending state criminal prosecution. In this case, as I pointed out, the original parties to this matter are women, and in one case the husband. The women certainly are not subject to prosecution in the state of Texas. It is impossible for them to stand in the criminal dock and litigate their interests. They came seeking injunctive relief, but it was not against pending state criminal prosecutions. They were not even aware of the prosecution against Dr. Halford.
Could they under Texas law, be charged as accomplices or
No,
as
Your Honor.
co-conspirators or anything like that?
No, we have expressed Texas cases. In one situation, Woodrow versus State, an 1880 case, the woman had taken a potion to induce abortion, and the Texas court specifically said that the woman is guilty of no crime, even in that situation, and that in fact she is the victim of our law. There is no declaratory relief available for these plaintiffs. Their only forum was the federal courts, and it was to those courts that they turned.
Your three plaintiffs here, representing classes, I gather, were
Yes, sir.
one, an unmarried pregnant woman,
Yes,
two,
sir.
a married couple.
Yes. And the
Where it
doctor...
was shown that it would be injurious to the wife's health to have a child, and also injurious to her health to use the most efficient form of birth control.
Yes.
And then third is a physician
Yes,
who is under indictment, or
Yes.
was at the time of this complaint.
The physician intervened after the order was entered granting Jane Roe a three-judge court. And he intervened again, asking only that future prosecution under the law be enjoined. He did not ask any relief of the court relating to his pending state criminal prosecution. He did specifically in his complaint reserve the right to ask for future relief, but that was never done. And certainly in the future, if he were to ask for relief, the court would have the guidance of the Younger versus Harris companion cases. But there was in no way any request for any action to interfere with the pending criminal prosecutions then in process. As to, there is an allegation that the question is moot since the woman has carried the pregnancy to term. And I think it is important to realize that there are several important aspects in which this case differs from the case that the courts might usually be presented. First, the case is different in the nature of the interest which is involved and in the extent to which personal determination is undermined by this statute, the effect that it has on women. Second, it is unique in the type of injury that's presented. Certainly there are some injuries that can be compensated, and most last over a sufficient period of time for the courts to litigate the interest. But in this case, a progressing pregnancy does not suspend itself in order to give the courts time to act. Certainly Jane Roe brought her suit as soon as she knew she was pregnant, as soon as she had sought an abortion and been denied. She came to federal courts. She came on behalf of a class of women, and I don't think there's any question that women in Texas continue to desire abortions and to seek them out outside our state. There was an absence of any other remedy, and without the ability to litigate her claims as a pregnant woman who came seeking relief and whom was affected by the time required for the federal process, not because of any infirmity in her own attempts to litigate her interests, that this will in fact be a case certainly presenting substantial federal question and yet evading review in the future. I think the third way in which it is unique is, as I've stated, the fact that it is the only forum available to these women. They have no other way to litigate their interests.
Does that mean that there is no possibility of getting a declaratory judgment under Texas law?
Yes, Your Honor. Declaratory judgments in the state of Texas are limited to a situation where property rights are involved. And we also have a very unusual situation in Texas where we have two concurrent jurisdictions, one the civil and one the criminal. And there are some cases which indicate that our state Supreme Court would not have the ability to mandamus any of the criminal prosecution officers because the Texas Court of Criminal Appeals has jurisdiction as to all criminal matters in the state of Texas. So even if the woman had been able to bring a declaratory judgment, which she couldn't have gotten any sort of relief against future prosecution. And it was exactly the absence of the court granting an injunction against future prosecutions which have resulted in the irreparable injuries these women have suffered. In Texas, the woman is the victim. The state cannot deny the effects that this law has on the women of Texas. Certainly there are problems regarding even the use of contraception. Abortion now for a woman is safer than childbirth. In the absence of abortion or legal, medically safe abortions, women often resort to the illegal abortion, which certainly carry risks of death, all the side effects such as severe infection, permanent sterility, all the complications that result. And in fact, if the woman is unable to get either a legal abortion or an illegal abortion in our state, she can do a self-abortion, which is certainly, perhaps by far the most dangerous, and that is no crime. She is in our state.
The microphone won't be effective if you
Excuse me, Your Honor. Thank you. Texas, for example, it appears to us, would not allow any relief at all, even in situations where the mother would suffer perhaps serious physical or mental harm. There's certainly a great question about it. If the pregnancy would result in the birth of a deformed or defective child, she has no relief. Regardless of the circumstances of conception, whether it was because of rape, incest, whether she is extremely immature, she has no relief. I think it's without question that pregnancy to a woman can completely disrupt her life, whether she's unmarried, whether she's pursuing an education, whether she's pursuing a career, whether she has family problems. All of the problems of personal and family life for a woman are bound up in the problem of abortion. For example, in our state, there are many schools where a woman is forced to quit if she becomes pregnant. In the city of Austin, that is true. A woman, if she becomes pregnant and is in high school, must resign or must drop out of regular education process, and that's true of some colleges in our state. In the matter of employment, she often is forced to quit at an early point in her pregnancy. She has no provision for maternity leave. She cannot get unemployment compensation under our laws because the law holds that she is not eligible for employment being pregnant and therefore is eligible for no unemployment compensation. At the same time, she can get no welfare to help her at a time when she has no unemployment compensation and she's not eligible for any help in getting a job to provide for herself. There is no duty for employers to rehire women if they must drop out to carry a pregnancy to term. And of course, this is especially hard on the many women in Texas who are heads of their own households and must provide for their already existing children. And obviously, the responsibility of raising a child is a most serious one, and the time and emotional investment that must be made cannot be denied. So a pregnancy to a woman is perhaps one of the most determinative aspects of her life. It disrupts her body, it disrupts her education, it disrupts her employment, and it often disrupts her entire family life. And we feel that because of the impact on the woman, this certainly, in as far as there are any rights which are fundamental, is a matter which is of such fundamental and basic concern to the woman involved that she should be allowed to make the choice as to whether to continue or to terminate her pregnancy. I think the question is equally serious for the physicians of our state. They are seeking to practice medicine in what they consider the highest method of practice. We have affidavits in the back of our brief from each of the heads of the obstetrics and gynecology departments from each of our public medical schools in Texas. And each of them points out that they were willing and interested to immediately begin to formulate methods of providing care and services for women who are pregnant and who do not desire to continue the pregnancy. They were stopped cold in their efforts, even with the declaratory judgment, because of the DA's position that they would continue to prosecute.
Mr. Weddington, so far on the merits, you've told us about the important impact of this law, and it's made a very eloquent policy argument against it. I trust you are going to get to what provisions of the Constitution you rely on, because, of course, we'd like to sometimes, we cannot here be involved simply with matters of policy, as you know.
Your Honor, in the lower court, as I'm sure you're aware, the court held that the right to determine whether or not to continue a pregnancy rested upon the Ninth Amendment, which, of course, reserves those rights, not specifically enumerated to the government, to the people. I think it is important to note, in a law review article recently submitted to the court and distributed among counsel by Professor Cyril Means, Jr., entitled The Phoenix of Abortional Freedom, that at the time the Constitution was adopted, there was no common law prohibition against abortion, that they were available to the women of this country. Certainly, under the Griswold decision, it appears that the members of the court in that case were obviously divided as to the specific constitutional framework of the right which they held to exist in the Griswold decision. I'm a little reluctant to aspire to a wisdom that the court was not in agreement on. I do feel that that the Ninth Amendment is an appropriate place for the freedom to rest. I think the 14th Amendment is equally an appropriate place under the rights of persons to life, liberty, and the pursuit of happiness. I think in as far as liberty is meaningful, that liberty to these women would mean liberty from being forced to continue the unwanted pregnancy.
You're relying in this branch of your argument simply on the Due Process Clause of the 14th Amendment?
We had originally brought the suit alleging both the Due Process Clause, the Equal Protection Clause, the Ninth Amendment, and a variety of others.
And anything else that might have been.
Yeah, right. Since the district court found the right to reside in the Ninth Amendment, we pointed our attention in the brief to that particular aspect of the Constitution. But I think we would not presume. I do feel that in so much as members of the court had said that the Ninth Amendment applies to rights reserved to the people and those which were most important, and certainly this is, that the Ninth Amendment is the appropriate place. Insofar as the court has said that life, liberty, and the pursuit of happiness involve the very most fundamental things of people, that this matter is one of those most fundamental matters. I think in as far as the court has said that there is a penumbra that exists to encompass the entire purpose of the Constitution, that I think one of the purposes of the Constitution was to guarantee to the individual the right to determine the course of their own lives, insofar as there was perhaps no compelling state interest, and we allege there is none in this case. That there again, the right fits within the framework of the previous decisions of this court.
What is the asserted state interest? Is there any legislative history about this statute?
No, sir, Your Honor. No, sir, there is not. The only legislative history, of course, is that which is found in other states, which has been pointed out to the court before, and Professor Means points out again that these statutes were adopted for the health of the mother. Certainly the Texas courts have referred to the woman as being the victim, and they have never referred to anyone else as being the victim. Times have certainly changed. I think it's important to realize that in Texas, self-abortion is no crime. The woman is guilty of no crime, even though she seeks out the doctor, even though she consents, even though she participates, even though she pays for the procedure. She, again, is guilty of no crime whatsoever. It's also interesting that our statute, the penalty for the offense of abortion depends on whether or not the consent of the woman was obtained prior to the procedure. It's double if you don't get her consent. There is no indication in Fondren v. State, for example. The court ruled that a woman who commits an abortion on herself is guilty of no crime. Again, she being regarded as the victim rather than the perpetrator of the crime. Obviously, in our state, the offense is not murder. It is an abortion, which carries a significantly lesser offense. There is no requirement of, even though the state in its brief points out the development of the fetus at an 8-week period, the same state does not require any death certificate or any formalities of birth. That the products of such a conception would be handled merely as a pathological specimen.
And the statute doesn't make any distinctions based upon at what period of pregnancy the abortion is performed?
No, Your Honor. There is no time limit or indication of time whatsoever. So I think...
Well, do you make any distinctions?
No, sir, I do. I feel that the question of a time limit is not strictly before the court because of the nature of the situation in which the case is handled. Certainly, I think as a practical matter, though, most of the states that do have some time limit indicated still permit abortions beyond the time limit for specified reasons, usually, again, where the health of the mother is involved.
What's your constitutional position there?
As to a time limit?
What about whatever clause of the Constitution you rest on? The Ninth Amendment, due process, the general pattern, penumbras?
It is our position...
Will that take you right up to the time of birth?
It is our position that the freedom involved is that of a woman to determine whether or not to continue a pregnancy. Obviously, I have a much more difficult time saying that the state has no interest in late pregnancy.
Why is that?
I think it's more the emotional response to a late pregnancy rather than it is any constitutional.
Response by whom?
I guess by persons considering the issue outside the legal context. I think as far as the state...
Well, do you or don't you say that the constitutional
I would say the
right you insist on reaches up to the time of birth?
The Constitution, as I read it and as interpreted and documented by Professor Means, attaches protection to the person at the time of birth. Those persons born are citizens. The enumeration clause, we count those people who are born. The Constitution, as I see it, gives protections to people after birth.
Mr. Whittington, the issue here, I guess, on your appeal is whether you are entitled to injunctive relief.
Yes, sir.
Assuming that in all other respects your argument were accepted, why do you think, in addition to declaratory relief, you're entitled to injunctive relief? Those are different things, aren't they?
Yes, sir. Certainly, in your dissent, you point out in Perez versus Ledesma, concurring and dissenting opinions.
That was a dissent.
It was a dissent thing. That there are different standards which apply to the declaratory judgment and to injunctive relief.
Well, I guess we said that in Switzerland before.
Yes, that's correct. And that's what the court said following Zwickler versus Cuda, that even though they were granting declaratory relief, that different considerations applied as to injunctive relief. But it seems that the opinions of this court have established that where there is great and immediate threat of irreparable injury with no adequate remedy in state courts, that an injunction is still proper. And it is our position that there is great and immediate threat of irreparable injury in the form of a continuing pregnancy that will not abate and that continues.
So you're really you're asserting that the pregnant woman has standing in this case, and the married couple where the wife is not pregnant has standing.
Yes, Your Honor.
What about the doctor where a criminal prosecution was already pending against it?
The doctor, as I said, was asking no relief as to the pending prosecution. He was only asking relief as to future prosecution.
He was asking for a declaratory judgment.
Yes, Your Honor. He joined in both the request for the declaratory judgment.
Well, didn't Younger and the companion cases cover the declaratory judgment background?
Where there were pending, Samuels versus Mackle, as I read it, did say that where you have a request for declaratory judgment, there would be an effect on a pending criminal prosecution.
There was one pending when this action
There was one pending when this action was brought, that one of those against Dr. Halford. However, in this case, we submit that if there is to be any meaning to the federal courts as the supreme arbiters of constitutional rights, that they must be able to act, at least in some form, when there are pending criminal prosecutions, not particularly against the person involved in the prosecution, but other
cases said that indeed the federal courts may, but I thought limited situations to those of harassment, where the prosecution improperly is used as a device to harass the person prosecuting. Wasn't that it?
Yes, Your Honor, but again, as I understood it...
You're suggesting it ought to be broader than that?
I'm suggesting that in this case, the women in particular brought a declaratory action, having nothing to do with the pending state criminal prosecution, and that the intervention of the doctor certainly should not be sufficient as to the
doctor's case.
Right. That that because the doctor intervened when he was asking no relief as to the pending state criminal prosecution, that his intervention...
You mean he was asking what? No injunction against the continuance of that process?
That's correct. He is willing to litigate his interest as to future prosecution.
Well, except that he wanted a declaratory judgment, as I understand it.
Yes,
the underlying statute on which the prosecution was brought is unconstitutional. Isn't that it?
Yes.
Well, I thought that's what Samuels and Michael said he couldn't have.
And which your dissent said was incorrect.
Well, I repeat.
It was a dissent. Okay. I think perhaps we would stress that there are two separate actions before the court. First, that of the women, and second, that of the doctor.
So that even though
the court might find that the doctor was an inappropriate party for relief, it certainly would not affect the original action as brought by the women.
All right, then I come back again. If we're left only with the ladies' action, you're suggesting that the declaratory relief they already obtained is not enough because that doesn't help terminate the pregnancy.
Because they are still subject to the irreparable injury and have no adequate state remedy. And if they are not able to continue to litigate their interests in this situation, anytime there was any prosecution pending against anyone in the state at any point in the appeal, for example, the Thompson case was filed in 1968. It's been decided now in our state courts. It's on appeal, or it will be appealed here, I think. And certainly, if they cannot litigate their interests while there's prosecution pending against a doctor, they will, in many instances where a statute, where there's...
Well, I suppose the answer is that prosecution against the doctor, there's not going to be any doctor that's going to be available. Is that it?
Yes, they cannot even decide to take the risk for themselves under the declaratory judgment. They must rely on another person to take that risk. But certainly the doctor raised not only his own rights, but the rights of his patients. And those same patients are suffering the same sort of irreparable injury that the original plaintiffs were suffering.
Couldn't the doctor raise that same point in the criminal prosecution?
Yes, Your Honor, he can, but I don't feel it's appropriate to make those women who are most vitally affected, certainly more so than the doctor, who can merely decide not to perform an abortion and thereby escape.
I'm only talking about the doctor. You said there were two separate issues here. And the issue involving the doctor is to litigate everything he's now litigating in the state court.
Yes, Your Honor. My point being that these women should not be compelled to leave it up to a doctor to litigate those issues.
Oh, well, he's going to obviously defend himself in a criminal prosecution, isn't he? You can count on him to do that.
Well, I think there are different interests involved, and in most criminal prosecutions, the doctors would bring up other problems, such as...
I didn't do it, or something.
Yeah, or the witnesses have disappeared, or it really was for this reason in this particular case.
But has this defense ever been interposed in a Texas criminal case?
Yes, Your Honor.
Constitutional defense?
There is one recent opinion, Thompson versus the state of Texas, which the Attorney General attempted to bring to the attention of the court, and it was not printed, and the court rejected it. But it was a decision about a month and a half ago, which originated in Houston. A doctor there was indicted on a charge of abortion. At trial, he used only an alibi defense. But on his appeal, he did raise the same constitutional questions that we raised in the federal court.
The court said that was too late?
No, Your Honor, they could have, but they didn't. They went ahead and litigated those issues. And our Texas Court of Criminal Appeals, which is our highest court, has now held that the statute is not vague, citing Vuitch, which again I would contend is an incorrect reliance.
That's the case you cited to the Chief Justice
yes.
in your argument.
And second, that they specifically did not determine whether or not there was a right to privacy, but did hold there was a compelling interest. So in that particular situation, which is the only situation, a doctor did attempt to litigate the same issue.
And the Texas Court of Criminal Appeals has basically upheld the constitutional validity of
they
the
upheld really directly in opposition to the federal court opinion from which we are appealing. They have filed a motion for rehearing in the State Court of Criminal Appeals, which will be argued tomorrow. I think it's very unlikely that the court would change its opinion, and it is the intention of those parties to appeal.
Does Texas law, in other areas of the law, give rights to unborn children in the areas of trusts and estates and wills? Or in
no,
the
Your Honor,
of
only if they are born alive. We have the Supreme Court of Texas recently has held in one case that there is an action for prenatal injuries at any stage prior to birth, but only upon the condition that it be born alive. The same is true of our property law. The child must be born alive. And I think there is a distinction between those children which are ultimately born, and I think it is appropriate to give them retroactive rights. But I think that's a completely different question from whether or not they had rights at the time they were still in the womb.
What about the unborn child who is, as a result of an accident, killed, or whatever word you want to use for it?
There has been no situation litigated like that in Texas. I suppose you noted that the
Iowa... around the country?
The Iowa Supreme Court about 2 weeks ago held that where it was stillborn, there was no cause of action whatsoever. The child... For the mother... Well, now, I'm speaking, solely for the fetus, that the fetus had no independent right, that the mother...
What about the mother recovering for the death of the child? Or for the, whatever you want to call it.
Only for her injury.
Only for her.
Yes.
Does that include anything with regard to the child?
No, Your Honor. Thank you.
Thank you, Mrs. Weddington. Mr. Floyd.
Mr. Chief Justice, may it please the court. It's an old joke, but when a man argues against two beautiful ladies like this, they're going to have the last word. Before I proceed to the original issue in this case, which was the propriety of the trial court denying injunctive relief, I would like to bring to the court's attention some grave matters concerning what has been referred to as the standing of the parties. The couple involved, they were a married couple, a childless married couple. The only matter, evidence, or whatever in the record concerning their contentions is contained in their first amended original petition. That is, that the woman would have difficulty if she became pregnant in carrying a child at childbirth. Further, that they were unprepared for parenthood. We submit to the court that their cause of action is strictly based upon conjecture. Will they continue the marriage? Will her health improve? Will they then be, at some time in the future, prepared or unprepared for parenthood? There is no fear of prosecution by married doe. If we accept all contentions of this married couple, we submit that they still do not come under the prescribed conditions of Glass versus Cohen and Golden versus Zwickler. We feel that the lower court properly denied them standing. As to the unmarried pregnant female, a unique situation arises in, is her action now moot? Of course, if moot, there is no case or controversy.
Class action, I think.
It was a class action.
Surely you would, I suppose we could almost take judicial notice of the fact that there are at any given time unmarried pregnant females in the state of Texas.
Yes, Your Honor. I would say that the only thing that could uphold her standing would be, or eliminate the mootness issue, would be whether or not this is a class action on her part. Yes, Your Honor. The record that came up to this court contains the amended petition of Jane Roe, an unsigned alias affidavit, and that is all. She alleges that she was pregnant on April the 20th, 1970, which is some 21 months ago. Now, I think that it has been recognized by the appellant's counsel that she is no longer pregnant. This court has consistently held that the time of determination of mootness is when the hearing is before the court. That is, a case can become moot from the hearing in the trial court until the time it reaches this court. We do not feel appellant's authority contained in their brief will substantiate her contention that the case is not moot. I might add this, that I believe the law to be that if there is a reasonable possibility of reoccurrence of the situation, then the case would not be moot. Now, this is the W.T. Grant case. The other case or cases concern orders of the Interstate Commerce Commission, which the court holds that there is a possibility or a reasonable possibility of continuation of those orders and the capability of repetition. It deals mainly with the capability of repetition. We think the case of Jane Roe can be easily compared to Hall versus Beals. In that particular case, a group of voters instituted a class action complaining of a Colorado statute which prescribed a residency requirement of 6 months. They had, at the time, lived in the state, or at the time of the election, lived in the state some 4 or 5 months. The case came up through the lower courts of this court, and in the meantime, Colorado repealed the statute and established a 2-month residency requirement. The election was held in the meantime. The trial court plaintiffs complained of the 2 months residency requirement. This court held the cause of action moot, even though it was denominated as a class action.
There's a big difference Colorado had amended its statute and Texas has not.
That is correct, Your Honor. But the fact was that you still had, if it is what we want to call it, the evil still existing at 2 months.
But it was the other statute that had been the subject of the litigation. And that statute had been amended.
I say there is.
Field. That's not true here.
It's not what we call white horse, Your Honor, I understand. In connection with the class action aspect of this, and I say I have no authority to support this proposition, but it would appear that in order for a class action to continue, if there be one to begin with, is that one plaintiff must remain, or else an intervenor or someone to be a representative of a class. Because this is the whole purpose of the class action, to have a representative in court. Now, the position of the appellant Halford.
How do you suggest, if you're right, what procedure would you suggest for any pregnant female in the state of Texas ever to get any judicial consideration of this constitutional claim?
Your Honor, let me answer your question with a statement, if I may. I do not believe it can be done. There are situations in which, of course, as the court knows, no remedy is provided. Now, I think she makes her choice prior to the time she becomes pregnant. That is the time of the choice. It's like more or less, the first 3 or 4 years of our life, we don't remember anything. But once a child is born, a woman no longer has a choice. And I think pregnancy may terminate that choice as well.
Maybe she makes her choice when she decides to live in Texas.
May I proceed? There's no restriction on moving. No. Your Honor, the appellant Halford is under 2 indictments, charged with the offense of performing an abortion. There are no allegations in the complaint of appellant Halford, or none in his affidavit, that there is any bad faith prosecution, bad faith arrest, harassment of him at all to bring him within Dombrowski's special circumstances. We think the cases of Younger versus Harris and Samuels versus Michael are controlling as to Dr. Halford's position. We also feel like that Dr. Halford cannot rely upon his patient's rights to bring him into federal court, and I think the Tillotson versus Ullman case will be authority for that proposition. As to the matter of injunctive relief, after a court once grants declaratory relief, I will make this comment that it appears the court can consider the propriety of declaratory relief and can consider the propriety of injunctive relief. That is, the court can divorce the two. And once granting declaratory relief that a statute is unconstitutional, in its discretion can determine whether or not injunctive relief is proper and deny it, if it so feels. Now, should this court, as I understand it, and all of the parties feel that if this court once acquires jurisdiction of the matter, that the parties would like the court to consider all the constitutional issues.
Are you sustaining, or are you saying that the denial of injunction was proper because the declaratory judgment was error?
No, Your Honor, I say the court can grant declaratory relief as an unconstitutionality and deny injunctive relief.
Well, I know, but certainly if the judgment about if the declaratory judgment was erroneous, it was also right to deny an injunction.
Yes, Your Honor.
Is that your position?
That's correct. I think if the court, of course, says...
You didn't cross-appeal it.
We could not, to this court, Your Honor. We have to go to the Fifth Circuit. So we have.
But are you attempting to sustain the denial of an injunction here on the grounds that the declaratory judgment was improper?
We are asking the court, petitioning the court to do this, that if the court gets into the merits of injunctive relief, whether or not it was proper under the circumstances, that this court go forward and continue the constitutional issues and make a determination of the Constitution.
Can we do that? You're in the Fifth Circuit because we said that you couldn't cross-appeal from a declaratory judgment. You could only cross-appeal from an injunctive grant or denial of
Yes, Your Honor.
I suppose we could do it if we bypass the Court of Appeals and bring up your appeal pending in the Fifth Circuit.
No, couldn't we? You're here. Your opponent has brought a direct appeal here because your opponent was denied an injunction by the three-judge district court.
Yes, sir.
You could not bring a cross-appeal here because you won from the point of view of successfully resisting the injunction.
Yes, sir.
But now that you're here as the appellee, you're arguing that an injunction should not have issued, and part of that argument very legitimately can be that on the merits the court was wrong and that it shouldn't have issued a declaratory judgment or an injunction.
That's correct, Your Honor.
And that is your position?
Yes, Your Honor. Now, the proceedings in the Fifth Circuit have been stayed or abated.
I must say, your position makes sense to me. But don't some of our prior cases rather foreclose it unless we bypass the circuit and bring your appeal pending there here?
Well, Your Honor, and I don't want to be repetitious, but a motion has been filed in the Fifth Circuit to hold the appeal in abeyance until a determination by this court.
You didn't file any motion here asking us to bring your appeal pending in the Fifth Circuit here for decision with this appeal, did you?
No, we have requested that in our reply to the jurisdiction and in our brief. We have presented it in that manner. Your Honor, we feel that this court can and should consider all issues, and under the Sterling, the Florida lime and avocado growers, and the Carter cases, which are cited in the briefs of the parties.
What is Texas' interest in this statute?
Mr. Justice, the Thompson case, which has been cited with the court, Thompson versus State, the Court of Criminal Appeals did not decide the issue of privacy. It was not before the court, or the right of choice issue. The state court, the Court of Criminal Appeals, held that the state had a compelling interest because of the protection of fetal life, protection. They recognized the humanness of the embryo or the fetus. And they said, we have an interest in protecting fetal life. Whether or not that was the original intent of the statute, I have no idea.
And yet Texas does not attempt to punish a woman who herself performs an abortion on herself.
That is correct, Your Honor, and the matter has been brought to my attention, why not punish for murder, since you are destroying what has been said to be a human being. I don't know, except that I will say this, as medical science progresses, maybe the law will progress along with it. Maybe at one time it could be possible, I suppose, a statute could be passed. Whether or not that would be constitutional or not.
Well, we're dealing with the statute as it is. There's no state, is there, that equates abortion with murder, or is there?
There is none, Your Honor, except one of our statutes that if the mother dies, that the doctor shall be guilty of murder.
But that's ordinary.
Yes.
Felony murder.
I would say so, Mr. Justice. Yes.
The Texas statute covers the entire period of pregnancy.
Yes, it does, Mr. Justice. Yes, sir.
Mr. Floyd, is that Thompson case? I don't find that Thompson case cited in the brief. I gather you said it just had been decided recently.
Mr. Justice, this case is just a recent case.
Do you have a citation?
It is not in the reporter system yet.
Are you going to provide us with a copy of it?
I'll be happy to, yes, sir. I'll provide the court with copies of that. This is number 44070, C.W. Thompson versus the state of Texas. The opinion was delivered on November the 2nd, 1971. I shall be happy to furnish the court with this copy if the court so desires.
That's the Court of Criminal Appeals.
Yes, Your Honor.
And that's the case Mrs. Whittington told me is pending on motion for rehearing.
Yes, Your Honor. Now, there's one other.
If you leave that with the clerk, Floyd, we'll distribute copies here.
That, in addition, the Thompson case cited Bute's case in regard to vagueness and said that it was controlling the issue. And as I recall, Dr. Thompson raised the issue of, well, how can you find me guilty of of abortion, if you make no determination that the fetus is alive at the time I performed this, in effect, is what he's saying. He never admitted doing it, but he's saying it. How can you prove it? Well, of course, the Texas court answered by saying it is presumed the fetus is alive when an abortion is performed.
You say that, in answer to my brother Marshall's question as to what is the interest of the state in this legislation, or even what is its purpose, what is its societal purpose, your answer was, I think, relying on your opinion of the most recent opinion of the Court of Criminal Appeals of Texas, that it was the protection of fetal life. And then I think you also said that was perhaps not its original purpose.
Well, I'm not sure of that.
Well, it may be rather important. In a constitutional case of this kind, it becomes quite vital sometimes to rather precisely identify what the asserted interest of the state is.
I think that original purpose, Mr. Justice, and a present prevailing purpose may be the same in this respect. There have been statistics furnished to this court in various briefs from various groups and from medical societies of different groups of physicians and gynecologists or whatever it may be. These statistics have not shown me, for instance, for example, that abortion is safer than normal childbirth. They have not shown me that there are not emotional problems that are very important resulting from an abortion. The protection of the mother at one time may still be the primary, but the policy considerations, Mr. Justice, would seem to me to be for the state legislature to make a decision.
Certainly that's true. Policy questions are for legislative and executive bodies, both in the state and federal government. But we have here a constitutional question, and in deciding it, assessing it, it's important to know what the asserted interest of the state is in the enactment of this legislation.
I am, and this is just from I speak personally, may I may. I would think that even when this statute was first passed, there was some concern for the unborn fetus.
When was it enacted?
I believe it was 1859 was the original statute. This, I believe, was around 1900, 1907.
It goes back middle of the 19th century?
Yes, sir.
Before that, there were no criminal abortion laws in Texas, were there?
As far as I know, there were not. I think this is maybe set out in some of the briefs.
Well, in any event, Mr. Floyd, apart from your personal attitude, your court has spoken on the intent of the statute.
Yes.
Is it not?
Yes.
Well, I can't quite square that most recent pronouncement with the earlier decisions of the Texas court that refer to the mother as the victim. Can you?
Well, as I say, Your Honor, I don't think the courts have come to the conclusion that the unborn has full juristic rights. Not yet. Maybe they will. I don't know. I just don't feel like they have at the present time.
In the first few weeks of pregnancy?
Sir?
In the first few weeks of pregnancy?
At any time, Mr. Justice, we make no distinction in our statute.
No distinction whether there's life there or not.
We say there is life from the moment of impregnation.
And do you have any scientific data to support that?
Well, we begin, Mr. Justice, in our brief with the development of the human embryo, carrying it through to the development of the fetus from about 7 to 9 days after conception.
Well, what about 6 days?
We don't know.
But the statute goes all the way back to 1 hour.
I don't, Mr. Justice, there are unanswerable questions in this field.
I appreciate it.
This is an artless statement on my part.
I withdraw the question.
Thank you. Or when does the soul come into the unborn? If a person believes in a soul, I don't know. I assume the appellants now are operating under the Ninth Amendment rights. There are allegations of First Amendment rights being violated. However, I feel there is no merit. This statute does not establish any religion, nor does it prohibit anyone from practicing or being a part of any religious group. I see no merit in their contentions that it could possibly be under freedom of speech or press. In fact, there was been some articles recently in this city's newspaper yesterday, for instance, about it. The other constitutional rights that the appellant speaks of, I think, are expressed in two manners. The individual or marital right of privacy. And secondly, or the right to choose whether or not to abort a child. Now, if the does are out of the case, the marital privacy is out of the case. But be that as it may, neither individual nor marital privacy has been held to be absolute. We have legal search and seizure. We have the possession of illegal drugs, the practice of polygamy, and other matters. A parent, I do not believe, or parents cannot refuse to give their child some form of education. As far as the freedom over one's body is concerned, this is not absolute. The use of illicit drugs, the indecent exposure legislation, and as Mr. Goldberg stated in the Griswold case, that adultery and fornication are constitutional beyond doubt.
Are constitutional, or you mean laws against them are constitutional?
The laws against them are constitutional. Sorry. Now, there is nothing in the United States Constitution concerning birth, contraception, or abortion. Now, the appellee does not disagree with the appellant's statement that a woman has a choice. But as we have previously mentioned, we feel that this choice is left up, it's the woman's prior to the time that she becomes pregnant. This is the time of the choice. Now, this was brought out in the Rosen versus Louisiana State Board of Medical Examiners case, and in Corky versus Edwards, which are lower court opinions, and my understanding is that Corky versus Edwards has been adopted in this court. Has been, yes, Your Honor. I'm not positive, but I think it has been.
Texas doesn't grant any exemption in case of rape. The woman, their pregnancy has resulted from rape, either statutory or otherwise.
There is nothing in our statute about that. Now, the procedure...
And such a woman wouldn't have had a choice, would she?
The procedure, and I'm telling the court something that's outside the record, but I understand the procedure when a woman is brought in after rape is to try to stop whatever has occurred immediately by the proper procedure in the hospital immediately she's taken there, if she reports it immediately. But no, there is nothing in our statute. Now, as I previously informed the court, the statistics are the people who prepare the statistics, and the different statistics are not in conformity in connection with the medical aspects of abortion, that is, whether or not it's safer. There are some statistics that will say it is. There are statistics that say it's not. It has been provided to this court the common law and the legislative history of abortion, and that the morality of abortion has been injected in various cases and by various groups. We think these matters, the matters of policy, should be properly addressed by the state legislature. We think that the consideration should be given to the unborn, and in some instances, a consideration should be given for the father if he would be objective to abortion. Thank you, Your Honor.
Floyd, your time is consumed unless you have some correction you wish to make, Mrs. Whittington.
Your Honor, I would only like to draw to the court's attention at page 130 of the record the notice of appeal by defendant State of Texas from the judgment of the district court to the Supreme Court of the United States. They have filed an appeal in this court.
Thank you. Thank you, Mrs. Whittington. Thank you, Mr. Floyd. The case is submitted. We'll hear arguments next in number... First, in number 70, 18, Roe against Wade. Mrs. Whittington, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court, we are once again before this court to ask relief against the continued enforcement of the Texas abortion statute, and ask that you affirm the ruling of the three-judge court below, which held our statute unconstitutional for two reasons. The first, that it was vague, and the second, that it interfered with the Ninth Amendment right of a woman to determine whether or not she would continue or terminate a pregnancy. As you will recall, there are three plaintiffs and one intervenor involved here. The first plaintiff was Jane Roe, an unmarried pregnant girl who had sought an abortion in the state of Texas and was denied it because of the Texas abortion statute, which provides an abortion is lawful only for the purpose of saving the life of the woman. In the original action, she was joined by a married couple, John and Mary Doe. Mrs. Doe had a medical condition. Her doctor had recommended first that she not get pregnant, and second, that she not take the pill. After this cause was instituted, and after, in fact, the three-judge court had been granted, those three plaintiffs were joined by an intervenor, Dr. Halford, who was, at the time he intervened, under a pending state criminal prosecution under the statute. He did not ask that his prosecution be stopped by the court, but rather joined in the original request for a declaratory judgment and injunctive relief against future prosecutions. As a matter of fact, his prosecution has not been continued, but the district attorney against whom we filed the suit has taken a position that because there was no injunction, he is still free to institute prosecutions. There is a letter from his office in the appendix stating that he will continue prosecutions, and in fact there have been a very limited number of prosecutions instituted in the state of Texas since the three-judge court entered its declaratory judgment.
Prosecutions of doctors you're speaking of? Prosecutions
of doctors, yes, sir. The problem that we face in Texas is that even though we were granted a declaratory judgment ruling the law unconstitutional, and even though we've been before this court once in the past, in Texas women still are not able to receive abortions from licensed doctors because doctors still fear that they will be prosecuted under the statute. So if the declaratory judgment was any relief at all, it was an almost meaningful relief, because the women of Texas still must either travel to other states if they are that sophisticated and can afford it, or they must resort to some other very undesirable alternatives.
You said meaningful. You meant meaningless, didn't you?
Yes, it's just. In fact, we pointed out in our supplemental brief filed here that there have been something like 1,600 Texas women who have gone to New York City alone for abortions in the first 9 months of 1971. In addition, I think the court would recognize there are many other women going to other parts of the country. One of the objections that our opponents have raised is saying that this court is moot because, of course, the woman is no longer pregnant. It's been almost 3 years since we instituted the original action. And yet we can certainly show that it is a continuing problem to Texas women. There still are unwanted pregnancies. There are still women who, for various reasons, do not wish to continue the pregnancy, whether because of personal health considerations, whether because of their family situation, whether because of financial situations, education, working situations, some of the many things we discussed at the last hearing. Since the last hearing before this court, there have been a few cases decided that we wanted to draw the court's attention to and are covered in our supplemental brief. In addition, there is a supplemental brief filed by an amicus party, Harriet Pilpel, on behalf of Planned Parenthood of New York, that seeks to point out to the court at pages 6 and 7 and subsequent pages some of the changing medical statistics available regarding the procedure of abortion. For example, that brief points out that the overall maternal death rate from legal abortion in New York dropped to 3.7 per 100,000 abortions in the last half of 1971, and that in fact is less than half the death rate associated with live delivery for women. That in fact the maternal mortality rate has decreased by about 2/3 to a record low in New York in 1971. That now in 1971, New York recorded the lowest infant mortality rate ever in that state. That during the first 18 months of from July 1st, 1970 to December 31st, 1971, out-of-wedlock pregnancies have dropped by 14%. We now have other statistics coming from California and other states that show that not only has the overall birth rate declined, but the welfare birth rate has also declined accordingly. As to the women, this is their only forum. They are in a very unique situation for several reasons. First, because of the very nature of the interest involved. Their primary interest being the interest associated with the question of whether or not they will be forced by the state to continue an unwanted pregnancy. In our original brief, we alleged a number of constitutional grounds. The main one that we are relying on before this court are the 5th, the 9th, and the 14th Amendments. There's a great body of precedent. Certainly we cannot say that there is in the Constitution so stated the right to an abortion, but neither is there stated the right to travel or some of the other very basic rights that this court have held are under the United States Constitution. The court has in the past, for example, held that it is the right of the parents and of the individual to determine whether or not they will send their child to private school, whether or not their children will be taught foreign languages, whether or not they will have offspring, the Skinner case, whether the right to determine for themselves whom they will marry, the Loving case, and even in Body versus Connecticut, the choice saying that marriage itself is so important that the state cannot interfere with termination of a marriage just because the woman is unable to pay the cost. Griswold, of course, is the primary case, holding that the state could not interfere in the question of whether or not a married couple would use birth control. And since then, this court, of course, has held that the individual has the right to determine whether they are married or single, whether they will use birth control. So there is a great body of cases decided in the past by this court in the areas of marriage, sex, contraception, procreation, childbearing, and education of children, which says that there are certain things that are so much a part of the individual concern that they should be left to the determination of the individual. One of the cases decided since our last argument, December 13th, was the second Connecticut case, Abel versus Markle, which Judge Newman wrote the opinion, yes, thank you. And Judge Lombard concurred. Part of in that case, that three-judge court held the Connecticut statute, a slightly revised statute for the second time, to be unconstitutional. And part of the language of that case pointed out that no decision, and I'm quoting, of the Supreme Court has ever permitted anyone's constitutional right to be directly abridged to protect a state interest which is subject to such a variety of personal judgments. And certainly the amicus briefs stacked before the court show the variety of personal judgments that come to bear on this particular situation. To oppose such a statute, the court said, would be to permit the state to impose its view of the nature of a fetus upon those who have the constitutional right to base an important decision in their personal lives upon a different view. Again, this is a very special type case for the women because of the very nature of the injury involved. It is an irreparable injury. Once pregnancy has started, certainly this is not the kind of injury that can be later adjudicated. It is not the kind of injury that can later be compensated by some sort of monetary reward. These women who have now gone through pregnancy and the women who continue to be forced to go through pregnancy have certainly gone through something that is irreparable, that can never be changed for them. It is certainly great and it is certainly immediate. There is no other forum available to them. As we talked last time, they are not subject in Texas to any kind of criminal prosecution, whether the woman performs self-abortion, whether she goes to a doctor, finds someone who will perform it on her. She is guilty of no crime whatsoever. And yet the state tries to allege that its purpose in this statute was to protect the fetus. If that's true, the fact the woman is guilty of no crime is not a reasonable kind of it does not reasonably follow. The women are not able to have any kind of declaratory judgment in Texas because of our special declaratory judgment statutes and our concurring criminal and civil courts, the two different lines of cases that we have. So the federal court was the only court to which the women had any kind of access, and it was to the federal courts they came, and it's the federal court, in my judgment, that should determine this case. It's a very unique kind of harm, certainly, that was done to them. Even though there are many cases, some very recent from this court, talking about the problem of when a state may interfere when or the federal judiciary may interfere when there is a pending state criminal prosecution. This case does come under the exceptions in that there is great, immediate, irreparable injury where there is no other forum. It is something that, as far as these women are concerned, can never be adjudicated in a criminal prosecution, much less in a single criminal prosecution. It certainly is an instance of a situation that is capable of repetition, yet evading review. The judiciary simply does not move fast enough for the case to be decided within the period of gestation, much less within the period within which an abortion would be medically safe for these women. The state has alleged, and its only alleged interest in this statute is the interest in protecting the life of the unborn. However, the state has not been able to point to any authority of any nature whatsoever that would demonstrate that this statute was in fact adopted for that purpose. We have some indication that other state statutes were adopted for the purpose of protecting the health of the woman. We have an 1880 case in Texas, shortly after the 1854 statute was adopted, that states that the woman is the victim of the crime and is the only victim the court talks about. We have all the contradictions in the statute and the way so many things that just don't make sense. If the statute was adopted for that purpose, for example, why is the woman guilty of no crime? If the statute was adopted for that purpose, why is it that the penalty for abortion is determined by whether or not you have the woman's consent?
Regardless of the purpose for which the statute was originally enacted or the purpose which keeps it on the books in Texas today, you would agree, I suppose, that one of the important factors that has to be considered in this case is what rights, if any, does the unborn fetus have?
That's correct. There have been two cases decided since the December 13th argument that expressly hold that a fetus has no constitutional rights, one being Byrne versus New York and the other being the McGee Women's Hospital cases. In both situations, a person sought to bring that very question to the court. Does a fetus, in the one instance, Byrne was a challenge to the New York revised statute. The other was a situation where a person sought to prevent McGee Women's Hospital from allowing further abortions to be done in that hospital. And in both cases, it was held that the fetus had no constitutional rights. Several of the briefs before this court would also argue that this court, in deciding the Vuitch case, which has allowed abortions to continue in the District of Columbia, certainly the court would not have made that kind of decision if it felt there were any ingrained rights of the fetus within the Constitution. There is also, of course...
Was it critical to your case that the fetus not be a person under the due process clause?
It seems to me that it is critical first that we prove this is a fundamental interest on the behalf of the woman, that it is a constitutional right.
Well,
and
yes,
second,
but how about the fetus?
Okay, and second, that the state has no compelling state interest. Okay, and the state is alleging a compelling state interest.
Well, yes, but I'm just asking you, under the federal Constitution, is the fetus a person for the purpose of the protection of the due process clause?
All of the cases, the prior history of this statute, the common law history, would indicate that it is not. The state has shown no...
Well, what if would you lose your case if the fetus was a person?
Then you would have a balancing of interest.
Well, you have anyway, don't you?
Excuse me?
You have anyway, don't you? You're going to be balancing the rights of the mother against the rights of the fetus.
It seems to me that you do not balance constitutional rights of one person against mere statutory rights of another.
You think a state interest, if it's only a statutory interest or a constitutional interest under the state law, can never outweigh a federal constitutional right?
I think it would seem to me that...
So all the talk of compelling state interest is beside the point. It can never be compelling enough.
If the state could show that the fetus was a person under the 14th Amendment or under some other amendment or part of the Constitution, then you would have the situation of trying... you would have a state compelling interest, which in some instances can outweigh a fundamental right. This is not the case in this particular situation.
Do you make any distinction between the first month and the 9th month of gestation?
Our statute does not.
Do you, in your position in this case?
We are asking in this case that the court declare the statute unconstitutional, the state having proved no compelling interest at all. There are some states that now have adopted time limits. Those have not yet been challenged, and perhaps that question will be before this court. Even those statutes, though, allow exceptions. Well, for New York, for example, says an abortion is lawful up to 24 weeks. But even after the 24 weeks, it is still lawful where there's rape or incest, where the mother's mental or physical health is involved. In other words, even after that period, it's not a hard and fast cutoff.
Then it's the weighing process Mr. Justice White was referring to. Is that your
The legislature,
position?
in that situation, engaged in the weighing process. And it seems to me that it has not yet been determined whether the state has the compelling interest to uphold even that kind of regulation. But that's really not before the court in this particular case. We have no time limit. There is no indication in Texas that any would be applied in any future date. You know, we just don't know that. But
Mrs. Weddington, you're attacking the statute on two grounds, are you not? Both
That's
vagueness
correct.
and the Ninth Amendment. Do you place any greater weight on one argument as against the other?
Our Texas Court of Criminal Appeals in Thompson versus State.
That's the recent case.
Yes, in November of
Again,
last
off
year.
on vagueness.
Yes. That particular case held that the Texas statute was not vague, citing Vuitch. It's my opinion that that reliance was misplaced. That in Vuitch, this court had before it the D.C. statute which allowed abortion for the purpose of saving the life or the health. And this court adopted the interpretation that health meant both mental and physical health. And it seemed to me the court's language in that case talked a great deal about the fact that the doctor's judgment goes to saving the health of the woman, that that's the kind of judgment he is used to making. In Texas, that's not the judgment he's forced to make. The judgment in Texas is this necessary for the purpose of preserving the life of the woman? And the language of that statute has never been interpreted. That's not the kind of judgment that a doctor is accustomed or perhaps even able to make.
Well, I'll go back to my question. Are you...
I still continue the argument that the Texas case is vague.
So you're relying on both?
Yes, Your Honor, we are.
Now, you referred a little bit to history, and let me ask you a question based in history. You're familiar with the Hippocratic Oath?
I am.
I think I may have missed it, but I find no reference to it in this, in your brief or in the voluminous briefs that we're overwhelmed with here. Do you have any comment about the Hippocratic Oath?
I think two things could be said. The first would be that situations and understandings change. In this case, for example, we have before the court a medical amicus brief that was joined by all the deans of the public medical schools in Texas. It was joined by numerous other professors of medicine. It was joined by the American College of Obstetricians and Gynecologists.
Of course,
you know,
there are other briefs on the other side joined by equally outstanding physicians.
None of theirs
tell me
had-
why you didn't discuss the Hippocratic Oath.
Okay. I guess it was, okay. In part because the Hippocratic Oath, we discussed basically the constitutional protection we felt the woman to have. The Hippocratic Oath does not pertain to that. Second, we discussed the fact that the state had not established a compelling state interest. The Hippocratic Oath would not really pertain to that. And then we discussed the vagueness jurisdiction. It seemed to us that the fact that the medical profession at one time had adopted the Hippocratic Oath does not weigh upon the fundamental constitutional rights involved. It is a guide for physicians, but the outstanding organizations of the medical profession have in fact adopted a position that says the doctor and the patient should be able to make the decision for themselves in this kind of situation.
Of course, it's the only definitive statement of ethics in the medical profession. I take it from what you just said that you didn't even footnote it because it's old. That's about really what you're saying.
Well, I guess it is old, and not that it's out of date, but that it seemed to us that it was not pertinent to the argument we were making.
Let me ask another question then. Last June 29th, this court decided the capital punishment cases.
Yes, sir.
Do you feel that there is any inconsistency in the court's decision in those cases outlawing the death penalty with respect to convicted murderers and rapists at one end of lifespan, and your position in this case at the other end of lifespan?
I think, had there been established that the fetus was a person under the 14th Amendment or under constitutional protection, then there might be a differentiation. In this case, there has never been established that the fetus is a person or that it's entitled to the 14th Amendment rights or the protection of the Constitution. It would be inconsistent to decide that after birth, various classifications of persons would be subject to the death penalty or not. But here we have a person, the woman, entitled to fundamental constitutional rights, as opposed to the fetus prior to birth, where there is no establishment of any kind of federal constitutional rights.
Well, do I get from this then that your case depends primarily on the proposition that the fetus has no constitutional rights?
It depends on saying that the woman has a fundamental constitutional right and that the state has not proved any compelling interest for regulation in the area. Even if the court at some point determined the fetus to be entitled to constitutional protection, you would still get back into the weighing of one life against another.
That's what's involved in this case? Weighing one life against another?
No, Your Honor. I said that would be what would be involved if the facts were different and the state could prove that there was a person for the constitutional right.
Well, if it were established that an unborn fetus is a person within the protection of the 14th Amendment, you would have almost an impossible case here, would you not?
I would have a very difficult case.
You certainly would, because you'd have the same kind of thing. You'd have to say that this would be the equivalent to after a child was born. If the mother thought it bothered her health having a child around, she could have it killed. Isn't that correct?
That's correct.
Could Texas constitutionally, did you want to respond further to Justice Stewart? Did you want to respond further to him?
No, Your Honor.
Could Texas constitutionally, in your view, declare that by statute that a fetus is a person for all constitutional purposes after the third month of gestation?
I do not believe that the state legislature can determine the meaning of the federal Constitution. It is up to this court to make that determination.
Yes, but states have to begin with statutes, don't they?
The state could obviously adopt that kind of statute, and then the question would have to be adjudicated as to whether for all purposes that statute is constitutional. We are not alleging that there cannot be some kind of protection. For example, the property rights, which again are contingent upon being born alive, but can be retroactive to the period prior to birth. But in this particular situation, we are alleging that this statute is unconstitutional.
They have been recognized in the period before birth for purposes of injury claims. You put that, I take it, in the property category?
In Texas, that is only when they are born alive. And the fact that there is the wrongful conduct of another is not the same as in this situation. As to property rights, for example, there are even property rights that relate back to prior to conception. Children that are not yet conceived can later inherit, but that did not prevent this court in Griswold from holding people had the right to birth control.
Mr. Flowers.
Mr. Chief Justice, and may it please the court. The lower court in Dallas held the Texas abortion law unconstitutional primarily on the two grounds that has just been discussed. On the vagueness question and the rights of the mother under the Ninth Amendment. the thrust of the whole argument of the state of Texas is against the rights of the mother under the Ninth Amendment, that it certainly is a balancing effect. There must be, or on the other side of the coin, Texas has no state. It is impossible for me to trace within my allocated time the development of the fetus from the date of conception to the date of its birth. But it is the position of the state of Texas that upon conception we have a human being, a person within the concept of the Constitution of the United States and that of Texas also.
Now, how should that question be decided? Is it a legal question, a constitutional question, a medical question, a philosophical question, a religious question, or what is it?
Your Honor, we feel that it could be best decided by a legislature in view of the fact that they can bring before it the medical testimony, the actual people who do the research. But we do
You think it's basically a medical question?
From a constitutional standpoint, no, sir. I think it's fairly squarely before this court. We don't envy the court for having to make this decision.
Do you know of any case anywhere that's held that an unborn fetus is a person within the meaning of the 14th Amendment?
No, sir. We can only go back to what the framers of our Constitution had in mind.
Well, these weren't the framers who wrote the 14th Amendment. That came along.
No, sir. I understand, but the Fifth Amendment, under the Fifth Amendment, no one shall be deprived of a right to life, liberty, and property without the due process of law.
Yes, but then the 14th Amendment defines person, and it defines person as somebody who's born, doesn't it?
I'm not sure about
that. No, it does. Any person born or naturalized in the United States. Doesn't. I suppose that's not a definition of a person, but that's a definition of a citizen.
Your Honor, it's our position that the definition of a person is so basic, it's so fundamental, that it is the framers of the Constitution had not even set out to define. We can only go to what the teachings at the time of the Constitution was framed. We have numerous listings in the brief by Mr. Joe Witherspoon, a professor at the University of Texas, that tries to trace back what was in their mind when they had the person concept, when they drew up the Constitution. He quoted Blackstone in 1765, and he observed in his commentaries that life, this right is inherent by nature in every individual and exists even before the child is born. I submit to you that the Declaration of Independence, we hold...
When you quote Blackstone, is it not true that in Blackstone's time, abortion was not a felony?
That's true, Your Honor, but what my point there was to see the thinking of the framers of the Constitution from the people they learned from and the general attitude of the time.
Well, I think I'm just wondering if there is a basic inconsistency there. And let me go back to something else that you said. Is it not true, or is it true, that the medical profession itself is not in agreement as to when life begins?
I think that's true, sir. But from a layman's standpoint, medically speaking, we would say that at the moment of conception, from the chromosomes, every potential that anybody in this room has is present from the moment of conception.
Well, then you're speaking of potential of life.
Yes, sir.
With which everyone can agree, perhaps.
On the seventh day, I think that the heart in some form starts beating. On the 20th day, practically all the facilities are there that you and I have, Your Honor. I think that
you're correct that the fetus is a person. then I don't suppose the state would have great trouble permitting an abortion, wouldn't it?
Yes, sir.
In any circumstance?
It would, yes, sir.
To save the life of the mother or her health or anything else?
Well, there would be the balancing of the two lives. And I think that...
what would you choose? Would you choose to kill the innocent one or what?
Well, in our statute, the state did choose that way, Your Honor.
Well,
in protection of the mother.
Well, could the state of Texas say that it is for the benefit of the health of the wife, they can kill the husband?
I'm sorry, I didn't understand your question.
Could Texas say, if it comes to a situation for the benefit of the health of the wife, that the husband has to die, could they kill him?
I wouldn't think so, sir.
That's right.
I wouldn't think so.
Is there any statute in Texas that prohibits a doctor from performing any operation other than an abortion?
I don't think so, sir. And there is another thrust of our argument. If we declare, as the appellees in this case have asked this court to declare, that an embryo or a fetus is a mass of protoplasm similar to a tumor, then of course the state has no compelling interest whatsoever.
But there is the only operation that a doctor can possibly commit that will bring on a criminal penalty is an abortion.
Yes.
Why?
As far as...
Well, why don't you limit some other operations?
Because this is the only type of operation that would take another human life.
Well, a brain operation could.
Well, there again, that would be... I think that in every feat that a doctor performs, that he is constantly making this judgment.
Well, if a doctor performs the brain operation and does it improperly, he could be guilty of manslaughter, couldn't he?
I would think so if he was negligent.
Well, why couldn't you charge him with manslaughter if he commits an abortion?
In effect, Your Honor, we did. In the statute 1195 that has been very carefully avoided all throughout these proceedings, is not attacked as unconstitutional for some reason. If you'll permit me to...
Well, is it an issue here?
No, sir. You asked a question about whether we had made manslaughter, abortion manslaughter.
Maybe the reason is why I have two statutes.
Well, this was in context with, this is 1195. They are attacking 1191 to 1196, but omitted 1195. Here's what 1195 provides. Whoever shall, during the parturition of the mother, destroy the vitality or life in a child in a state of being born before actual birth, and before actual birth, which child would have otherwise been born alive, which shall be confined to the penitentiary for life or not less than 5 years.
What does that statute mean?
Sir?
What does it mean?
I would think that
it's an offense to kill a child in the process of childbirth.
Yes, sir. It would be immediately before childbirth or right in the proximity of the child being born.
Which is not an abortion.
Which is would not be an abortion. Yes, sir. You're correct, sir. It would be homicide. Gentlemen, we feel that the concept of a fetus being within the concept of a person, within the framework of the United States Constitution and the Texas Constitution, is an extremely fundamental thing.
Of course, if you're right about that, you can sit down. You've won your case.
Your Honor,
except insofar as maybe the Texas abortion law presently goes too far in allowing abortion.
Yes, sir. That's exactly right. We feel that this is the only question, really, that this court has to answer. We have
You think the case is over for you? You've lost your case then. If the fetus or the embryo was not a person, is that it?
Yes, sir. I would say so.
You mean the state has no interest of its own that it can assert?
Oh, we have other interest, Your Honor. Preventing promiscuity, say. Maybe
yes,
this
but
is...
your legislature apparently, or you're asserting that the state, that your state law wants to protect the life of the fetus.
Yes, sir.
And under state law, there are some rights given to the fetus.
Yes, sir.
And you are asserting those rights against the right of the mother.
Balancing against the Ninth Amendment rights.
Well, yeah, but that's wholly aside from whether or not the fetus is a person under the federal Constitution. You can still assert those rights whether the fetus is a person or not.
Yes, sir.
Does Texas have traditional statutes on mutilation, making it a criminal act?
Yes, sir.
So that there are other surgical procedures which could be criminal.
That's right. They do.
The man walked into a doctor's office and said, "I want you to cut off my right arm because
That's right.
it has
Mutilation,
offended me."
Castration. Yes, sir. I had forgotten about those, Your Honor.
Statutes apply to doctors?
I would assume so, sir. Anyone.
You have any case that says so?
No, sir. I would say that there would have to be a culpability of mind proven there, as in most of criminal cases. Your Honor, I'd like to call the attention of the court that the unborn child, that this court has not been blind to the rights of the unborn child in the past. In the Memorial case versus Anderson, a New Jersey Supreme Court case, this was a case where the pregnant woman had refused on religious grounds to undergo a blood transfusion, and in order to save the child. The court held that the right of the child to live and to be born was paramount over this pregnant woman's right of religion. I think that here is exactly what we're facing in this case, is the life of this unborn fetus paramount over the woman's right to determine whether or not she shall bear a child. In Glickman versus Cosgrove, it's a New Jersey Supreme Court case. It's a tort action instituted against the doctor as a result of his failure to warn the mother that she was suffering from German measles in order that she could terminate her pregnancy. The court recognized the life of the embryo and stated that it would have been easier for the mother and less expensive for the father. This alleged detriment cannot stand against the precedent of one single life. In Jones versus Jones, a New York Supreme Court held that the unborn child was a patient of the mother's obstetrician as well as the mother herself. In Jackson versus Indiana, this court zealously guarded the rights of a retarded child. Now, if we're going to extend the right of a child who has reached its potential, it cannot go on and grow. It cannot go on and grow mentally and achieve. Then how much more rights should we afford to a child who has all of the potential of achieving? The Prince versus Commonwealth of Massachusetts case, this course was faced with the contention that the state statute precluding labor by a child in tender years and distributed in religious tracts was protected, that the child's right to grow up and to become educated and fully develop was paramount to these parents' religious beliefs. This court has been diligent in protecting the rights of the minorities. And gentlemen, we say that this is a minority, a silent minority, the true silent minority. Who is speaking for these children? Where is the counsel for these unborn children whose life is being taken? Where is the safeguard of the right to trial by jury? Are we to place this power in the hands of a mother and a doctor? All of the constitutional rights. If this person has the person concept, what would keep a legislature under this grounds from deciding who else might or might not be a human being or might not be a person?
Well, generally speaking, I think you've agreed that up until now the test has been whether or not somebody's been born or not. And that's the word used in the 14th Amendment.
Yes, sir.
That's what would keep a legislature, I suppose, from classifying people who've been born as not persons.
Your Honor, it seems to me that the physical act of being born, I'm not playing it down. I know it's a very momentous incident. But what changes? Is it a non-human and changing by the act of birth into a human?
Well, that's been the theory up until now in the law.
Well, in other words, it has been the theory that we have deriving from non-human material a human being after conception. Well, Your Honor...
that's the reason I asked you at the beginning, within what framework should this question be decided? Should it be a theological one, or a philosophical one, or a medical one, or are we confined here to dealing with
I think, Your Honor, that the court...
constitutional meaning of it?
I wished I could answer that. I believe that the court must take these, the medical research and apply it to our Constitution the best it can. I said I'm without envy of the burden that the court has. I think that possibly we have an opportunity to make one of the worst mistakes here that we've ever made.
But there's no medical testimony that backs up your statement that it goes from inception, is there?
Only that...
medical.
Sir, in this case you're talking about?
No, is there any medical testimony of any kind that says that a fetus is a person at the time of inception?
Your Honor, I would like to call the court's attention in answering that question, what I feel to believe one of the better culminations of the medical research, and that was Senior Judge Campbell's dissenting opinion in the Doe versus Scott, which is very similar to the case we have before us. He goes in chronological order what the medical research has determined from the chromosome structure at the time of conception, what the potential is, down through each day of life until it's born.
I understood you to say the state of Texas says it extends from the date of inception until the child is born.
The date of conception till the day of... Yes, sir.
And that's it?
Yes, sir.
Now, you're now quoting me a judge. I want you to give me a recognizable medical writing of any kind that says that at the time of conception, the fetus is a person.
I do not believe that I could give that to you without researching through the briefs that have been filed in this case, Your Honor. I'm not sure that I could give it to you.
Mr. Flowers, did Judge Campbell rely on medical authorities in that statement you're summarizing?
Yes, sir, he did. This case was, the court held there that really the problem could be answered on an extension of the Griswold case. And here's what my dissenting judge had to say about that, which we adopt, Your Honor. Said, In citing Griswold, the majority concludes we cannot distinguish the interests asserted by the plaintiffs in this case from those asserted in Griswold. In other words, in their views, there is no distinction that can be made between prohibiting the use of contraceptives and prohibiting the destruction of fetal life, which, as explained above, may reasonably be construed to be a human life. I find this assertion incredible. Contraceptive prevents creation of new life. Abortion destroys existing life. Contraceptives and abortion are as distinguishable as thoughts and dreams are distinguishable from a reality. Now,
well, where are the medical authorities you told Mr. Justice Rehnquist he cited? Are they there?
Yes, sir. He lists them day by day, just prior to this time, sir. But it's quite lengthy.
Where is that you're reading from?
It's 321 Federal Supplement on page 394, sir. Or 392 it begins, Your Honor. And I refer you to his medical condensation because I have read most of the comments that he has to make through the throughout these many briefs that we have had submitted in this case and other cases. For instance, he starts off, we did, as the Illinois legislature would have before us the following undisputed facts relating to fetal life. 7 weeks after conception, the fertilized egg develops into a well-proportioned small-scale baby and then goes from there on. Now, I know he doesn't address himself, Your Honor, to the moment of conception.
I didn't think so.
You're entirely right there, but I find no way that I know that any court or any legislature or any doctor anywhere can say that here is the dividing line. Here is not a life and here is a life after conception. Perhaps it would be better left to our legislators. There they have the facilities to have some type of medical history brought before them, and the opinion of the people who are being governed by this.
Well, if you're right that an unborn fetus is a person, then you can't leave it to the legislature to play fast and loose with that, in dealing with that person. In other words, if you're correct in your basic submission that an unborn fetus is a person, then abortion laws such as that which New York has is grossly unconstitutional, isn't it?
That's right.
Allowing the killing of people.
Yes.
Of persons.
Your Honor, the Massachusetts, I might point out...
You can't leave this up to the legislature. There's a constitutional problem, isn't it?
Well, if there would be any exceptions within this...
And the basic constitutional question initially is whether or not an unborn fetus is a person,
yes,
isn't it?
And entitled to the constitutional protection.
That's critical to this case.
Yes, sir, it is. And we feel that the treatment that the courts have given unborn children in descent and distribution property rights, tort laws, have all pointed out that they have, in the past, have given credence to this concept.
Mr. Flowers, doesn't the fact that so many of the state abortion statutes do provide for exceptional situations in which abortion may be performed, and presumably these date back a great number of years, following Mr. Justice Stewart's comment, suggest that the absolute proposition that a fetus from the time of conception is a person just is at least against the weight of historical legal approach to the question?
Yes, sir, I would think possibly that would indicate that. However, Your Honor, in this whole field of abortion here, we have, on the one hand, great clamoring for this liberalization of it. perhaps this is good. Population explosion. We have these so many things that are arriving on the scene in the past few years that might have some effect on producing this type of legislature, rather than facing the facts squarely. I don't think anyone has faced the fact in making a decision whether this is a life in a person concept. Thank you.
Mr. Flowers, when was the first abortion statute adopted in your state?
Your Honor, in 1854.
Prior to 1854, what was the situation in Texas?
I do not think it was an offense, Your Honor.
So on your theory...
I think it was silent. The state was silent on that.
So on your theory, destruction of a person in the form of a fetus was legal?
Yes, sir. Well, at least the legislature hadn't spoken on it, Your Honor.
Well, it was legal.
Yes, sir.
Mr. Flowers, did Texas have an abortion statute on the books at the time, at least in the eyes of the North, it was readmitted to the Union after the Civil War?
No, sir. The state was admitted to the Union in 1845, Your Honor.
Well, at the time that it was passed muster with...
when it was a republic?
Well, my historical impression is that following the Civil War, Congress went through the procedure, at any rate, of readmitting the states which had seceded and passing on their constitutional provisions and that sort of thing. Did Texas have an abortion statute at that time?
Yes, sir. It was passed in 1854, Your Honor.
Do you know, as a matter of historical fact, when most of these abortion statutes came on the books?
I think it was, most of them were in the mid-1800s, Your Honor.
In fact, the latter half of the 19th century. Do you know why they all came on at that time?
No, sir, I surely don't. Sorry.
The materials indicate that, generally speaking, they were enacted to protect the health and lives of pregnant women because of the danger of operative procedures generally in that era of our history.
I'm sure that was a great factor, Your Honor.
Well, isn't it historically pretty well accepted as a fact that in the early period of the history of this country, there was general reliance upon religious discipline to preclude this kind of activity, abortions, and when that didn't seem to cover it, then the states began to enact statutes.
Yes, sir.
As had been done in England.
Also, in the exploration and the Indian days, if you wish, the frontier days, I don't imagine that too many intentional abortions were created in these United States. People was of such a necessity to develop the United States.
Thank you, John. Mrs. Weddington, you have 4 minutes left.
Thank you, Your Honor. I think Mr. Flowers well made the point when he said that no one can say, here is the dividing line. Here is where life begins. Life is here and life is not over here. In a situation where no one can prove where life begins, where no one can show that the Constitution was adopted, that it was meant to protect fetal life, in those situations where it is shown that that kind of decision is so fundamentally a part of individual life, of the family, of such fundamental impact on the person.
Well, I gather your argument is that a state may not protect the life of the fetus or prevent an abortion even at any time during pregnancy. Until a moment of birth.
At this time, my point is that this particular statute is unconstitutional.
Well, I understand that, but your argument is the way you stated is that it wouldn't make any difference in pregnancy if the state didn't prevent the abortion. It would still be unconstitutional.
At this time, there is no indication to show that the Constitution would give any protection prior to birth. That is not before the court, and that is a question I think...
Well, I don't know whether it is or it isn't. If the statute, you're claiming the statute's void on its face.
That's correct.
Now, is it possible the statute, before you can declare the statute void on its face, that you have to say that it's void no matter when in the pregnancy the abortion takes place?
It seems to me in this situation the court is... Excuse me, I must... Would you ask the question again?
Well, is the statute void? Would the statute be void on its face if the state could prevent abortions at any time after 6 months?
You mean if the state in fact did that?
Well, let's assume that it's constitutional for the state to prevent abortions after 6 months.
It would still be void on its face in this situation because it is overly broad. It interferes at a time when the state has no...
This is a free speech case. The statute might be perfectly valid in part and invalid in part. You're saying
in areas where...
on its face, totally invalid.
Well,
it may not apply to it may not prevent an abortion no matter when the abortion takes place.
My argument would first be that it's void on its face, and second, if the court finds it's not void on its face, that it certainly is void because it infringes upon the fundamental right at a time when the state can show no compelling interest early in pregnancy.
What did this court say about voidness in the Vuitch case? What did we say there?
There you said the particular D.C. statute was not void for vagueness. It's a different statute. There was an interpretation of the meaning of the statute, and the court there said the doctor could work within that context and could tell what the statute meant.
Well, then isn't the only difference between the Texas statute and the D.C. statute that the Texas statute does not have the health factor in?
That's correct, which makes it much more difficult for the doctor to tell when it is
well, then under Vuitch, unless the court was prepared to overrule it, modify it, the Texas statute would be valid if it was construed to include abortions for the protection of health, treating life as broad enough to
mental and physical
health.
But then the question is raised as to the right of privacy, which was not before the court in the Vuitch case and is before the court in this particular situation. As to the Hippocratic Oath, it seems to me that that oath was adopted at a time when abortion was extremely dangerous to the health of the woman. And second, that the oath is to protect life. And here the question is, what does life mean in this particular context? It's the sort of same vagueness that it seems to me that well, okay, life there could be slightly different because of the constitutional implications here.
Well,
it seems to me that
Hippocratic Oath went directly and specifically to abortive procedures.
To providing abortion.
However life was
That's correct. That's
defined.
That's right. As to mutilation, there it seems to me that the purpose of those statutes was to prevent the citizen from becoming a dependent or ward of the state, and also to ensure that its citizens would be available for service in the military. In this particular instance, the rationale works just the opposite. Here, a woman, because of her pregnancy, is often not a productive member of society. She cannot work, she cannot hold a job, she's not eligible for welfare, she cannot get unemployment compensation. And furthermore, in fact, the pregnancy may produce a child who will become a ward of the state. We do not object to the cases, such as the transfusion case, where there is a decision already made by the woman that she desires to carry the pregnancy to term. And when that decision is made, that the child should be given every opportunity to come into life a healthy person. We do not believe that that necessitates the conclusion that, therefore, under the Constitution, prior to birth, a person under the 14th Amendment would exist. This court is faced with a situation where there have been 14 three-judge courts that have ruled on the constitutionality of abortion statutes. 9 courts have favored the woman, 5 have gone against her. 25 judges have favored the woman, 17 have gone against her. 9 circuit judges have favored the woman, 5 have gone against her. 16 district court judges have favored the woman, 10 have gone against her. No one is more keenly aware of the gravity of the issues or the moral implications of this case, but it is a case that must be decided on the Constitution. We do not disagree that there is a progression of fetal development, It is the conclusion to be drawn from that upon which we disagree. We are not here to advocate abortion. We do not ask this court to rule that abortion is good or desirable in any particular situation. We are here to advocate that the decision as to whether or not a particular woman will continue to carry or will terminate a pregnancy is a decision that should be made by that individual, that in fact she has a constitutional right to make that decision for herself, and that the state has shown no interest in interfering with that decision. Our supplemental brief on page 14 points out that the brief of the opposition can't quite decide when life does begin. At one point they suggest it's when there's implantation. A few pages later they suggest it's with conception.
But any doctor, I suppose you would say, may refuse her.
Certainly, Your Honor, he may. He may refuse any kind of medical procedure whatsoever.
But the state
Here it's the question of whether or not the state, by the statute, will force the woman to continue. The woman should be given that freedom, just as the doctor has the freedom to decide what procedures he will carry out and what he will refuse to his patients.
Let me be sure that I get your argument in focus. I take it from your recent remarks that you are urging upon us abortion on demand of the woman alone, not in conjunction with her physician.
I am urging that in this particular context, this statute is unconstitutional. That in the Baird versus Eisenstadt case, this court said if the right of privacy is to mean anything, it is the right of the individual, whether married or single, to make determinations for themselves. It seems to me that you cannot say this is a woman of this particular doctor and this particular woman. It seems to me...
well, doesn't it follow from that, then, that a woman can come into a doctor's office and say, I want an abortion?
And he can say, I'm sorry, I don't perform them.
And then what does she do?
She goes elsewhere, if she so chooses. If she stays with that, that's an impossible question. Certainly, I don't think the state could say the first doctor a woman goes to, she'll make that determination and she cannot go elsewhere.
Your time is up now, Mrs. Whittington. Thank you, Mrs. Whittington. Thank you, Mr. Flowers. The case is submitted.
We'll hear argument now in number 91-744, Planned Parenthood of Southeastern Pennsylvania versus Robert P. Casey. 91-902, Robert P. Casey versus Planned Parenthood of Southeastern Pennsylvania. Ms. Colbert.
Mr. Chief Justice, and may it please the Court. Whether our Constitution endows government with the power to force a woman to continue or to end a pregnancy against her will is the central question in this case. Since this Court's decision in Roe v. Wade, a generation of American women have come of age secure in the knowledge that the Constitution provides the highest level of protection for their childbearing decisions. This landmark decision, which necessarily and logically flows from a century of this Court's jurisprudence, not only protects rights of bodily integrity and autonomy, but has enabled millions of women to participate fully and equally in society. The genius of Roe and the Constitution is that it fully protects rights of fundamental importance. Government may not chip away at fundamental rights, nor make them selectively available only to the most privileged women. If the right to choose abortion remains fundamental as established in Roe v. Wade, the strict scrutiny standard is applicable, and as this Court found in Akron and in Thornburg, Pennsylvania's onerous restrictions must fall. Should this Court abandon strict scrutiny, as urged by the Commonwealth and the solicitor, not only might Pennsylvania's egregious intrusions on privacy stand, and a century of this Court's privacy decisions may also be dismantled. Equally disturbing, should this Court remove fundamental protection for the abortion right, women might again be forced to the back alleys for their medical care, with grave consequences for their lives and health. The Commonwealth argues that this Court may overrule Akron and Thornburg and abandon strict scrutiny and nevertheless preserve Roe's central meaning. While politically expedient, this view is certainly not based upon this Court's privacy jurisprudence. Every other brief filed in this case agrees that the protection offered by Roe's heightened scrutiny lies at the core of this important decision. To abandon heightened review is to overrule Roe. This Court has repeatedly held that the doctrine of stare decisis is of fundamental importance to the rule of law. Fidelity to precedent ensures that our law will develop in a principled and intelligible fashion, and that our guiding rules are founded in law rather than in the proclivities of individuals. Accordingly, this Court has established that departure from precedent must be supported by some special justification. But no special justification exists here. Only 9 years ago in Akron, this Court invoked the doctrine of stare decisis and expressly reaffirmed Roe v. Wade. Only 3 years later, in Thornburg, a case that is virtually identical to that before this Court today, this Court again found especially compelling reasons to reaffirm Roe and to find Pennsylvania law unconstitutional under the standard of strict scrutiny. Nothing has changed since that time. Indeed, millions of women continue to rely on the fundamental rights guaranteed in Roe v. Wade. The medical conditions that led this Court to create and establish these fundamental rights remain the same. This case, the statute, the parties are nearly identical to those in Thornburg. Never before has this Court bestowed and taken back a fundamental right that has been part of the settled rights and expectations of literally millions of Americans for nearly 2 decades. To regress now by permitting states suddenly to impose burdensome regulations or to criminalize conduct would be incompatible with any notion of principled constitutional decision-making. Roe is both soundly based in the Constitution and sets forth a fair and workable standard of adjudication. From as early as 1891, this Court has recognized that the rights of autonomy, bodily integrity, and equality are central to our notions of ordered liberty. Roe lies at the heart of those interests. While pregnancy may be a blessed act when planned or wanted, forced pregnancy, like any forced bodily invasion, is anathema to American values and traditions. In the same way that it would be unacceptable for government to force a man or woman to donate bone marrow, or to compel the contribution of a kidney to another, or to compel women to undergo abortion or forced sterilization, our Constitution protects women against forced pregnancy. If anything, because forced pregnancy will jeopardize a woman's life or health, the constitutional protections ought to be greater. The solicitor tries to draw a distinction between constitutional protection against forced abortion, which he agrees is fundamental, and constitutional protection against forced pregnancy, which he maligns. But once this Court removes fundamental status from the abortion right, there is no logical stopping point. Fundamental status for all reproductive rights, decisions about birth control, pregnancy, sterilization, even high technology around reproduction may also be jeopardized, particularly where there is no bright line between abortion and some methods of birth control. The fundamental right both to prevent pregnancy and to end pregnancy may be at stake. Our nation's history and tradition also respects the autonomy of individuals to make life choices consistent with their own moral and conscientious beliefs. Our Constitution has long recognized an individual's right to make private and intimate decisions about marriage and family life, the upbringing of children, the ability to use contraception. The decision to terminate a pregnancy or to carry it to term is no different in kind. Both the solicitor and some Commonwealth amici argue that the Constitution only protects private decision-making within families. It is true that the rights of privacy have been recognized in the familial context. For example, in Griswold, the Court found unconstitutional the Connecticut statute that prohibited married persons from using birth control. And in Loving, this court found invalid a Virginia statute that prohibited the marriage of interracial couples. Nevertheless, this court has never limited the notions of privacy recognized in these cases as only arising or belonging to married couples. Indeed, in Eisenstadt and in Carey, this court specifically rejected this view. Nor can this court alter its historic recognition of privacy and deny women fundamental freedoms because, as the solicitor argues, the woman is not isolated in her privacy. Surely, if the government cannot require individuals to sacrifice their lives or health for others or for other compelling purposes, it cannot require women to sacrifice their lives and health to further the state's interest in potential life.
Ms. Colbert, you're arguing the case as though all we have before us is whether to apply stare decisis and preserve Roe against Wade in all its aspects. Nevertheless, we granted certiorari on some specific questions in this case. Do you plan to address any of those in your argument?
Your Honor, I do. However, the central question in the case is what is the standard that this court uses to evaluate the restrictions that are at issue? And therefore, one cannot...
Well, the standard may affect the outcome or it may not, but at bottom we still have to deal with specific issues, and I wondered if you were going to address them.
Yes, I am, Your Honor, and I would like in particular to address the husband notification provisions. But the standard that this court applies will well establish the outcome in this case for a variety of reasons. This court has already found that under the principles of Roe versus Wade, the bulk of the Pennsylvania statute is unconstitutional. There is no question that this court struck down as unconstitutional under strict scrutiny the bias counseling provisions and the 24-hour mandatory delay, both in Thornburg and in Akron, the case in 1983. And therefore, this court must examine first the question of what's the appropriate standard before determining the constitutionality of those other provisions. The court cannot alter its historic recognition of privacy and deny women fundamental freedoms, as I was speaking, because, as the solicitor argues, there's the presence of the fetus. Surely, if the government cannot require individuals to sacrifice their lives or health for human beings who are born for other compelling purposes, they cannot do so for purposes of protecting potential fetal life. And if this court is to reduce the presence of a constitutional right merely because of the presence of the fetus, other childbearing decisions, whether they be the right to carry the pregnancy to term or make other childbearing decisions, will be particularly affected. Particularly here, as this court noted in Roe, where there is widespread disagreement in both a philosophical and a religious sense about when life begins. This court cannot sanction one view to the detriment of women's lives and health. Nor can the state of the law in 1868 define or determine constitutional rights for all future generations. This court must look generally to whether a right is reflected in our nation's history and traditions, rather than at whether the activity was illegal at the time of the adoption of the 14th Amendment. Relying exclusively on what 50 states have legislated in determining the scope of liberty would imperil numerous freedoms, such as rights recognized by this court in Brown, Bowling, Griswold, and Loving. This court has also recognized as...
Ms. Colbert, on this last point, I'm not sure what you suggest we look to. You say we should not look to what the practice was in 1868. Should we look to what the practice was at the time of Roe, or what the practice is today? That is, what the states would do, left to their own devices?
Your Honor, I believe that you have to look very generally at whether the nation's history and tradition has respected interests of bodily integrity and autonomy, and whether there has been a tradition of respect for equality of women. Those are the central and core values.
But not to abortion in particular.
Well, this court is if the court was only to look at whether abortion was illegal in 1868, that is, at the time of the adoption of the 14th Amendment, it would be placed in a very difficult situation because at the time of the founding of this nation, at the time that the Constitution was adopted, abortion was legal.
Well, pick 1968. I gather you wouldn't accept 1968 either, though.
Well, we think that the court ought to look generally at the principles that this decision protects. That ought to while it is important to look, and I would not urge you to ignore the state of the law at different periods of our history. It is only one factor in a variety of factors that this court has to look to in determining whether or not something is fundamental. And fundamental status in this instance derives from a history of this court's acknowledgement and acceptance that private autonomous decisions made by women in the privacy of their families ought to be respected and accorded fundamental status. Certainly, the anomalous posture of the fact that abortion was legal at the time of the founding of the Constitution and then illegal at the time of the adoption of the 14th Amendment would place this court in a very difficult position that his rights may be guaranteed under the 5th Amendment and not the 14th, merely because only the exact state of the law in 1868 is the factor that the court accepts.
This is not an antiquarian argument you're making. I mean, you would have made the same argument in 1868. I think you would have said the mere fact that most states disfavor of abortion is no justification for this court saying that it is not therefore included with it. You would have made that same argument in 1868. I
would, and that is the argument that this court has made in many instances in rejecting exactly the state of the law prior to the granting of fundamental status. That is, this court, if we were only to look at whether state legislatures prohibited activities in determining whether or not an activity is fundamental, many of the most precious rights that we now have, rights to travel, rights to vote, rights to be free from racial segregation, would not be accorded status because, in fact, state legislators have acted to inhibit those rights at the time of the adoption of the 14th Amendment.
Some of those are mentioned in the Constitution, like racial segregation.
Your Honor, this Court has recognized that the rights at issue here, that is, the rights of privacy, the rights of autonomy, flow from the Liberty Clause of the 14th Amendment, which is also mentioned in the Constitution. The debate centers on what is the meaning of that term liberty, and we think that the precedents of this Court that began at the end of the 19th century and have proceeded from this Court to the very present logically and necessarily include fundamental rights to decide whether to carry a pregnancy to term or to terminate that pregnancy.
I don't question the importance of your arguing that there's a fundamental right, as you've done. However, there's a fundamental right to speech, and we hear any number of arguments in this case on time, place, and manner. I don't think our decision on parental notice in the Akron case is necessarily inconsistent with a fundamental right. But one way of our understanding this fundamental rights, and their parameters, and their dimensions, is to decide on a case-by-case basis. And you have a number of specific provisions here that I think you should address.
The critical factor is whether, as a result of its fundamental status, this Court will accord the standard of Roe, that is, strict scrutiny. Because under that standard, there is no dispute among the parties. Under that standard, the bias counseling provisions, the 24-hour mandatory delay, have been found unconstitutional. And significantly, this Court has also gone so far as to say that the husband consent requirements, very similar to the husband notification requirements at issue in this case, have also been found unconstitutional.
I'm suggesting that our sustaining these statutory provisions does not necessarily undercut all of the holding of Roe versus Wade.
It is our position, Your Honor, that if this Court were to change the standard of strict scrutiny which has been the central core of that holding, that in fact that will undercut the holdings of this court and effectively overrule Roe versus Wade. To adopt a lesser standard, to abandon strict scrutiny for a less protective standard such as the undue burden test or the rational relationship test, which has been discussed by this court on many occasions, would be the same as overruling Roe. For it is the beauty of Roe, the protections of Roe, flow from the fact that this court gives, upon a proof that particular state regulations interfere with the right, Roe establishes and creates a burden on government to come forward with a compelling purpose.
Well, if you're going to argue that Roe can survive only in its most rigid formulation, that's an election you can make as counsel. I'm suggesting to you that that's not the only logical possibility in this case.
Our position is that Roe, in establishing the trimester framework, in establishing strict scrutiny, and in also establishing that the rights of women and the health interests of women always take precedent over the state's interest in potential life. Those hallmarks of Roe are central to this case and are central to continuing recognition of the right as fundamental. Should the court abandon that?
Did the court hold that even after viability of the fetus in Roe? Do you think that was a correct characterization of Roe's holding that you just gave? That the woman's interest always takes precedence? Is that true under Roe?
Your Honor, under Roe,
stages of pregnancy.
After the point of viability, that is the point when the fetus is capable of survival, the state is free to prohibit abortion, but only so long as it is necessary, or only so long as the woman's health interests and life interests are not at stake. That is, potential fetal life is a recognized value, is a recognized state interest after the point of viability. But when in conflict, when the woman's health interest is in conflict with those state interests in potential life, those women's interests, the women's interests in health, take precedent. Now, admittedly, the question of viability and the viability line is not as present in this case as it has been in many of the other cases that this court has seen before here. That is, all of the restrictions that are at issue in Pennsylvania attach in pregnancy at the very beginning of pregnancy. And therefore, the state's interest in protection of fetal life really does not come into play. The real issue is whether or not these health interests, that is, whether or not the state's interest in protecting compelling interest in health, are present. And frankly, this court need only look to the record, that is, need only look to the findings of the district court to determine that this statute in no way furthers women's health interests. That in fact what this statute does is cause a detriment to women's health, submit her to increased dangers as a result of delay, as a result of interference with the doctor-patient relationship, as a result of permitting third parties who would injure individuals who are required to give husband notification, that those interests in health are not furthered in any respect. The Commonwealth attempts to characterize the restrictions at issue here as reasonable. For the woman who, as a result of mandatory husband notification provisions, will be beaten or will see her children beaten, the restrictions are not reasonable. For the woman who must travel 200 miles on 2 and 3 occasions as a result of the Act's mandatory delay, the restrictions are not reasonable. For the woman who has become pregnant as a result of marital rape, obtaining information from her doctor that her husband may be liable for child support is both cruel and oppressive. They are not reasonable. To find these restrictions reasonable, this court would have to ignore the facts placed in evidence in this case, which demonstrate that the restrictions were not enacted to improve women's decision-making or health care. After listening to the testimony of 10 witnesses including those proffered by the Commonwealth. The district court made 387 findings of fact and repeatedly concluded that the Pennsylvania restrictions will interfere with the ability of physicians to provide quality medical care and will delay and discourage the performance of abortion to further no legitimate state interest. In particular, the lower court found that the mandatory husband notification provisions will have dangerous and potentially deadly consequences for battered women, likening forced notification in a battering situation to providing the husband with a hammer with which to beat his wife.
Was the husband notification provision the one that the Court of Appeals held unconstitutional?
It was, Your Honor.
And it upheld the balance of the act. Is that correct?
That's right. The district court found as well that biased counseling provisions transform the physician from the impartial counselor mandated by accepted medical standards into a partisan proponent of the state's ideology, and mandatory delay will increase both the expense and medical dangers of abortion, yet furthering no legitimate state purpose. There is no serious contest about the effect of this law, nor can there be, for under Rule 52, the district court's findings are not clearly erroneous. Nor did the fact that this is a facial challenge require petitioners to prove that the statute cannot be constitutionally applied to any person. This court has repeatedly found statutes facially invalid after looking at facts like those present here. For example, in Hodgson, this court relied extensively on district court findings to strike down Minnesota's two-parent notification statute with no bypass, despite the fact that that statute had never yet been in effect. The extensive record here demonstrates that the harms are not speculative nor remote, nor is this a worst-case scenario. The court should not demand an unwanted child or a woman maimed by an illegal abortion as proof that strict scrutiny is applicable. Pennsylvania women should not be the guinea pigs in the state's experiment with constitutional law. To find otherwise would totally eviscerate the strict scrutiny standard of review and would prevent federal courts from scrutinizing legislative findings, a central role in the process of judicial review. Let me turn now specifically to the husband notification provisions. There is little doubt that these provisions violate the fundamental right of privacy, marital integrity, and equality. Beginning as early as Danforth, this court recognized that a husband cannot arbitrarily veto the childbearing decisions of his wife. Like the Missouri law at issue in Danforth, state-mandated communication between husbands and wives violates the autonomy of married women to make personal and private decisions. Particularly here, where a married woman is often the survivor of marital rape and where the penalty for transgressing her husband is likely to be physical violence against her or her family members, government has the obligation to respect her private decisions, not to involve her husband. The solicitor dismisses the import of the state-imposed harm and believes or claims that the Constitution is not intended to remedy them. But this approach seriously ignores that women will be seriously maimed and that harms will be invoked. And it's a callous disregard for their lives and health. While it may be desirable for husbands and wives to share intimacies in their daily life, the concepts of this court developed in the principles of marital integrity ensure that the government cannot decree for those couples how that communication should occur. That to decree and direct family life is more destructive of family integrity than permitting families to resolve their differences on their own terms. The husband notification provisions also violate principles of equality. These are provisions that apply to women and women alone. Imposed notification gives a benefit only to men, and as such, they violate the dictates of the Equal Protection Clause. The legislative scheme that assumes that husbands are capable and authorized to make all independent decisions, but wives are not, reflect an outmoded common law view that women once married lost their legal identities to their husbands. In the days before Roe, thousands of women lost their lives, and more were subjected to physical and emotional scars from back alley and self-induced abortions. Recognizing that, this Court established Roe and established fundamental protection for women's childbearing decisions. We urge this Court to reaffirm those principles today, to adopt the rulings of this Court in Akron and Thornburg that use the Roe strict scrutiny standard, and affirm in part and reverse in part the judgment of the Court of Appeals. I would like to reserve 3 minutes for rebuttal if there's no further questions from the Court.
Very well, Ms. Colbert. General Preet, we'll hear from you.
Mr. Chief Justice, and may it please the Court. This Court granted certiorari on the question of whether 5 sections of our Pennsylvania Abortion Control Act are constitutional. It is the position of Pennsylvania that each of the 5 provisions is constitutional under the analysis that was applied by this Court in Webster. And further, Roe v. Wade need not be revisited by this Court except to reaffirm that Roe did not establish an absolute right to abortion on demand, but rather a limited right, subject to reasonable state regulations designed to serve important and legitimate state interests.
Mr. Attorney General, I'm not so sure that's so important. Roe itself said that.
That's correct.
This does not provide for abortion on demand. Have you read Roe?
Yes, I have.
Thank you.
In our view, the accommodations of the woman's right and the state's legitimate interest in the unborn child is best served, short of overruling Roe, by employing the undue burden standard for reviewing state abortion regulations. However, as we argue in Part 2 of our brief, if our statute cannot be upheld under the undue burden standard, Roe, being wrongly decided, should be overruled. I'll now address the specific provisions of our statute and start with the requirement of spousal notice, which is the only aspect of our law that the Court of Appeals found unconstitutional. It's important to remember, and perhaps more important in this context than any other, that the petitioners brought this action as a facial challenge to the statute. In this kind of a challenge, it's enough for the petitioners to show, it's not enough for them to show that the act might be unconstitutional as applied to someone in some hypothetical worst-case scenario. Rather, the petitioners must show that the statute could not constitutionally be applied to anyone. We ask, have they met that burden? And we submit that they have not met that burden. This is a spousal notice provision. It is not a spousal consent statute.
Now, the provision does not require notification to a father who is not the husband, I take it.
That's correct.
Or notice if the woman is unmarried.
It only applies to married women.
Mm-hmm. So what's the interest? To try to preserve the marriage?
There are several interests. The interest, of course, of protecting the life of the unborn child.
Well, then why not require notice to all fathers? It's a curious sort of a provision, isn't it?
It is that, but the legislature has made the judgment that it wanted its statute to apply in this specific instance because it wanted to further the integrity of marriage.
Would you say that the state could similarly require a woman to notify anyone with whom she had intercourse that she planned to use some means of birth control after the intercourse that operates, let's say, as an abortifacient?
Well,
could the state do that? I mean, it would be the same state interest, I suppose.
The state interest would be the same, but I think that would be problematic. I'm not.
And why would it be problematic? Do you think?
I think that with regard to applying a statute to all women, that it might create a severe obstacle, an absolute obstacle to their obtaining an abortion.
I don't understand.
The undue burden standard, as I understand it, is that whether or not the regulation would impose such an absolute obstacle, whether it would deter or inhibit some women from obtaining an abortion.
We're talking about the provision for notification, in this case under the statute, to the husband. And I'm just asking whether a different type of state regulation would have to be upheld under your standard.
Well, if the state had posited its interest as protecting the life of the unborn, then utilizing the rational basis standard that I would submit that it could legitimately require that kind of notification to all people. In this instance, however, we have a different statute. We have a statute that provides exceptions where exceptions are appropriate. There are 5 of them. Medical emergency, where the husband is not the father of the child, where the husband cannot be found, where the pregnancy is the result of a reported sexual assault, or where the woman in her judgment believes it's likely that she will be physically abused. Now, petitioners have produced some testimony and made some argument, essentially through one expert about battered wives. But the testimony was that some unknown number were rendered so helpless by their battering husbands that they were incapable of checking off the line on the form, the spousal notice form. We can agree that these women are indeed cruelly burdened, but they're not burdened by the statute, and that's the compelling point. They're not burdened by the statute, but by the circumstance and the tragic circumstance of their lives. We're looking at the statute to see if the statute imposes the obstacle. If there is a battering husband that's interposed in there, that's a different story.
What's our standard on a facial challenge? Whether there's a substantial likelihood of the harm?
No, I think you have to ignore what the petitioners have posited, which is a worst-case analysis scenario, and you have to look and see if it could be constitutionally applied, validly applied to anyone. And we submit that in this particular instance, the record reflects that right now in Pennsylvania, 50,000 abortions, 20% of those women are married, and 95% of those women notify their husbands. Therefore, only 1% of the women are not in Pennsylvania notifying their husbands now. The act's not even in effect. There is no broad practical effect in the Pennsylvania statute to prohibiting abortion for those women. The act goes into effect. Some of those 1% of women will then have to notify their husband, and the result will be they will resolve their difficulties amicably. There will be some who will then take the exception, because they don't want to notify their husband. They may be battered. There may be a spousal rape. There may be they can't find the husband. So what we're doing is reducing that set of women down into several subsets. And the petitioner's burden in a facial challenge is to establish, see that there's a broad practical impact.
No,
they have not met that burden.
May I ask you a question? Is it not true, therefore, that the only people affected by the statute, this very small group, are people who would not otherwise notify their husbands?
I'm not sure I got all of that question, Justice.
Well, you've demonstrated this, that the public interest is in a very limited group of people, the few women who would not otherwise notify their husbands. And those are the only people affected by the statute.
That is correct.
Everyone in that class, should we not assume, would not notify her husband but for the statute.
That is correct. In that 1%, not everyone would want to notify, and there are exceptions.
They would not without the statute.
They would not without the statute, but there are exceptions. Yeah. There's several of 4 of them.
No, you've already taken the exceptions into account in narrowing the group very to 1% or whatever it is.
Justice,
you aren't suggesting there's no one affected whose decision will be affected by the statute.
Well, that's the point. On this record, which is what we have to go on, there is nothing established by the petitioners.
Well, if there's no one affected by the statute, what is the state interest in upholding the statute?
The state interest in upholding the statute is the protection of the life of the unborn and the protection of the marital integrity, and to ensuring of communication, the possibility. We're not
but not if the statute has no effect. As a general matter, when we're dealing with rational basis review, we ask, whom does the law affect? And so it seems to me that you have to justify the law based on the effect of this 1% who would not otherwise know. And you may have an argument there. It's a very strange argument to say that the law doesn't affect 90% of the people, so we're not concerned with the law. I've never heard that argument.
We're not in any way advocating that, because we think that the law is rational. If you look at the state interest that are trying to be pursued here. Protecting the life of the unborn, protecting the marriage, ensuring the possibility of communication. This statute rationally advances it, may not advance it in every single instance, but that is not the test. The test is, does it generally rationally advance the interest that the state is trying to protect? In this instance, it does, by the sheer numbers that we have demonstrated.
General Payne, I thought we were talking not rational basis, but undue burden. Are they the same thing?
No, they are not, Justice Scalia.
How do I go about determining whether it's an undue burden or not? What law books do I look to?
Well, this is a quantitative analysis, Justice Scalia, and you begin by ascertaining under undue burden the increase, whether it's a significant increase in cost such that it broadly impacts, it prohibits women from having abortion, or whether it bans abortion.
I suppose it depends on how important I would think it is that the husband of a wife know before a fetus that he co-generated be destroyed.
I think
would that be part of it?
That would be part of the analysis that's done in the weighing side after you establish whether or not there is, in fact, in the first instance, the threshold question is, what is the broad practical impact? If there is no broad practical impact, it's minimal, as is in Pennsylvania statute, then you reach the question of the weighing that's involved.
Well, it depends. I mean, if the impact is only minimal, but also the interest involved is only minimal, then I suppose it is an undue burden. And I guess that again leads you to how much weight you place on that kind of an interest.
As I understand it, Justice Scalia, what you're talking about is if there is no undue burden, that is, there's no broad practical impact in the initial analysis, then you determine whether or not the statute rationally furthers the state's interest. It's a rational basis test in the second phase of it. And under the rational basis test, which would be the same rational basis test that the members of this court have applied in Webster, you come to the conclusion that Pennsylvania's spousal notice section does pass undue burden analysis, and it does pass rational basis analysis.
May I ask you a question about your understanding of the undue burden test? Do you think it refers to the number of persons burdened by the law on the one hand, or the severity of the burden on a particular individual affected by the law on the other hand? Which is the right analysis?
I think, Justice Stevens, in the initial application, it's a quantitative analysis, whether there is a broad practical impact here. The fact that it
in other words,
might...
you say it's the number of persons affected is your answer.
The number of persons...
Regardless of how severe the burden on a particular individual.
As the test has been posited, the question is whether or not...
I'm just asking you to explain to me what your conception of the test that you're asking us to adopt is.
It may be that some women would be deterred to some degree, but that is not sufficient to create an undue burden.
It's the number of women affected.
Initially, it's the number of women affected, the broad practical impact of it.
How about as applied to a specific woman?
As applied to a specific woman. Let's say there is such a woman who has been battered and psychologically battered. And so the exception doesn't work in her instance.
Right. Let's
posit that. In that instance, of course, that's a worst-case scenario. That's not the way you test facial challenges. In that instance, the law would work. You would test the statute as applied in the lower courts, and that woman would then be...
And you'd apply an undue burden test there on the as-applied challenge, do you suppose?
No, I would think that you would be asking the court to give full rein to the interest that you have. The woman would have, under rational basis analysis test, a liberty interest protected by the 14th Amendment, or under the undue burden standard would have a limited right.
I would have thought you would look at the burden of the law as applied to the woman.
And I think that you would look to that, but you're asking the court in an as-applied mechanism to give full effect to your right. The statute given. It is a given that it burdens you. So you can't just look at the burden in the as-applied context, but you must look at it in that context at giving full rein to your right. And that's what the woman would be seeking from the district court or for a court of common pleas, in asking the court in applying this spousal notice section to her particular instance because she didn't have one of the exceptions to check off because she was psychologically or economically pressured.
But in the facial context, I don't understand what you... So there are two undue burden tests. There's one at the facial level in which we consider the statute in gross and decide whether, all things considered, in the generality of applications, the burden's undue. And then we have a second wave of application of the undue burden test, case by case, so that even though the law facially may be okay, it may be invalid in its particular application because of is that what you're saying?
As in the second instance, as applied.
I'm worried about the first one, not the second one. I thought the way.
In the facial challenge, Justice Scalia, you're looking at not the worst case scenario hypothesis, but whether this act could be applied constitutionally to anyone. And that
any single case. Not in gross, to any single case. Isn't that the normal situation? To challenge a statute facially, you have to show that it can never be constitutionally applied. Isn't that right?
That's correct.
Well, but that's not looking at it in gross. That's asking whether there is any single case where a woman would not be unduly burdened.
In this particular instance, we find that there is no undue burden in our statute, anywhere in our statute. And if the undue burden test is applied or understood by this court causes our statute to fall, then we ask this court to adopt rational basis as the appropriate analysis.
You think that compelling speech requires any kind of First Amendment analysis?
Compelling
speech. The state is compelling a woman to say something to her husband.
We are asking that
does that invoke any First Amendment concerns?
Not in our view. This statute.
I would have thought perhaps compelling speech would get us right into a First Amendment area.
In this particular instance, the statute we feel causes notification, but there's a legitimate state interest involved in furthering that interest.
There's the doctor to say certain things to the patient. Do you think that's really commercial speech?
Yes, I do, Justice O'Connor.
Why is that? When the doctor is giving professional advice to the patient, you think that's commercial?
That is commercial. The petitioners already do that right now. They already tell their patients, the physicians, and the counselors, that there are medical risks associated with
I wouldn't have thought that was commercial speech. What do you rely on?
And Zouderer.
But that's advertising. That's different.
In Pennsylvania's general informed consent law, applying to every single contact between a doctor and a patient, there is the same information that must be presented, and that is the doctor must tell the patient about the medical risks of the procedure and the alternatives to it.
Well, it might meet a First Amendment test, but I'm wondering how you get to commercial speech on that kind of advice.
Well, we think that there's with the interest involved, with the statute furthers those interests, and that it can legitimately require the husband to be notified because of the interest involved. I see that my time is running short, and I want to devote make sure the Solicitor General has some time to respond. We think that Pennsylvania has developed an intelligent statute that fully comports with the Due Process Clause of the 14th Amendment. It's a statute that's carefully drafted, and it's been amended to reflect the teachings of this Court's jurisprudence since Roe. We ask this Court to overturn Akron and Thornburg's strict scrutiny approach as being unwarranted extensions of Roe. On the facial challenge, whereby the petitioners must show that there are no set of circumstances under which this provisions can be valid, petitioners have utterly failed to do so, done in no small measure as the record this demonstrates and is indicated in the Third Circuit Court of Appeals opinion by their own rational practices, which this statute mirrors.
Mr. Preet, because you have a little time left, there's one point on which I guess I never fully followed your argument, and I wonder if you'd go back to it. You got to the point, you were arguing about the number of instances, the percentage of instances in which the spousal notification would in fact make a difference in the behavior of the parties involved. And as I recall, you got it down to about 5% to begin with who would not otherwise, 5% of the women who would not otherwise give notice to their spouses. And then from that 5%, you subtracted some number for those, I guess, subject to medical emergencies, those subject to certification that they would be physically abused. And I think by that process of elimination, you got it down to about 1% who would actually be affected by the by the stricture of the statute. Is that right?
That is not correct, Justice.
Okay.
You start with the 1% because 95% of 20% is 1%. You're talking about 500 women.
Well, you're talking about all women, but the spousal notification applies only to married women.
That's correct. And so
what's the percentage of married women? Well, your time is up.
Sorry, thank you.
Thank you, Mr. Priade. General Starr, we'll hear from you.
Thank you, Mr. Chief Justice, and may it please the Court. In view of what has been discussed, let me address very briefly 3 points. The first is the standard of review, which has been the subject of considerable discussion. In a number of its cases over the last 20 years in the abortion area, the Court has articulated the governing standard of review in different ways. And as a result, there is confusion in the law as to how legislatures, if they choose, can legislate, and how judges are to judge in this extraordinarily sensitive and divisive area. In our view, the correct articulation of that standard is to be found in the Webster plurality opinion. That standard has deep roots. It finds its roots in a long line of due process cases that do not involve liberty interests which, by virtue of the nation's history and its legal traditions, rise to the level of fundamental rights to a free people. This is the process of analysis that is quite familiar to the Court, very lengthily laid out by Justice Harlan in his dissent in Poe v. Ullman, and then adumbrated in his concurring opinion in Griswold against Connecticut. Second, and relatedly, with all respect, we do not believe that stare decisis considerations weigh against the Court's providing that needed clarification as to the standard. This is not a new
May I ask you one rather basic question that affects the standard review and everything else? What is the position of the Department of Justice on the question whether a fetus is a person within the meaning of the 14th Amendment?
We do not have a position on that question, and this Court has not addressed, or at least there's no justice in this Court.
It's addressed in Roe and decided.
That is correct. And it does seem to me that ultimately that is an extraordinarily difficult question which this Court need not address, and it need not address it in this case.
We need not address it. I'm just
we do not have a position.
Does the United States have a position on that question?
We do not, because we think it would be an extraordinarily difficult and sensitive issue by virtue of a number of questions that would flow from that, including
the Court
equal protections and so forth.
In Roe, did it not?
The Court did, in fact, decide that there is a very keen interest on the part of the state in what the Roe Court called potential life, and that's my
said the fetus is not a person under the 14th Amendment?
Well, I think that is the necessary consequence of Roe v. Wade. But I think that the key point is that a number of the justices of this Court have said that regardless of that legal question, that constitutional question, that the state does have a compelling interest in the potential life, in fetal life, and that interest runs throughout pregnancy.
We did not say in Roe that a state could not have a position on whether a fetus is a person, did we?
Certainly.
We said that the Constitution takes no position on whether a fetus is a person, or that it does take a position that a fetus is not protected by the Constitution.
The Court seemed to admit of the possibility of state regulation to protect the unborn at all
including
stages.
State regulation on the basis of the people's determination within that state that a fetus is a person. There's nothing in Roe that says a state may not make that judgment if it wishes.
That it says that the state may, if it sees fit, that the state does have. I think Roe goes this far. Roe says that there is a legitimate interest of the state in the potential life in utero throughout pregnancy, and then the nature of that interest changes and becomes stronger over time. But it did, in fact, say that there is a legitimate interest, and there have been an expression by a number of the justices of this court to suggest that interest is indeed a compelling interest on the part of the state.
Is that also not the position of the government of the United States? That it is a compelling interest throughout pregnancy?
That is our position, that there is a compelling interest.
What is the textual basis for that position in the Constitution? Is there any?
Well, I think that, if I may, Justice Stevens, it seems to me that it goes to the recognition that we all do, that there is, in fact, an organism.
What is the textual basis in the Constitution? You argue very vigorously there's no textual basis supporting your opponent's position. What is the textual basis for your position? That there's a compelling interest in something that is not a person within the meaning of the 14th Amendment?
The state has
What is the textual basis?
The state has an interest in its potential citizen. It does not have to be granted a basis in the Constitution. Justice Stevens, it is my view that the state can look out and say, we, as we have historically, regulate and legislate in the interest of those who will come into being, who will be born. It is an interest that every member of this court has said in potential life.
That is my question. My question is, what is the textual basis in the Constitution? If you're going to say there is none, fine. That's perfectly all right.
I think it's in the nature of our system, and if nothing else, the 10th Amendment, Justice Stevens, suggests that the state can order its relationships in ways that reflect the morality of the people within limits. There's a determination to... I'm sorry.
Why does there have to be something in the Constitution? There's nothing in the Constitution that requires the state to protect the environment, is there?
Of course not.
That can be a compelling state interest, may it not?
Yes. As I have said, the Constitution does not seek to order and to ordain. These are interests in which the state can have, and our nature of government...
All that Roe says is that the Constitution does not protect the fetus under the 14th Amendment. It does not say that a state may not choose to do so.
It doesn't even go so far.
Or that if a state chooses to do so, it is not a compelling state interest. There's nothing in Roe that contradicts.
I think, Justice Stevens, it is in fact the nature of our governmental structure. I do know of prohibitions that the Constitution sets forth. I do not know of particular provisions, other than indeed perhaps the 10th sheds light on this, that this is a matter that ultimately is, and I think this is quite important in terms of analyzing what Pennsylvania has done here. What Pennsylvania has said, in effect, is that we will not prohibit abortion, save for gender selection abortions. Our colleagues on the other side believe that Roe v. Wade forbids that it protects that decision. It does not prohibit. It has seen fit to regulate. That is very much in the tradition of the Western democracies.
Standard, you started out to tell us what the standard was.
We believe it was articulated, Justice White, by the Webster plurality.
Well, what is it?
It is the rational basis standard. And that is the standard that has been articulated by this court in a variety of decisions and by a variety of justices of this court in its abortion.
And under that standard, you would think all of the provisions that are at issue here should be sustained?
Exactly.
And so would complete prohibition, wouldn't it?
Complete prohibition that had no exception for the life of the mother, I think, could raise very serious questions under the protection of life.
Subject to that exception, it would cover it would justify complete prohibition.
I think it best not to answer these in the abstract. We look to the specific interests of the state as it has articulated those interests. For example,
I'll grant you that, but you're asking the court to adopt a standard, and I think we ought to know where the standard would take us.
I think the rational basis standard would in fact allow considerable leeway to the states if it saw fit.
General, that's not really a fair answer. Rational basis under your analysis is an interest in preserving fetal life at all times during pregnancy. It's rational under your view. Ergo, it follows that a total prohibition protected by criminal penalties would be rational, would meet your standard.
I don't think so. The common law.
Then what is your rational basis standard if it's not the traditional one?
Ours is the traditional one, but under that traditional analysis, there must in fact be a rational connection with a legitimate state interest, and the state cannot proceed in an arbitrary and capricious fashion, in my view. If I may complete this, I think this is an important part of the answer. It would be arbitrary and capricious. It would moreover deprive an individual of her right to life if there were not an emergency exception, and even in Roe v. Wade, the Texas statute at issue there provided for that exception. It would be quite at war with our traditions as embodied in the common law not to provide at a minimum for that kind of exception.
But what you're saying is the rational basis standard, which normally just requires a reason that is legitimate to support it, can be overcome in some cases by countervailing interest, which is not the normal rational basis standard.
Well, may I respond? I think that the traditional rational basis test does in fact analyze the ends. It looks at the ends and the means, and it requires in fact that the state not conduct itself in an arbitrary and capricious fashion. That is the ultimate insight of the rational basis test. I thank the Court.
Thank you, General Starr. Ms. Colbert, you have 3 minutes remaining.
Mr. Chief Justice, I'd like to address 2 points very quickly. The first is in response to this last dialogue with General Starr. Recognition of a state's interest in fetal life as compelling throughout pregnancy would denigrate and restrict the ability of women at all stages of pregnancy to have an abortion. And certainly in the only exception that Mr. Starr and the Solicitor General has laid out for this Court is in the very rare instance where only the life of the woman would be excluded from a ban. Bans of second trimester abortions, bans of certain classes of women having abortions, bans that would prevent women who have serious and long-lasting health needs to have abortions would be significantly approved by this Court if the rational basis standard were adopted, precisely because of a formulation that the state's interest is compelling throughout pregnancy and sufficient to override any liberty interest, any interest of the woman to choose or not choose a pregnancy. And in fact, that is why this Court must go back to the hallmark of Roe. That is, again reaffirm that the right to choose abortion is fundamental, and only when the government can show a compelling purpose, as recognized in Roe, that is, a compelling purpose after the point of viability, should it be able to sustain a statute. The second point I wanted to raise goes to the question of the rights by numbers approach articulated by the Commonwealth. It is our view that the husband notification statute applies to every single married woman in Pennsylvania, that the rights of autonomy, the rights of communication within the family, are infringed because those communications are subject to criminal prosecution and subject to independent district attorneys subpoenaing women and probing the communications between husband and wife.
Are there First Amendment values at stake there, do you think?
Your Honor, I do believe there are, not only in this section, but in the bias counseling provisions as well. Clearly, we've set forth in our brief why we believe this is not commercial speech. But in both instances, the Court is forcing the physician to be the proponent of its ideology and also to communicate information about the abortion decision.
Thank you, Ms. Goldberg. The case is submitted. We'll hear
Planned Parenthood of Southeast Pennsylvania versus Casey in a companion case will be announced by Justices O'Connor, Kennedy, and Souter.
These cases come to us on certiorari to the Court of Appeals for the Third Circuit. At issue are 5 provisions of the Pennsylvania Abortion Control Act. The petitioners file suit in federal district court challenging the provisions as facially unconstitutional. The district court found them unconstitutional and enjoined their enforcement. The Court of Appeals reversed in part and upheld 4 of the 5 provisions. The remaining provision, which would require married women to notify their husbands before obtaining abortions, was found unconstitutional by the Court of Appeals. By the combination of several separate opinions filed today, the judgment in number 91902 is affirmed, and the judgment in 91744 is affirmed in part and reversed in part. Justice Kennedy, Justice Souter, and I have filed a joint opinion, which is joined in part by Justice Blackmun and Justice Stevens, and is to that extent the opinion of the court. Justice Kennedy and Justice Souter will also have something to say about the judgment in these cases. Both the petitioners and the cross-petitioners, as well as the United States as amicus, have urged us to re-examine the court's holding in Roe against Wade, decided in 1973. In the joint opinion filed with the clerk today, we have done so, and we conclude that the central holding of Roe should be reaffirmed. Some of us as individuals find abortion offensive to our most basic principles of morality, but that can't control our decision. Our obligation is to define the liberty of all, not to mandate our own moral code. After considering the constitutional questions decided in Roe, the principles underlying the institutional integrity of this court, and the rule of stare decisis, we reaffirm the constitutionally protected liberty of the woman to decide to have an abortion before the fetus attains viability, and to obtain it without undue interference from the state. We also reaffirm the state's power to restrict abortion after fetal viability if exceptions are made where the woman's life or health is in danger. We also hold the state has legitimate interest from the outset of pregnancy in protecting the health of the mother and the life of the fetus that may become a child, and that the state may further these interests so long as it does not unduly burden the woman's right to choose. Applying our analysis to the Pennsylvania statutes challenged here, we uphold, with some exceptions, 4 of the 5 challenged provisions. We find that the definition of medical emergency, the requirement of informed consent, the requirement of parental consent, and the record-keeping and reporting requirements do not impose undue burdens on a woman's right to choose whether she will terminate her pregnancy before viability. We conclude, however, that the husband notification requirement unduly burdens this right and is for that reason unconstitutional.
The essential holding of Roe versus Wade, the holding that we today retain and reaffirm, has 3 parts. First is a recognition of the right of the woman to choose to have an abortion before viability and to obtain it without undue interference by the state. Before viability, the state's interests are not so strong to support a prohibition of abortion or the imposition of a substantial obstacle to the woman's effective right to elect that procedure. Second is a confirmation of the state's power to restrict abortion after fetal viability if the law contains exceptions for pregnancies which endanger a woman's life or health. And third is the principle that the state has legitimate interest from the outset of pregnancy in protecting the health of the woman and the life of the fetus that may become a child. These principles do not contradict each other, and we adhere to each. Our cases recognize the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Our precedents have respected the private realm of family life, which the state cannot enter. These matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, of the mystery of human life. These considerations begin our analysis of the woman's interest in terminating her pregnancy, but cannot end it. For the liberty at stake is in a sense unique to the human condition and so unique to the law. The mother who carries a child to full term is subject to anxieties, to physical constraints, to pain that only she must bear. That these sacrifices have from the beginning of the human race been endured by woman with a pride that ennobles her in the eyes of others and gives to the infant a bond of love cannot alone be grounds for the state to insist that she make that sacrifice. Her suffering is too intimate and personal for the state to insist without more upon its own vision of the woman's role, however dominant that vision has been in the course of our history and of our culture. The destiny of the woman must be shaped to a large extent on her own conception of her spiritual imperatives and her place in society. Now, for these basic reasons, the essential judgment in Roe v. Wade was well within our constitutional heritage. Yet it must be remembered that Roe v. Wade speaks with clarity in establishing not only the woman's liberty, but also the state's important and legitimate interest in potential life. That portion of the decision in Roe has been given too little acknowledgement and implementation by the court in its subsequent cases. Roe established a trimester framework to govern abortion regulations. That trimester framework, no doubt, was erected to ensure that the woman's right to choose not become so subordinate to the state's interest in promoting fetal life that her choice exists in theory but not in fact. We do not agree, however, that the trimester approach is necessary to accomplish this objective. Though the woman has a right to choose to terminate or continue her pregnancy before viability, it does not at all follow that the state is prohibited from taking steps to ensure that her choice is thoughtful and informed. Under the standard we would adopt, so long as it does not place a substantial obstacle in the path of the woman's choice, throughout the woman's pregnancy the state may enact measures designed to persuade the woman to choose childbirth over abortion. Put another way, the state may not place an undue burden on the woman's right to choose an abortion. Today we hold that the requirement that a married woman inform her husband before she undergoes an abortion is invalid. Most married women who seek abortions inform their husbands of their own volition. For these women, the regulation is irrelevant. The regulation is targeted at women who would not otherwise choose to inform their husbands. The record shows that the reason many of these women do not inform their husbands is that they have good reason to fear abuse. The husband's interest in the life of the child his wife is carrying does not permit the state to empower him with this troubling degree of authority over his wife. A husband has no enforceable right to require a wife to advise him before she exercises her personal choices, and a state may not give to a man the kind of dominion over his wife that parents exercise over their children. The notification provision is invalid. As Justice O'Connor has indicated, with one exception, we uphold the other challenged provisions of the statute. On the basis of the record before us and in the context of this facial challenge, we cannot say that the petitioners have shown that any of these provisions places a substantial obstacle in the path of the woman's choice. The exception is the portion of the reporting statute which requires a woman to supply the reason she did not provide notice to her husband before obtaining an abortion. We hold this provision invalid for the same reason that the husband notification requirement itself is invalid.
Justice O'Connor and Justice Kennedy have spoken about the application of the undue burden standard in implementing the central holding of the Roe case, and about the conception of personal liberty that is one of the grounds supporting our decision to adhere to that holding. That holding rested, of course, not only on a concept of liberty, but also on an assessment of the state interest asserted to restrict the exercise of that liberty. It is unnecessary for us to decide, and we do not say, whether we would have resolved the opposing personal and governmental claims as the Roe court did. Instead, it suffices to explain that a foundation for our decision today is the conclusion that if there was error in Roe, its significance is outweighed by the importance of following prior precedent. The principles on which we measure that importance not only support but require adherence to Roe's central holding. A presumption in favor of stare decisis, of standing by the resolution of an issue reached in a prior case, is necessary not only to accomplish the mundane tasks of any legal system, but to realize our hope for a stable society aspiring to the rule of law. At the least, that ideal requires a system characterized in the main by the continuity of rules over time. Except in the instance of a ruling so clearly erroneous as to be, for that very reason, unenforceable, our decisions to adhere to holdings of prior cases, or in exceptional circumstances to overrule them, are informed by a series of prudential inquiries, which in this instance provide reasons to adhere to Roe's central holding. Despite the controversy it has produced, the decision has not proven unworkable in practice. It has undoubtedly engendered reliance in countless people who have organized intimate relationships and made choices that define their views of themselves and their places in society in the 2 decades since it was handed down. It has not been rendered doctrinally anachronistic by other legal developments in the past 20 years, and the factual premises on which it rests are no different today from those on which the ruling rested initially. A decision to adhere to Roe's central holding would therefore be appropriate in accordance with the customary indications of precedential force. But to rest the decision on those customary indications alone would fail to explain the decision completely, for it would fail to take account of the cost of ignoring principles of stare decisis when asked to overrule a case with the very rare significance of Roe. Roe's extraordinary dimension is imparted by the fact that the court's constitutional decision in that case called the contending sides of the national controversy to end their national division by accepting a common mandate rooted in the Constitution. The court is not asked to do this very often, having thus addressed the nation only twice in our lifetime in the decisions of Brown v. Board of Education and Roe itself. But when the court does act in this way, its decision requires an equally rare precedential force. Whatever the premises of opposition may be, only the most convincing justification under accepted standards of precedent would suffice to demonstrate that a later decision overruling the first was anything but a surrender to political pressure and an unjustified repudiation of the principle on which the court staked its authority in the first instance. So to overrule in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. To all those who will be tested by following the court's decision in a watershed case like Roe, the court implicitly undertakes to remain steadfast. The promise of constancy once given binds the court for as long as the power to stand by the decision survives and the understanding of the issue has not changed so fundamentally as to render that commitment obsolete. A willing breach of it would be nothing less than a breach of faith, and no court that broke its faith with the people could sensibly expect credit for principle in the decision by which it did that. It is true that diminished legitimacy may be restored, but only slowly. Unlike the political branches, a court thus weakened could not seek to regain its position with a new mandate from the voters, and even if the court could somehow go to the polls, the loss of its principled character could not be retrieved by the casting of so many votes. Like the character of an individual, the legitimacy of the court must be earned over time. If the court's legitimacy should be undermined, the country would also, in its very ability to see itself through its constitutional ideals. The court's concern with legitimacy is not for the sake of the court, but for the sake of the nation to which it is responsible. The court's duty in the present case is clear. In 1973, it confronted the already divisive issue of governmental power to limit personal choice to undergo abortion, for which it provided a new resolution based on the due process guaranteed by the 14th Amendment. A decision to overrule Roe's essential holding under the existing circumstances would address error, if error there was, at the cost of both profound and unnecessary damage to the court's legitimacy and to the nation's commitment to the rule of law. It is therefore imperative to adhere to the essence of Roe's original decision, and we do so today in striking down a portion of the Pennsylvania statute.
Justice Stevens has filed an opinion concurring in part and dissenting in part. Justice Blackmun has filed an opinion concurring in part, concurring in the judgment in part, and dissenting in part. I have filed an opinion concurring in part and dissenting in a part in which Justices White, Scalia, and Thomas have joined. Under our system of government, unless the Constitution speaks to an issue, the matter is one for resolution by the legislatures, even if the court deems those resolutions unwise. 19 years ago, in Roe against Wade, this court decided that the Constitution establishes a woman's fundamental right to obtain an abortion. And thereafter, the court acted, in our view, as a sort of national legislature on this issue, imposing a complex abortion code on the states. Today, only 2 members of this court still claim that the court's decision in Roe was correct. In their joint opinion, Justices O'Connor, Kennedy, and Souter do not say that the decision in Roe was correct, but they conclude that what they call its central holding must be retained to serve the principle of stare decisis. Stare decisis is defined by Black's Law Dictionary as meaning to abide by or adhere to decided cases. It is clear, however, that the joint opinion does not apply that principle in dealing with Roe. Roe decided that a woman has a fundamental right to an abortion. The joint opinion rejects that view. Roe decided that abortion regulations were to be subjected to strict scrutiny and could be justified only in the light of compelling state interests. The joint opinion rejects that view. Roe analyzed abortion regulation under a rigid trimester framework, a framework which has guided this court's decision-making for 19 years. The joint opinion rejects that framework, and cases following Roe are overruled. The analysis in Roe is replaced by what is called the undue burden test, which does not command a majority of this court even today. This is surely not stare decisis as we have known it up till now. The joint opinion expresses the view that the solution it has come up with is necessary to save the legitimacy of the court. It expresses concern that a complete reversal of on this intensely divisive issue would be viewed as a surrender to political pressure in response to our decision in Roe. But the joint opinion's insistence on preserving the form, if not the substance of Roe, can just as easily be viewed as a surrender to those who have brought political pressure in favor of that decision. Once the court starts looking to the currents of public opinion regarding a particular judgment, it enters truly a bottomless pit from which there is simply no extracting itself. The special rule for intensely divisive cases depends on a completely amorphous standard, quite foreign to our established doctrine of stare decisis with respect to constitutional cases. Justice White, Justice Scalia, Justice Thomas, and I are of the opinion that the court did err in Roe when it determined that the Constitution includes a fundamental right to abortion. We believe, in accordance with the views expressed in Webster versus Reproductive Health Services, decided several terms ago, that a woman has a liberty interest under the Due Process Clause in obtaining an abortion, but that the state may regulate abortion procedures in ways that are rationally related to a legitimate state interest. Applying this test, we would uphold each of the Pennsylvania regulations challenged in this case. Justice Scalia has filed a dissenting opinion in which I, Justice White, and Justice Thomas have joined.
We'll hear argument first this morning in Case 05380, Gonzales versus Carhart. General Clement.
Mr. Chief Justice, and may it please the Court, Congress held 6 hearings over 4 different Congresses and heard from dozens of witnesses in determining that partial birth abortions are never medically necessary, pose health risks, and should be banned. Under familiar principles of deference to congressional fact-finding, those determinations should be upheld as long as they represent reasonable inferences based on substantial evidence in the congressional record. That standard is amply satisfied here. The evidence before Congress was clear that partial birth abortions were never medically necessary and that safe alternatives were always available such that no woman would be prevented from terminating her pregnancy. As a result, Congress was entitled to make a judgment in furthering its legitimate interests that they were going to ban a particularly gruesome procedure that blurred the line between abortion and infanticide.
General Clement, couldn't a similar record be made with respect to what is the more common procedure, the D&E? That involves dismemberment of a fetus inside the womb. So assuming you're right that it is constitutional for Congress to ban the D and X proceeding, wouldn't the same reasoning apply? Couldn't Congress make similar findings with respect to what is the most common method for second trimester abortions?
I don't think so, Justice Ginsburg, and I think that this Court's precedents, in particular the Danforth case, would stand as an obstacle to that piece of legislation, because in Danforth this Court struck down an effort to ban what was then the majority method of inducing a second-term abortion. And I think in the same way, there's quite a different situation when Congress comes in and tries to deal with the primary abortion method in the second trimester. Here, though, Congress didn't go after the dog, so to speak. It went after the tail, this very aberrant procedure, atypical procedure, and the numbers are hard to come by. But I don't think anybody suggests that the DNX procedure is anything more than a very small minority of second trimester abortions. And so I do think
even though we're told by some of the medical briefs that the procedures are basically the same. They start out in the same way, and that the differences are not large in particular cases.
Well, Justice Ginsburg, let me make a couple of points in response to that. I think, taking it the broader level first, I think there is one very important difference between these two procedures that led Congress to ban one and allow the other to stand, and that is whether fetal demise takes place in utero, which is, of course, the hallmark of all abortions, or whether fetal demise, the lethal act, takes place when the fetus is more than halfway out of the mother. Now, as to there's the suggestion, I think, most particularly by respondents in the second case, that there really is no meaningful difference between those two procedures. And with respect, I just don't think the record supports that. If you look at the record in this case, it's very clear in the district court opinion that you have some doctors, and examples would be plaintiff's expert Dr. Cranen or one of the Nebraska plaintiffs, Dr. Vibekar. They go in each and every case and try to perform a dismemberment or D&E procedure. And because they're trying to perform the D&E procedure, they need to dilate the cervix only modestly. And so Dr. Cranen, for example, his testimony is he only dilates the cervix 2 centimeters or 2.5 centimeters. Now, in contrast, you have other doctors, and here the examples I would point to are two of the plaintiff's experts, Dr. Chasen and Dr. Fredrickson. They, in every single case, set out to perform the DNX procedure. And that has material differences in, for example, the dilation regimen that they use. And so Dr. Fredrickson, for example, uses multiple sets of laminaria to dilate the cervix, and she gets a much greater degree of dilation, 5 to 6 centimeters of dilation. And, of course, not only do they set out to perform different procedures, but they, in fact, perform different procedures. So the evidence here again reflects that Dr. Vibekar, for example, in 100% of the cases, ends up performing a dismemberment procedure or a D&E procedure. For Dr. Cranen, it's 99%. Now, by contrast, Dr. Chasen and Dr. Fredrickson, when they set out to perform a DNX procedure, they're successful in their objective less often. The records, there are different numbers for different doctors, but it seems that at most they can achieve their objective about a third of the time.
Were those doctors testified in the congressional hearings or in the Eighth Circuit or in the Ninth Circuit or the Second Circuit? But there are so many doctors here. Which of the two that you're referring to that do not dilate the cervix fully? Did they testify in any of the district court cases?
They did. They did, Justice Kennedy. And, I mean, in particular, Dr. Cranen is an expert. I think his deposition was taken, or his testimony was taken principally in the California case, but it was introduced in all three cases as part of the evidentiary record. Dr. Vibekar is one of the plaintiffs in this particular case. And Dr. Chasen and Dr. Fredrickson was also their testimony was in the record, I think, in all three cases.
Right, so my going through this record, I compare it with Stenhart, with what's in Congress. We have two cases here, and isn't it a fair conclusion that there are, in each case, before Congress and in here, there are some doctors who think this is safe and some doctors who think it isn't safe. And if you look at the sort of counted by numbers, I guess if you look by lines of testimony or by different doctors, interestingly enough, it seems to me there are more doctors in these two cases and in front of Congress who said it is not safe than there were when we considered the other case. And there are fewer doctors who say it is safe even with the other case. So I don't know if you're supposed to count doctors or what. My question would be, if this Do we owe more deference to a congressional finding or to Congress than we owe to a state legislature? What is, I take it a state legislature is democratically elected. And don't we owe similar deference to both?
Well, Justice Breyer, I think you certainly owe deference to both. I think
well, if we owe deference to both, and I would have thought that we did, then I think in the Nebraska case, despite the deference that was owed, the Court came to the conclusion that the statute of Nebraska was unconstitutional because it lacked an exception for the health of the mother, something that came from preceding cases. So if giving deference to Nebraska, we reach that conclusion there, and if the deference that is owed is the same, and if the evidence is about the same on both sides, how can we reach a different conclusion here?
Well, Justice Breyer, obviously I'm in a certain deficit to you in discussing what this Court held in the Stenberg opinion, which you wrote. But my reading of that opinion is that this Court did not focus on what was before the Nebraska legislature, but this Court focused on what the district court found. And in particular, in the critical part of the opinion, which would be Section 2A of the opinion, as I read the opinion, what this Court did is it confronted Nebraska's argument that the DNX procedure was not, in fact, safer. And the first thing this Court did is say, well, that argument faces quite a burden because the district court made a contrary finding. And then this Court, in 2A1 of the opinion, referenced that finding and 4 different times cited the district court record. And then so on and so forth. It then noted the various 8 arguments were made by the State and its amici to the contrary. And as I read the opinion, basically said the latter, the objections, don't outweigh the former, the findings. Now, I think if you compare the record before the courts and before Congress, compare that to what was before the district court in Stenberg, I think there's a much more robust factual record here. If you look at the Stenberg case —
General Clement, are not some of the findings by Congress clearly erroneous? For example, there is a statement that no current medical schools provide instruction in the procedure. Now, that's clearly wrong, isn't it?
Well, specifically what Congress found in that finding was that none of them provided as part of the curriculum. And I think what the record here clearly reflects is I don't know that the idea of a curriculum, I don't know exactly what Congress had in mind, but clearly as a matter of sort of what you teach residents.
Do you think that finding is correct?
I don't know if it's correct based on the curriculum point, but let me say this.
Well, supposing there was a lot of evidence introduced in the district court that there were schools like Yale and New York University that did include this as part of the curriculum, could the district court disregard that finding and make a contrary finding?
I think if the evidence in the district court were overwhelmingly to the contrary, I think that the district court could effectively undermine that one finding. I don't think in this case anything turned.
On other findings, is there a different standard of review of what the district court found as opposed to what Congress found?
Well, Justice Stevens, I would answer you this way. You might first want to isolate those situations where if the district court is addressing an issue that just wasn't before Congress at all, but it's somehow relevant and makes factual findings, I suppose the district court is entitled to the normal kind of deference on review. But I think if you have situations, which you have in this case, where the district court heard some of the same witnesses who testified before Congress and before the district court, and the district court makes a different credibility finding than the Congress made, I don't think that's a basis for the district court to be able to overcome the contrary finding of Congress.
I don't understand Congress to have made credibility findings. As I read the whole finding, there were 6 or 7 pages of findings, and I don't find a single reference in those findings to the performance of an abortion on a non-viable fetus. All of the language in the findings seems to be referring to viable fetuses just inches away from becoming persons. I don't think you even find the word fetus in those findings. The findings as opposed to the text of the statute.
Sure, Justice Stevens, though, I think I need to clarify an important point there, which is to say the statute didn't focus on viable versus non-viable because it applies on both sides of the viability line.
I'm talking about the findings. And is there a single word in the findings that refers to a viable fetus? It refers to a non-viable fetus.
I don't think there is, Justice Stevens, but I wouldn't find that at all remarkable in a statute that applies and bans certain procedures without regard to whether the procedure is applied to a viable or a non-viable fetus. And when Congress does make specific findings that the procedure that it's banning would have the effect of preventing a lethal act on a fetus just inches from being born,
well, it's not
referring.
May I interrupt? It's
sure.
not preventing the lethal act. It is requiring that the lethal act be performed prior to any part of the delivery, because there's no doubt there will be a lethal act.
That's very important. I agree with you.
The only issue is when it may be performed.
Well, the issue is whether.
Correct?
Yes, but the issue is very important because it's the issue as to whether it's going to be performed in utero or when the child is more than halfway outside of the womb. And that, of course,
the fetus
corresponds.
is more than halfway out.
I'm sorry?
Whether the fetus is more than halfway out. And some of these fetuses, I understand, in the procedure are only 4 or 5 inches long. They're very different from fully formed babies.
Justice Stevens, again, I mean, you're right.
When it's halfway out, I guess you could call it either a child or a fetus. It's sort of half and half, isn't it?
I think you could use either terminology, Justice Scalia. My point is nothing turns on the terminology. I mean, the terminology that Congress chose to use is a living fetus. I think the point, though, is that when fetal demise is induced in utero, whatever else you think about that procedure, that is classically an abortion as it's been always understood. But when fetal demise is induced when the living fetus is over halfway outside of the womb, then I think Congress
is going to suffer a demise in seconds anyway.
Well, it may be seconds, it may be hours, it depends on because
But do you not agree that it has no chance of survival? In most cases.
If we're talking about pre-viability, then yes. By definition, chances are it won't survive.
That's right.
But again, I don't think that that anything
and
in this
Congress
act
has made the judgment that it is far preferable to ensure that fetal demise takes place before any delivery begins. That's the big issue.
Well, I'm not sure if it's whether. That's a fair summary. I mean, it's the line isn't that fetal demise has to be done before any delivery begins, but the basic point of this statute is to draw a bright line between a procedure that induces fetal demise in utero and one where the lethal act occurs when the child or the fetus, whichever you want to call it, is more than halfway outside of the mother's womb.
Would it be lawful or would it be infanticide to deliver the fetus entirely and just let it expire without any attempt to keep it alive?
Well, in the post-viability context, it would clearly be infanticide. I think in the pre-viability context, if you have a complete delivery, but the child isn't going to survive, I don't think it would be infanticide to necessarily let the child expire. But I do think, by contrast, if somebody tried to, with the fetus, perfectly alive, and in the hours that it might have to live, if somebody came in and ripped its head open, I think we'd call that murder. And in fact, Congress passed another statute to make that clear.
That's not what this case is about, because I think that you have recognized quite appropriately that we're not talking about whether any fetus will be preserved by this legislation. The only question that you're raising is whether Congress can ban a certain method of performing an abortion. So anything about infanticide, babies, all that is just beside the point, because what this bans is a method of abortion. It doesn't preserve any fetus because you just do it inside the womb instead of outside.
Justice Ginsburg, that's right, but I don't think that's to trivialize Congress's interest in maintaining a bright line between abortion and infanticide. And the way I would illustrate it is that line, even if you might think it has a temporal line in the sense that viability versus pre-viability is relevant, it clearly has a spatial dimension as well. And the best illustration of that, I think, is think about a lawful post-viability abortion. There's a problem with the mother's health. There's a problem with her life. So it's a lawful post-viability abortion. I don't think anybody thinks that the law is or should be indifferent to whether in that case fetal demise takes place in utero or outside the mother's womb. The one is abortion, the other is murder. And I think that just recognizes that even in the post-viability context, you have a very important line, which is a spatial line, and that line is basically in womb, outside of womb. And what Congress tried to do in this statute is to draw that line and differentiate between one procedure where fetal demise takes place in utero.
If this case were limited to post-viability abortions, it would be a different matter. But isn't it so that the vast majority of these abortions are going to be performed pre-viability?
I think that's probably right, Justice Ginsburg, but I think the point I would make is that Congress has an interest in maintaining the spatial line between infanticide and abortion, even with respect to pre-viability fetuses. And that's true for at least two reasons.
So I see what you're driving at in terms of the procedure. We're focusing on a universe where the fetus is not going to survive no matter what, right?
Right.
Okay. So we're not talking about anyone being born and living. They're not going to. And
well, with the caveat that the statute does apply
that's
both.
The area of focus.
Right.
Now, Congress has said that good doctor, you can achieve that result through method A, but not through method B. And you're saying Congress had good reason for doing that. I take it Congress also agrees that if method B, which they don't want, were to be necessary for the safety or health of the mother, the Constitution would require it being done. I didn't see anything here about Congress disagreeing with that.
Oh, I think that's right, Justice Breyer.
Right,
I think Congress took this Court's Ginsburg decision as a given and as a starting point.
Okay, they make a finding that although we don't disagree with that, we don't think it's ever necessary for the health or safety of the mother. That's where we are. Now, as I looked at the record, I see many, many, many doctors telling Congress and everybody else that it is necessary and safer. And I see other doctors telling Congress primarily, but in court too, that it isn't necessary ever for safety. And so if medical opinion is divided, and I'm not advocating what I'm about to say, I just want to know your reaction. If medical opinion is divided, why wouldn't it be up to this Court, or could this Court say, this use of this procedure, we enjoin the statute to permit its use, but only where appropriate medical opinion finds it necessary for the safety or health of the mother. Now, if Congress is right, there will be no such case, so it's no problem. But if Congress is wrong, then the doctor will be able to perform the procedure, and Congress couldn't object to that because the Congress isn't worried about Congress, then Congress was wrong. They agreed that we had a health or safety exception.
With respect, Justice Breyer, here's the problem with that way of approaching the statute. That might be a permissible way of approaching it if what the evidence on the other side here was that, well, there are cause-specific reasons why you need this procedure. There are particular conditions where you need this procedure. But that's not the evidence on the other side. What their doctors say, the doctors who perform this DNX procedure, the Dr. Chasins, the Dr. Fredricksons, what they will tell you is that in every single case, the DNX procedure is better and safer, and they want to do it. And so it doesn't make – Congress can't pass a statute that bans procedure A, and that ban doesn't apply any time a doctor prefers procedure A.
No, it just wouldn't be a question of the doctor's preference. You would have to refer back to prior cases. And what the prior cases talk about, including Stenberg, is not that the doctor simply has a preference, but rather that there has to be a significant body of medical opinion that says that this is a safer procedure and necessary for the safety of the mother. Now, where that's true, the Court has previously said that the Constitution protects the right. And I don't see anything in what Congress says that wants to change that law. They simply have a different view of the facts.
Well, they do have a different view of the facts, and I guess
so. If they have a different view of the facts, why can't we leave it up to whatever facts develop? If there is an appropriate body of medical opinion that does in fact believe this is necessary for the health of the mother, so be it, and the abortion could be performed, and the injunction would say that.
Well, I think
otherwise not.
If this Court rejects the facial challenge to this statute, it is still going to be open for litigants in the future to try to identify specific conditions where this procedure is the safer alternative.
Can you tell me the hypothetical instance in which an as-applied challenge could be brought if we sustain the statute on its face? The procedure has to take place within
24, 48, 72 hours. How would an as-applied challenge take place? I read all the doctor's testimony in these cases, hundreds of pages, and am familiar with the area generally. But it takes a while to get up to speed. I don't know if you could just go to a district judge and say, well, I need an order. The judge would have to take many hours to understand this.
Oh, Justice Kennedy, what I think I have in mind principally would be a pre-enforcement challenge that was an as-applied challenge. And what I have in mind, and that's something that there is in other areas of the law. Steffel against Thompson is an example. But what you would have in mind is a doctor who has standing under this Court's abortion jurisprudence would come in and say, look, in my practice, I've seen that this procedure would be particularly useful in dealing with preeclampsia or placental previa or some condition.
Why isn't that already in the record in the Ninth Circuit, in the Second Circuit, and in the Eighth Circuit, in the district court's proceedings in those circuits?
Well, there's an effort to make that showing. I don't think that it's been a successful effort to make that showing. In fact, I think if you look at the findings of the district courts in these cases, 2 of the 3 district courts found that there was no particular condition where the DNX abortion was medically necessary or had marginal safety benefits. In this case, the Nebraska case, the district court identified only 2 conditions, preeclampsia combined with maternal cancer and placenta previa. And as to those particular findings, as we point out in our reply brief, there are problems with each of those findings.
I'm just thinking, trying to imagine how an as-applied challenge would be really much different from what we've seen already.
Well, I don't think, they've challenged everything, including every application of the statute, and they've tried to pick off some particular conditions. What I'm imagining is in the future you might have additional evidence, you might have additional experience with doctors, and they might come in and target their challenge to particular conditions and try to say
General Clement, conditions don't show up in the abstract. Wouldn't it often be the case that it depends on the vulnerability of the particular patient, and you couldn't bring a pre-enforcement challenge as to that? I mean, if it's a question of hemorrhaging, that it's a combination of what the condition is and the vulnerability of the particular patient, and I don't see how that could be tested in advance.
Well, Justice Ginsburg, my understanding is that even when you talk about an idiosyncratic condition, the doctors that perform these abortions perform, hundreds of them a year, and they can identify those conditions, and they have names for those conditions, and I think it would be amenable to bringing a more as-applied challenge.
General, do you understand the scope of this statute to be different than the scope of the statute at issue in Stenberg? Focusing in particular on the deliberate and intentional language?
I certainly do, Mr. Chief Justice, and I think that this statute, unlike the Nebraska statute, clearly uses an anatomical landmark approach that is based in the text of the statute and clearly distinguishes between the D&E procedure on the one hand and the DNX procedure on the other hand.
But isn't it quite independent of the anatomical approach that the health exception is denied? That does not depend on the anatomical approach. The anatomical approach may well be an answer at the facial challenge stage to problems of vagueness, for example. But the health exception problem is not affected by that. And the difficulty that I have with your argument that somehow the health exception issue should be left to an as-applied challenge is the statement in Stenberg, it's on 938, and I'm quoting, "But where substantial medical authority supports the proposition that banning a particular abortion procedure could endanger women's health, Casey requires the statute to include a health exception where the procedure is necessary in appropriate medical judgment for the preservation, of the life or health of the mother." Now, your position, it seems to me, requires us to do one of 3 things. Either we overrule Stenberg in that respect, or we find, I don't know how, but we might find, well, in this case there is no substantial medical authority, and therefore on the face of the statute there seems to be no impediment in the Stenberg statement. Or 3, we say, well, there seems to be a tension between the showing of substantial medical authority which occurred in the litigation in these cases
in the findings made by Congress, and under those circumstances, in effect, we are required to ignore the record in the cases and go with Congress's apparently contrary judgment. Which of the three do we take?
Well, I mean, we would urge you to take any one of
take
the three.
all three. No, but seriously.
But in fairness, I mean, we have an obligation to defend the statute. So our first effort would be to say we distinguish the Stenberg
case. But the problem, I guess, focus the problem this way. The Stenberg opinion talks about substantial medical authority as triggering this requirement for a statutory element. That problem is not focused simply by saying Congress made some findings and the district court made other findings and Congress should prevail. The fact is the substantial medical judgment finding, I would suppose, is satisfied by the record in the district courts in these cases. This is not one doctor's idiosyncratic judgment. And a court could reasonably find, it seems to me, that there is substantial medical judgment. If we are going to defer, as you say we should defer to Congress, haven't we got to overrule that statement?
I don't think so, Justice Souter. And let me just, I'd like to save some time for rebuttal, but let me try to answer it this way, which is our way of looking at Stenberg is Stenberg really doesn't address what you do when there are congressional findings. And there's some tension between Stenberg and Turner on this, because Stenberg seems to suggest, well, when there's a doubt, the kind of doubt that would normally get you past summary judgment, you defer to the doctors. And Turner seems to suggest when you have a doubt, conflicting evidence, the kind of doubt that might get you past summary judgment normally, you defer to Congress. And it has to be one or the other. You can't go both ways, can't go opposite ways. And we would say resolve that tension by when there is congressional findings, something that you obviously didn't have to confront in Stenberg, defer to the congressional approach. If Stenberg means something contrary, and even in the face of congressional findings, that you have to defer to a minority opinion of doctors, and, kind of invert what would normally be the way of approaching it, we think then that would be inconsistent with this Court's decision in Casey, among others, and you should revisit Stenberg to that extent. Thank you.
Thank you, General. Ms. Smith?
Mr. Chief Justice, and may it please the Court. The government throughout this case has quarreled with the plaintiff's statement of Stenberg, and Congress quarreled clearly with the district court findings. But their real argument here is with this Court and the Court's ruling in Stenberg, particularly in light of the congressional findings that are frankly unsupported by either the congressional record or the additional evidence presented to the district courts. The only course here that preserves the independence of the judiciary, that exemplifies the importance of stare decisis, not to mention the only course that will protect women from needless risks of uterine perforation, infertility, sepsis, and hemorrhage, is to hold this act unconstitutional.
Can you tell me, I didn't find it in the materials, and maybe the statistics aren't available. In the cases where intact D&E or DNX are performed, in the period, 16 through 21st, 22nd weeks, in how many of those instances, do you have any idea, in how many of those instances is there a serious health risk to the mother that requires the procedure, as opposed to simply being an elective procedure?
If what Your Honor,
are there any statistics on that?
No. In terms of the underlying medical conditions, there really aren't, Your Honor, and it varies dramatically according to the practice of the physician. If a physician is in a high-risk OBGYN practice, he or she is much more likely to encounter patients with serious underlying medical conditions, such as the ones that the doctors have testified about in this case, the liver disease, kidney disease, heart, cardiovascular disease, cancer of the placenta, bleeding placenta previa, all of these issues that and underlying conditions that make the intact and the risks that are reduced by the intact D&E particularly important.
We have no evidence either in the record before the Court or Congress as to how often that situation arises?
No, we don't, Your Honor. We know that in some practices it's quite frequent. In some practices it's not as frequent because those are mostly hospital-based practices. But on the other hand, there's extensive evidence in this case, much more evidence, frankly, Your Honor, Justice Breyer, than there was in the Stenberg case of the
I have just one other question.
Yes.
It's generally related to the first.
Okay.
If there is substantial evidence that other procedures or alternate procedures are available, alternate to DNX, alternate to intact D&E, is your response that although they're available as a matter of science, as a matter of medical expertise, they're not available because hospitals don't allow the patients to be admitted? I was going to ask that same question to the government. Because there's some indication in the record that certain hospitals just don't admit patients for this purpose, which goes back to my earlier question. I was wondering if that's because it's surely elective.
Because it's what?
Because it's purely elective and not medically necessary.
No, Your Honor. Many hospitals throughout the United States refuse to provide any abortions whatsoever, as just a blanket rule. There are some that will provide abortions in certain circumstances where the woman is obtaining the abortion because of a certain medical condition. Then there are women who are obtaining an abortion because they have chosen that that's the best course for them, who also have underlying medical conditions. So if you're a woman who has chosen to obtain an abortion and you have an underlying cardiac disease, for example, we had a case like this in Louisiana. The hospital refused to do the abortion because her chance of dying from the underlying medical condition was not over 50%. So the availability of hospital services is somewhat unrelated to this case, but it is quite limited in some
Well, it might be related
Yeah.
in the sense that the government's argument that there are alternate mechanisms is not a practical alternative. I was going to ask the government about that. On the other hand, the fact that any number of hospitals don't allow the procedure is also indication that there's a medical opinion against it.
No, not at all, Your Honor. The medical opinion in those cases is against abortion whatsoever and a refusal to use one's facilities to provide any abortions of any kind, not about any particular procedure. I'm sorry, Justice Breyer.
I'd like to get your characterization and the government's of the state of the record. I asked my law clerk, basically, to go look up every statement that was made in 4 forums. First was the first Stenberg case. Second was Congress. Third is one of the cases here. And the fourth is the other case here. Now, my own impression of that is if you're talking about the medical need for such a case, that is for intact D&E, that there is a risk attached if you don't use it. In some instances, the fewest number of statements for that proposition was in the first Stenberg.
Yes.
More statements in Congress. More statements that the doctors who say I need this procedure for safety.
There are many more in this case.
There are many more in this case than there were. In these 2 cases, there are many more than there were in Congress, and in Congress there are many more than they were in first Stenberg.
That's right.
Now, if we look to the other side of the coin,
yes, the
doctors who say no, it isn't safe, there I'd have to say there are probably many more in Congress than there are the doctors who say it isn't safe. There are probably many more in Congress and then there are some in these cases too, and there is hardly any in Stenberg, not too many.
Well, there's
those against you, in other words.
There are many letters written to Congress that are in the record.
Right.
In terms of live witnesses, Your Honor, there were in Congress 8 live witnesses that testified all
together. So I'm left with a record where I guess you have a subjective characterization that there's at least as much evidence in these cases supporting you and as much in Congress supporting you as there was in the first Stenberg case. But Congress made this finding. So what am I to do with the finding?
Right. Well, the important point, Your Honor, is that even if the Court applied the highest level of deference under Turner, the findings would be rejected and must be rejected, as all three district courts held, because they're simply unreasonable, even under a Turner standard.
Ms. Smith, was the statement of the American College of Obstetricians and Gynecologists before Congress?
Yes, Your Honor, it was. As was the brief that was filed, the amicus brief that was filed in this case in Stenberg was before Congress, and also testimony from numerous physicians in the form of letter. In terms of live witnesses, there were simply not that
We'll give you an extra 30 seconds to
That's
proceed.
fine, Your Honor. I've lost track of my train of thought, though, I think.
Well,
what I was saying was there were 8 witnesses who testified live.
The question basically
And,
I think you might have been going after
Yes.
is I was saying that I agreed with you in that there's more evidence supporting your side in these cases than there was before Congress, than there was in first Stenberg.
Yes.
But still, there was a finding in Congress, and there wasn't a finding in the Nebraska legislature. And so does that fact of the finding being in Congress and not in the Nebraska legislature, what kind of legal difference does that make?
And, Your Honor, what I would say in this case, it makes none. While it's an extremely interesting academic question about the level of deference that should be applied in this kind of circumstance, here it really is academic, because even under the Turner standard, if applied in the way that Turner actually applied deference, to carefully review the findings in light of the evidence in Congress and, again, in light of the evidence in the district court.
May I ask you this question about what you think we should do if I thought the evidence did support the conclusion that it's never medically necessary? The evidence merely supports the proposition that a doctor has to be a lot more careful if he goes one way rather than the other, because there are more risks involved in one procedure rather than the other. Would that be sufficient to support I can see the argument that the intact delivery may have less risks of complications and so forth, without it not necessarily being absolutely necessary.
Well, I think there's been some confusion about the word necessary, and it's been used sometimes to talk about whether there are other procedures that could be used, as opposed to the determination that it is the safest procedure that reduces significantly the risk of very serious complications, not the risks of minor complications.
I guess that gets back
Yes.
to the point earlier. I mean, do you agree with the discussion earlier that this Act is not going to prevent abortions?
No, not at all, Your Honor. The issue of the scope and breadth of the law is, I think, the evidence clearly shows that this is a very broad law that applies to D&E abortions. And contrary to what the Solicitor General said about the intent of abortion providers like Dr. Vibacher and others, they actually, their intent is always to remove the fetus as intact as possible, and the district courts have recognized that as an intent that's covered under the terms of the Act.
What degree of marginal impact on safety do you think is necessary to override the state's interest? I mean, if you have complications under the D&E procedure in, say, 10% of the cases, complications under DNX in 9.99% of the cases, is that marginal benefit in safety enough to override the state's articulated interests?
I don't believe a marginal benefit in safety is enough, and I don't believe that's what we have here. The testimony from at least 11 board-certified OBGYNs from the American College of Obstetricians and Gynecologists is that the reduction in risk is significant and that it reduces the risk of serious complications, such as uterine perforation, which can lead to hysterectomy.
But I thought your submission earlier was that we don't have any record evidence about how often the complications arise. So it's hard to get a handle on exactly what the difference is in terms of safety under your submission.
We don't have a quantification of the safety. What we have is the clinical experience of major leading physicians in the field who've testified that they've used both procedures. In fact, many of them have testified that they've perforated uteruses in non-intact D&Es, and they've never perforated a uterus in an intact D&E. And that, in fact, is borne out by the Chasen study, a very small study with very small numbers, but it shows all the serious complications are in the non-intact group.
If we could go back to the first question that the Chief asked you, you said, yes, it will prevent abortions because of this uncertain line between the D and X and the D and E. Is there a way that Congress could have written the statute that would have insulated the physician who's performing a D and E?
Absolutely, Your Honor. I think that the blueprint that this Court laid out that certainly is suggested in Justice O'Connor's concurrence in Stenberg was rejected by Congress. She references 3 statutes that if they had included a health exception, she thinks would have been constitutional. They all include the word intact. I think there's another narrower construction of the Act, too, that is possible. Adding in the word intact, reading in the word intact, it seems to me, is not a reasonable interpretation of the statute as it is, but certainly Congress could have done that, and other states have done it. But Congress set out not to do that.
May I ask you to focus on one particular problem that I think is implicated by Justice Ginsburg's question? If I understood you correctly a moment ago, and I think this is in your briefs too, you said that the definitional problem is that doctors always set out to do an intact procedure if they can, because it involves less risk to the mother from acts performed inside. And if that's the case, then it would be, I guess, in the real world, very difficult for Congress to define a difference between D and E and D and X, because the intention is always, as you understand it, to have an intact result. Your brother on the other side, the Solicitor General, says there certainly is testimony to the effect that that is not so, that doctors who intend to perform a D&E simply intend at the beginning to have a lesser degree of dilation, which will force them to do the D&E and not have a totally intact procedure. Would you comment on what I think is the factual difference between you and the Solicitor General there?
Yes, Your Honor. The problem with the law is that because it's not limited to intact, it would in fact cover the procedures that are performed by physicians who intend to perform a procedure as intact as possible, but simply don't expect that.
I understand that, but
yes.
could you start simply with the factual predicate for your argument and his argument? You seem to be starting from, if I understand the two of you correctly, you seem to be starting from basically different factual assumptions. Could you start by commenting on that?
Yes. The doctors perform the same dilation protocols, whether they're going to perform a D&E or an intact D&E. And that's true for Dr. Chasen and Dr. Westhoff, who perform both intact and non-intact procedures.
I thought the evidence was that you're looking for a different degree of dilation if you're intending to perform D&E than if you're looking for a greater degree if you're intending to perform a D&X.
It doesn't play out that way. Doctors do have different dilation protocols, but they're often looking for as much dilation as they can get.
Is your submission that there aren't different dilation protocols if you're intending a D&E and if you're intending a D&X?
It varies by doctor. For example, Dr. Carhart uses the same dilation protocol whether he's going to do an intact or a non-intact. Other doctors might try to do more dilation, and the doctors, importantly, can't control the amount of dilation they get. So a decision happens.
Well, they may not be able to control it in an absolute sense, but can't they go about it in a way that would tend to produce less rather than more dilation? They can't guarantee results, but couldn't they at least start with a, I don't know how to put it, a procedure that would be likely to produce less rather than more, and hence come within the safe harbor, if you will, of the statute?
Well, they're always looking for a minimal amount of dilation. Then people who chose to do another day of dilation, for example, that could add additional dilation. But for the first day of dilation, no, Your Honor. They don't seek more or less over one day. They might do a second
you say
day or a
they
third
don't.
day.
My question is, can they? And the record may not show this. I'm not asking you to answer the impossible, but do we have evidence that would indicate that they can or that they can't?
Not in the first day of dilation, no. They can't control how much dilation is going to occur. They need a minimal amount, and they're not going to shoot for less than that.
Can you tell us where to look in the record for the evidence on that?
Each doctor testifies about their own dilation protocols, Your Honor, and I believe that that's in the Eighth Circuit appendix, those portions of that testimony, and are cited more specifically in the Eighth Circuit briefs, which goes more into the factual detail, Your Honor, but I don't have the cites right now. I'm sorry.
If there were a health exception, yes, the health of the woman, would that obviate the vagueness and overbreath problems that you bring up? Because then after it would say to the doctor, you put the health of your patients first. And if you think that it's riskier for her health to do it one way than another way, then you pick the safer way. If you had that, then wouldn't the concerns about overbreath fade?
No, not if this is not limited to intact, Your Honor, because then you would be limiting D&E abortions, which is 95% of all abortions, to circumstances where the doctor could prove that it was, in fact, the safest procedure. And we've had doctors testify in trial, for example, that they refuse to describe even regular D&Es to their patients because they believe induction is always safer. So those doctors, I think, would still be at risk, and it would put 95% of second trimester abortions at risk in that case to prosecution for performing a D&E when you should have been performing an induction.
Do you think on this same issue, I think, the addition of the deliberately and intentionally language in the Congressional Act addresses that concern?
No, Your Honor, because actually that same language is in the Stenberg, the Nebraska statute. It also was targeted at deliberately and intentionally. I do think that if there is a construction that would narrow the law to a limited amount of intact D&Es, if you read the for the purpose of language in the statute, to be performing an overt act for the sole purpose of completing delivery, then, or rather, I'm sorry, for the purpose of performing an overt act that causes fetal demise, that does not facilitate delivery of the statute.
That's what I was wondering. Suppose that maybe this might help. Suppose the physician testifies that I wanted to do a non-intact, an in utero D&E. That was my intent. That's what I wanted to do. That's what I always want to do. In this case, I had an intact delivery and had no other choice. Are you saying that we could interpret the statute to say that that is not the prohibited criminal intent? He is immune from prosecution in that case.
No, I don't believe that's the line that could be drawn, Your Honor, because anyone who does a D&E is intending to remove the fetus as intact as possible and always can have the intent to go to the anatomical landmark that's here. I'm suggesting a different interpretation that uses the for the purpose of language, where it says for the purpose of performing an overt act that the person knows will kill the partially delivered living fetus. If that language was interpreted to be for the sole purpose of performing fetal demise at that point, rather than what the doctors do, which is perform the action that causes fetal demise in order to facilitate delivery of the fetus, So if it's not to facilitate delivery of the fetus.
Give me one instance in which your proposed interpretation would work in the real world.
Well, there are allegations in the congressional record, for example, and referenced in Justice Thomas's dissent by Nurse Schaefer, Dr. Pamela Smith, about circumstances where the physician actually holds the fetus in the woman's body in order to cause fetal demise, rather than causing fetal demise because it's an integral part of removal of the fetus from the woman's uterus. And those circumstances would be banned under that interpretation. But I want to get back to the Turner point, if I may, for a minute, the issue of deference to congressional findings.
Well, just on that last point, I mean, we're interested, of course, in different interpretations, but it just seems to me that your interpretation would have very little practical effect.
Well, it would ban certainly a certain type of intact procedure that was discussed, and I think is the image many people have of, quote, partial birth abortion, frankly, that this is something that's done gratuitously, not as an integral part of making a procedure the safest for the woman and avoiding instrumentation and avoiding perforations and hysterectomies, which are serious complications that, though rare, when they occur, they are catastrophic and life-changing and disastrous. So the numbers are not high of any complications, but the complications when they occur are devastating. And this is what the doctors are experiencing when they perform intact D&Es, that they're not having these types of complications. So if I could move to the deference point, I would like to talk a little bit about deference to congressional findings, because there's significant authority from this Court, of course, saying that where there are danger signs of constitutional risks, as the Court recently said in Randall versus Sorrell, that the Court must independently and carefully review congressional findings. And the Court has rejected findings that attempted to change either by findings of fact or legal findings that attempted to change a constitutional standard. But in any case, the findings in this case are simply unreasonable and not supported by the evidence. If you go to the findings themselves, the ultimate finding in 14-0, which claims that it is actually relying on the preceding findings, it says, for these reasons, Congress finds that partial birth abortion is never medically indicated. And then you go backwards and look at the reasons. The reasons are the findings that are not defended by the government, that were not defended by the government witnesses, and that are blatantly false, except for perhaps one of them. There are findings of that partial birth abortion poses serious risks. The government witnesses agreed that this was not true. There are findings that partial birth abortion is not taught in medical schools. Of course, we know that is simply not true. It's an integral part of abortion training at major medical institutions like Cornell, Columbia, Yale, NYU, Northwestern, et cetera. It says that partial birth abortion is a disfavored practice among abortion providers. That is absolutely not true. And it says that there are no comparative studies. We know now that is not true because the Chasen study has come out and is the first study of its kind to try to evaluate the differences between intact and non-intact. It is still true that there are no controlled studies. There's no randomized clinical trial. But if that were the standard, no new and safer abortion procedures could ever be developed. Turning back, Your Honors, to the health issue.
Could I ask you just on one thing? The statute, of course, refers to both feet first and vertex deliveries. How common is the vertex delivery?
Not very common. Not very common, Your Honor. It would occur in circumstances where there's a significant fetal anomaly and some kind of something called ascites or another type of fetal anomaly where there's a distension of the abdomen. But it's very rare.
And given your arguments as for the safety benefits of the DNX, I couldn't understand why they wouldn't also apply to the total delivery of the fetus in a vertex delivery situation.
I'm sorry, I don't know if I understand.
Well, my understanding, the vertex, the skull and head are already outside the mother, and the objection in the feet first is that you want fewer instrument passes as much out. But in that case, it's not the skull itself that is preventing the delivery of the fetus.
Right.
So your arguments about why the DNX is safer in the feet first, wouldn't that apply in a case of total delivery of the fetus as well? In other words, if you want as much of the fetus intact and out as possible, why wait, stop it halfway? Wouldn't the safety argument suggest delivery of the fetus?
Yes, but these are circumstances where the fetus can't be delivered. That's the point, Your Honor, is that the fetus is obstructed. And so the overt act that takes place is...
In the case of a vertex delivery, where is the obstruction?
The obstruction would come from a distension of the abdomen, usually from a significant fetal anomaly, like ascites, this is the serious anomalies, lethal anomalies that I was talking about. And in those circumstances, an overt act would need to be performed that would, in fact, cause fetal demise before the the delivery could be continued.
It seems to me that your argument is that there's always a constitutional right to use what the physician thinks is the safest procedure.
No, Your Honor, I think the Constitution...
I inferred that from your comments.
I don't think so, Your Honor. What the Court held in Stenberg in applying the appropriate medical judgment standard of Casey was that there had to be a substantial body of medical opinion, an objective standard that, in fact, supports the use of that procedure, and that balances concerns against protecting the woman's health with a concern of unfettered discretion, which the Court has rejected.
So then you think there are instances in which the State can require that a procedure be used even if it's not the safest procedure?
I'm sorry.
So then the opposite, the obverse of the proposition I put at first must be true, that there are some instances in which the State can prohibit a procedure even if it is the safest procedure.
That's true, Your Honor, as long as it didn't pose an undue burden on the woman, which is, certainly the circumstance with the D&E, which is 95% of abortions.
Can I just follow up on that?
Stenberg ruling.
I don't understand that. In other words, the fact that it's not the safest procedure does not itself constitute an undue burden? In other words, under Justice Kennedy's hypothetical, he said that the State can prohibit something even if it is the safest procedure. And your answer was so long as it doesn't pose an undue burden. And I was just following up to say that so in some circumstances, prohibiting what you regard as the safest procedure does not itself constitute an undue burden.
No, I understood Justice Kennedy's question to be, could the State prohibit things that are not the safest? And under the Stenberg ruling, although the Court hasn't addressed that question directly, under Stenberg, what the Court has said is the Court can ban procedures only where there's not significant medical authority supporting their use as the safest procedure in some circumstances. So perhaps I misunderstood your question. But the Court has not ever addressed the question, can we ban a procedure that's not the safest? I think the ruling in Stenberg would say, well, there has to be significant medical authority that in some circumstances it is the safest. The alternative argument would be, but if it is the procedure that's used in 95% of the cases or a vast majority of the cases, and banning it would thereby deny women the right to get an abortion and be a substantial obstacle in their path of obtaining an abortion, that would be another reason you couldn't ban it.
Thank you, Ms. Smith.
Thank you, Your Honor.
General Clement, you have 2 minutes remaining.
Thank you, Mr. Chief Justice. Let me make just a couple of points in rebuttal. I'd like to start with Justice Kennedy's question about whether or not there are going to be alternative methods available to end the pregnancy as a practical matter. And the answer to that is there will always be an alternative available as a practical matter. The alternative will always be the D&E procedure, which the district court in this case called the gold standard. And the best evidence of that, Justice Kennedy, is that their own witnesses, like Dr. Chasen, for example, when they set out to perform the DNX procedure, they're only successful about 33% of the time. What happens in the other 67% of the cases is they actually, even though they tried to perform a DNX, will perform a D&E. And so all of the clinics that provide DNX also necessarily provide D&E, because the D&E is what they end up with if they're not able to remove the fetus intact. So in every single case, there are some, the induction procedure has to be done in a hospital, but the DNX and D&E procedures are both equally available in clinics. So no woman, as either a theoretical matter or a practical matter, is going to be denied a safe alternative to end her pregnancy. I wanted to pick up on Justice Souter's question as well. You asked for factual citations in the record on this dispute between us. I think the record is really overwhelmingly in our favor. I'd point you to Dr. Fitzhugh, who's one of the plaintiffs on this side, 135A. He says that he doesn't try for intact delivery in every case because it would necessitate a second round of dilation, a second round of laminaria. So he doesn't do the second round, he gets dismemberment. Dr. Knorr, another one of the plaintiffs, at page 142A, he says the procedure would require greater dilation. And if I could just finish on the citations, Dr. Vibekar, who does dismemberment 100% of the time, 148A, all of these are the petition appendix to the district court opinion. Dr. Cranen explains his procedure at 174A to 177A. Thank you.
Thank you, General. The case is submitted. Justice Kennedy has the opinion in 05380, Gonzales versus Carhart, and 05382, Gonzales versus Planned Parenthood Federation.
These cases, just announced by the Chief Justice, require us to consider the validity of a federal statute that regulates abortion procedures. It has been held invalid in decisions of the Courts of Appeals for the 8th and 9th Circuits. The act is called the Partial Birth Abortion Ban Act of 2003. The principal challenges to the act are, first, that it is void for vagueness; second, that it poses an undue burden because it prohibits the most common second trimester abortion methods; and third, that it has no exception for when the health of the mother is at risk. We know from recitations in the preamble of the act enacted by the Congress that the legislation was in response to the invalidation of a somewhat similar statute enacted by the state of Nebraska. The earlier state statute was invalidated by this court in Stenberg versus Carhart. The federal statute now before us is more specific concerning the instances to which it applies, so it is more precise. A premise central to the joint opinion in Planned Parenthood versus Casey was that the government has a legitimate and substantial interest in promoting fetal life. That premise would be repudiated were we to affirm the judgments of the Courts of Appeals, and so we reverse. As the Court did in Stenberg, it is necessary in the opinion to explain the nature of abortion procedures used in the second trimester or even in later term abortions. And these matters are discussed in the opinion at some length and will not be rehearsed again here. The two principal methods discussed are the dilation and evacuation, or the so-called D&E method, and a variation of that procedure. Now, the variation has different descriptions attached to it. We refer to it in the opinion, as some doctors do, as intact D&E. And the federal statute, the Act, prohibits intact D&E. We conclude the Act is not void for vagueness or overbroad. The Act does not apply unless a doctor has the intent at the outset, both, one, to deliver a fetus to certain anatomical landmarks, and two, to commit an additional overt act other than completion of delivery that kills the partially delivered fetus. These objective standards provide doctors a reasonable opportunity to know what is prohibited. We find the Act does not impose an undue burden by reason of its lack of an exception for protecting women's health. There is documented medical disagreement whether the Act's prohibition would ever impose significant health risks on the woman. The Court has given state and federal legislatures, in other cases, wide discretion to pass legislation in areas where this medical and scientific uncertainty exists. Physicians are not entitled to ignore regulations that direct them to use reasonable alternative procedures. Medical uncertainty does not foreclose the exercise of legislative power in the abortion context any more than it does in other contexts. Our decision in Stenberg was interpreted in the courts of appeal to leave no margin of error for legislatures to act in the face of medical uncertainty. But a zero-tolerance policy would strike down legitimate abortion regulations like the present one if some part of the medical community were disinclined to follow the prescription. And this is too exacting a standard. Now, it is objected that the intact D&E is a little different from standard D&E, so that the Act accomplishes little. The Act's purposes demonstrate to us that the legislature was justified in concluding that the procedure should be prohibited. The Act prescribes a method of abortion in which a fetus is killed just inches before completion of the birth process. By prohibiting that procedure, the Act expresses respect for the dignity of human life. The government also has an interest in regulating the medical profession and protecting its integrity and ethics. A central premise of the plurality opinion in Casey versus Planned Parenthood was that the court's precedents in Roe and cases immediately following Roe had undervalued the state's interest in potential human life. In Casey, the controlling opinion indicated that a law which serves a valid purpose cannot be declared void, even if it has the incidental effect of making it more difficult or more expensive to procure an abortion. The premise that the state from the inception of pregnancy maintains its own regulatory interest in protecting the life of the fetus that may become a child cannot be set at naught by interpreting Casey's requirement of a health exception so it becomes tantamount to allowing a doctor to choose the abortion method he or she might prefer. Respect for human life finds an ultimate expression in the bond of love the mother has for her child. The Act recognizes this reality as well. Whether to have an abortion requires a difficult and painful moral decision. While we find no reliable data to measure the phenomenon, it does seem unexceptionable to conclude that some women come to regret their choice to abort the infant life they once created and sustained. It is self-evident that a mother who comes to regret her choice to abort must struggle with grief more anguished and sorrow more profound when she learns only after the event what once she did not know, that she allowed a doctor to pierce the skull and vacuum the fast-developing brain of her unborn child, the child assuming human form. The state's interest in respect for life is advanced by the dialogue that better informs the political and legal systems, the medical profession, expectant mothers, and society as a whole of the consequences that follow from a decision to elect a late-term abortion. So we hold the Act is not invalid on its face. The considerations we have discussed support our further determination that the facial attacks in these cases should not have been entertained by the courts in the first instance. The proper means to consider exceptions is by as-applied challenge. This is the proper manner to protect the health of the woman if it can be shown that in discrete and well-defined instances a particular condition has or is likely to occur in which the procedure prohibited by the Act must be used. In an as-applied challenge, the nature of the medical risk can be better quantified and balanced than in a facial attack. We reverse the judgment of the Court of Appeals for the Eighth Circuit. We also reverse the judgment of the Court of Appeals for the Ninth Circuit. Justice Thomas has filed a concurring opinion, which Justice Scalia has joined. Justice Ginsburg has filed a dissenting opinion, which Justices Stevens, Souter, and Breyer have joined.
4 members of this Court, Justices Stevens, Souter, Breyer, and I, strongly dissent from today's opinion. 15 years ago, in Planned Parenthood of Southeastern Pennsylvania v. Casey, the Court declared that liberty finds no refuge in a jurisprudence of doubt. There was, the Court said, an imperative need to dispel doubt as to the meaning and reach of the Court's 7-2 judgment nearly 2 decades earlier in Roe v. Wade. One of the clarifications Casey provided concerned the state's unconditional obligation to safeguard a woman's health. At all stages of pregnancy, the Court reconfirmed state regulation of abortion procedures must protect the health of the woman. In reaffirming Roe, the Casey Court described the centrality of the decision whether to bear a child to a woman's dignity and autonomy, her destiny, her conception of her place in society. Challenges to undue restrictions on abortion procedures, the Court comprehended in Casey, do not seek to vindicate some vague or generalized notion of privacy. Rather, they home in on a woman's autonomy to decide for herself her life's course and thus to enjoy equal citizenship stature. In keeping with this understanding of the right to reproductive choice, we have consistently required that laws regulating abortion at any stage of pregnancy and in all cases safeguard not only a woman's existence, her life, but her health as well. Faithful to precedent, unbroken from 1973 until today, the Court held 7 years ago in Stenberg v. Carhart that a state statute banning the very procedure at issue today, intact D&E, was unconstitutional in part because it lacked a health exception. If substantial medical authority maintains that banning a particular abortion procedure could endanger women's health, we held, a health exception cannot be omitted by the legislators. Despite that unambiguous ruling, Congress passed the Partial Birth Abortion Ban Act without an exception for women's health, a ban that would operate nationwide. After lengthy trials and thorough review of volumes of medical evidence, each of the district courts to consider the statute found that it was unconstitutional for the same reason. Significant medical authority identified intact D&E as the safest procedure for some women. In an alarming decision, the Court today reverses the judgments of other federal courts, decisions unanimously and uniformly made. Today's decision refuses to take Casey and Stenberg seriously. The Court's opinion tolerates, indeed it applauds, federal intervention to ban nationwide a procedure found necessary and proper in certain cases by the American College of Obstetricians and Gynecologists. For the first time since Roe, the Court blesses a prohibition with no exception protecting a woman's health. The Court asserts that its ruling furthers the government's interest in promoting fetal life. But the Act scarcely furthers that interest, for it targets only a method of abortion. The woman may abort the fetus so long as her doctor uses another method, one her doctor judges less safe for her. The Court further pretends that its decision protects women. Women might come to regret their physician-counseled choice of an intact D&E and suffer from severe depression and loss of esteem, the Court worries. Notably, the solution the Court approves is not to require doctors to inform women adequately of the different procedures they might choose and the risks each entails. Instead, the Court shields the woman by denying her any choice in the matter. This way of protecting women recalls ancient notions about women's place in society and under the Constitution, ideas that have long since been discredited. If there is anything at all redemptive about today's opinion, it is that the Court is not willing to foreclose entirely a challenge to the constitutionality of the Act. But the as-applied challenges in discrete cases that the Court would allow put women's health in danger and place doctors in an untenable position. Even if courts were able slowly to carve out health exceptions for discrete and well-defined instances through hard-fought, protracted piecemeal litigation, women whose circumstances have not been anticipated by prior litigation could well remain unprotected. In treating those women, physicians would risk criminal prosecution, conviction, and imprisonment if they exercise their best judgment as to the safest medical procedure for their patients. The Court is thus gravely mistaken to conclude that narrow, as-applied challenges are the proper manner to protect the health of the woman. As the Court wrote in Casey, overruling Roe's central holding would not only reach an unjustifiable result under principles of stare decisis, it would seriously weaken the Court's capacity to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. Although today's opinion does not go so far as to discard Roe or Casey, the Court, differently composed than it was when we last considered a restrictive abortion regulation, is hardly faithful to Casey's invocation of the rule of law and the principles of stare decisis. In candor, the Partial Birth Abortion Ban Act and the Court's defense of it cannot be understood as anything other than an effort to chip away at a right declared again and again by this Court and with increasing comprehension of its centrality to women's lives. A decision of the character the Court makes today should not have staying power.
We'll hear argument this morning in Case 15-274, Whole Women's Health versus Hellerstedt. Ms. Toty?
Mr. Chief Justice, and may it please the Court, the Texas requirements undermine the careful balance struck in Casey between states' legitimate interests in regulating abortion and women's fundamental liberty to make personal decisions about their pregnancies. They are unnecessary health regulations that create substantial obstacles to abortion access.
Ms. Toty, there is a preliminary question. Would you address that this claim is precluded? And let's take first the claim that was in the prior litigation. Well, let's assume that they're separate claims. Well, let's take the admitting privileges. That was argued and decided. Why isn't it precluded?
Your Honor, it's not precluded because material facts relevant to the claim developed subsequent to entry of judgment in the Abbott case.
But you could have amended, you could have asked for supplemental briefing. I mean, the new action is filed 6 days after the Supreme Court issues its decision in this case. You could have asked for supplemental briefing.
In Abbott, the plaintiffs brought the new facts to the attention of the Court of Appeals. The Court of Appeals said that it would only consider evidence in the trial record in rendering its decision, and it held that the evidence in the trial record was speculative, that there wasn't a sufficient basis to conclude that any doctor would be unable to obtain admitting privileges or that any clinic would be forced to close as a result of the admitting privileges requirement.
But you made allegations concerning those same claims. I mean, is your argument that when you have allegations on a facial challenge and the facial challenge is resolved against you, that all you have to do is come up with new evidence and then you can start over again?
No, Your Honor. The evidence must be material and it must be newly developed. So newly discovered evidence wouldn't be sufficient. If it was evidence that was available at the time of the first suit, but the plaintiffs merely hadn't discovered the evidence or didn't bring it forward, that wouldn't provide the basis for a subsequent suit. But evidence that develops after judgment in the first suit that is material to the claims does provide sufficient basis for a second
And what's
suit.
this key new evidence?
The evidence is the clinic closures that resulted from enforcement, actual enforcement of the admitting privileges requirement. So the first suit was a pre-enforcement challenge. It was before the law took effect, and the court concluded that there was not sufficient evidence that any doctor would actually be unable to obtain admitting privileges or that any clinic would actually close.
Well, there's very little specific evidence in the record in this case with respect to why any particular clinic closed. Basically, your argument is that the law took effect, and after that point, there was a decrease in the number of clinics. So suppose you win here, and the state then examines what happened in each of these clinics and comes up with evidence showing that in quite a few instances the closure was due to other factors. And so then could they take the position, well, the decision of this court holding that the law is facially unconstitutional is not binding on us by res judicata, and so you would have to sue them again and they would be able to make the same argument you're making now. Is that correct?
No, Your Honor.
Well, what's the difference?
Well, first of all, the state had an opportunity to bring forward evidence in this case about the reasons why.
Was that their burden?
No, Your Honor, not in the first instance, but the plaintiffs came forward with evidence, and the state did not offer anything to rebut the evidence, which was more than sufficient to support the district court's finding that HB2 was the cause of the clinic closures.
What evidence is that?
There are a couple of things, Your Honor. Prior to HB2, in the 5 years prior to HB2, the number of clinics in the state remained fairly stable. In any given year, there may have been a 1 to 2 clinic variance. Following the enactment of HB2, more than 20 clinics closed within a very short period of time. The timing of the closures alone.
I'm sorry. Yeah. What is the evidence in the record that the closures are related to the legislation?
The timing is part of the evidence, Your Honor, and the testimony of the plaintiffs about the reasons why their clinics closed. So that the plaintiffs testified that clinics closed in anticipation of enforcement in some cases, and in some cases because of actual enforcement of the requirements.
Can we go on to the second piece, that is the ambulatory surgical centers? That was not part of the last case, and your position on that is that that is a discrete claim, so it's not barred by claim preclusion. Is that your position?
Yes, that's correct. And the claims against the ASC requirement weren't ripe at the time that the Abbott case was filed because the final implementing regulations for that statutory requirement hadn't yet been adopted.
Well, certainly in the federal system, and I assume in many states as well, regulations sometimes take years to promulgate. I don't know of any rule that says we have to wait for regulations to be promulgated unless it's something unanticipated. And the key objections you're making were clear in the statute anyway.
I would disagree that the extent of the burden that the law would impose was clear on the face of the statute until those implementing regulations were adopted, and the statute provided a deadline for the adoption of those regulations. Until they were adopted, the plaintiffs couldn't have known whether waivers or grandfathering would have been permitted. And if waivers or grandfathering were permitted, as they have been in every other ASC requirement that's been adopted for abortion providers, the burdens would have been much less, and the plaintiffs would have first attempted to get licensed and seek appropriate waivers before filing their suit.
So you think you can separately challenge the admitting privilege provision and the ASC provision?
Yes, Your Honor, because those —
So if you can separately challenge them, if you challenge just the admitting privileges provision, how would you factor in — presumably you would have to assume that the ASC provision was not under challenge. So in assessing the burden, you would look at just the admission privilege, and vice versa. If you're challenging just the ASC separately, you'd have to assume you'd assess the burden solely caused by that provision. It seems to me the separation of the two provisions would make your case much harder.
I would disagree with that, Your Honor, because each of these requirements is extremely burdensome on its own. The admitting privileges requirement, which is partially in effect, has been responsible for the closure of nearly half of all the abortion facilities in Texas to date. And the ASC requirement, if it took effect, the respondents have stipulated that it would close any remaining licensed abortion facility that was able to comply with the admitting privileges requirement. So independently, each requirement is extremely burdensome, and collectively, the 1-2 punch of these requirements would be responsible for the closure of nearly 30.
What I think the Chief Justice asked, I don't want to take words out of his mouth, but I think the question was, one of the two lines that's been asked, is that in the district opinion at page 7, the district court has said that if the ASC regulation goes into effect, there will be one facility left in Austin, 2 in Dallas, 1 in Fort Worth, 2 in Houston, and either 1 or 2 in San Antonio. And before that, he said that the enforcement of the appointment privileges, the privileges of admission, would reduce the number from 20 down to about — from 40 down to about 20. Now, I think the question was, what evidence did those findings rest upon? Because you've heard the other side, I think, say there is no such evidence, or the Court of Appeals said there is no such evidence. So can you give a brief account or page numbers that will show that those findings, the diminishment of the number from about 40 to about 8, which is what the district court found, rested upon some evidence? What was that evidence?
Yes, Your Honor. So initially, 20 clinics closed in the wake of HB2. 8 closed prior to initial enforcement of the admitting privileges requirement, and 11 closed on the day that the admitting privileges requirement first took effect. Respondents quibble with the evidence concerning the first 8. Even if we — and there is a basis in the record for the district court to infer that those 8 closed for the same reasons as all the others. But even if we took those —
Sorry to interrupt you. Where in the record is that evidence?
Your Honor, I can provide specific pin sites during my rebuttal, but the evidence is in the plaintiff's testimony about the reasons why their clinics closed. Each of the plaintiffs testified that their clinics closed either in anticipation of enforcement of these requirements, knowing that the clinic would not be able to continue operating once the requirements took effect, and as a result of that, either they needed to move resources to remaining clinics to ensure that some clinics would continue to operate in the state.
What they say, could you give us any record references later or on rebuttal?
Yes.
As to how many of the total that you claim closed, do you have direct evidence about the reason for the closure?
Well, 11 of them, Your Honor, closed on the day that the admitting privileges took effect.
Yeah, and as to how many are you claiming total closed as a result of the law?
To date, roughly 20 clinics have.
And of the 20, as to how many do you have direct evidence?
Approximately 12, Your Honor, direct evidence.
Because if you go through this, now we're not talking about a huge number of facilities. I really don't understand why you could not have put in evidence about each particular clinic and to show why the clinic closed. And as to some of them, there's information that they closed for reasons that have nothing to do with this law. Now, maybe when you take out all of those, there still would be a substantial number and enough to make your case. But I don't understand why you didn't put in direct evidence. I mean, I could give you examples. Planned Parenthood Center for Choice, Bryan, Texas. Is that one of the ones you're talking about?
Yes, Your Honor.
Okay. There's a news report, Planned Parenthood and the Huffington Post reported that this was closed as a result of the 2011 Texas Women's Health Program bill, which cut funding for family planning services. It's not the law that we're talking about here.
Well, Your Honor, that evidence is not in the record.
Well, I understand that, and you put quite a bit of evidence that's not in the record in your brief. But my point is, why is there not direct evidence about particular clinics?
You said you had direct evidence for 12 clinics, and you were going to supply us with those record citations later. That's what I understood you to say.
Yes, Your Honor, absolutely. But I think what's important to keep in mind here is—
Ms. Toti, could I just make sure I understand it? Because you said 11 were closed on the day that the admitting privileges requirement took effect. Is that correct?
That's correct.
And is it right that in the 2-week period that the ASC requirement was in effect, that over a dozen facilities shut their doors, and then when that was stayed, when that was lifted, they reopened again immediately? Is that right?
That is correct, Your Honor. And
it's almost like a perfect controlled experiment as to the effect of the law, isn't it? It's like you put the law into effect, 12 clinics closed, you take the law out of effect, they reopen.
That's absolutely correct. And as the state had stipulated, that's exactly what the state stipulated would happen. And that stipulation is certainly direct evidence of the impact of the ASC requirement.
The state, I think, is going to talk about the capacity of the remaining clinics. Would it be A, proper, and B, helpful for this court to remand for further findings on clinic capacity?
I don't think that's necessary, Your Honor. I think there's sufficient evidence in the record that we have to support the district court's finding that the remaining clinics, which would number fewer than 10, don't have capacity to meet the statewide demand.
There have been some changes, like a major clinic, I don't quite know the adjective they use for it, in San Antonio. Suppose there were evidence that there was a capacity and a capability to build these kinds of clinics. Would that be of importance? And then it would show that this law has an effect, and a beneficial effect so far as the legislature is concerned.
If the court had any doubts about the capacity of the remaining clinics, a remand would certainly provide the petitioners with the opportunity to supplement the evidence already in the record. But the evidence in the record shows that supports the district court's finding that because the ASC requirements, the costs of it are so prohibitive, it will deter new clinics from opening to take the place of the ones that closed.
Is it correct that the number of ambulatory surgical centers performing abortion has increased by 50% since this law went into effect?
Since this law has taken effect, 3 new ambulatory surgery centers have opened, and there was evidence about that at the trial, and the trial court knew that was going to happen. The trial court took that into account in making its finding. But nevertheless, there was substantial evidence, including Texas's experience in 2003 following enactment of the ASC law for later abortions, for post-16-week abortions, that shows that the market never adjusted, and the rate at which those procedures occurred in Texas was drastically diminished following
well,
enactment of the law.
One quick question about capacity. I don't want to take your rebuttal time, but your co-counsel is also litigating a case like this in Louisiana, and in that case, the plaintiffs were able to put in evidence about the exact number of abortions that were performed in all of the facilities. Why could that not have been done here? Why wasn't it done here?
Well, so I see that I'm getting into my rebuttal time, Your Honor, but there is evidence in the record about the number of abortions that were performed on an annual basis, the geographic distribution of those abortions. Texas collects those statistics, and those statistics are part of the record in this case.
We have absorbed so much of your time with the threshold question. Perhaps you can, since you have some time to address the merits.
Why don't you take an extra 5 minutes, and we'll be sure to afford you rebuttal time after that.
Thank you, Mr. Chief Justice. So, fundamentally, these laws impose heavy burdens on abortion access that are not medically justified. And for that reason, they impose an undue burden on the right to abortion.
Do you think there's a rational basis for the law based on the benefits that the legislature saw?
I do not, Your Honor, because...
Well, I thought you expressly did not challenge the law as lacking a rational basis.
We did not preserve our rational basis claim. The district court denied that claim, and we haven't preserved it here. Here we're focusing on the undue burden, but we wouldn't concede that the law has a rational basis because, in fact, it undermines...
We have to assume it does, since you're not raising that challenge, don't we? Because the law actually undermines the state's interest in health rather than advancing it by causing an increase in later abortions and self-induced abortions, we wouldn't concede that it's rationally related to the state's interest in health. But
you said even if the test is undue burden, not rational basis.
That's correct, Your Honor. And in order to determine whether a law imposes an undue burden on the abortion right, we must first consider the magnitude of the burden that it imposes and then compare that burden to what the law is intended to achieve.
How is that illogical? I mean, the question is whether there's an undue burden or a substantial obstacle. What difference does it make what the purpose behind the law is in assessing whether the burden is substantial or undue? It seems once you get past the assumption that the law has a rational basis and you haven't challenged that, then you look at the burden or the obstacle. And the purpose that the law is directed to, I would think, doesn't make a difference. It's either a substantial obstacle or an undue burden, or it's not.
In order to determine whether a burden is undue, Your Honor, we have to consider what the burden is in relation to. In Casey, for example, in upholding the informed consent requirements, the court first looked to the state interest that was being served by those requirements, in that case, the state's interest in potential life, and concluded that the requirements were reasonably designed to serve that purpose by making the abortion decision more informed. And
I thought the undue burden and substantial obstacle went to whether it was undue in light of the woman's right to exercise her right to an abortion, not with respect to the state interest that's asserted.
Well, Your Honor, it's both. Casey sought to balance the state's legitimate interest in regulating abortion with the woman's fundamental right, with her liberty to access the procedure, and it concluded that the state couldn't impose unwarranted burdens. So where the state had a good reason to impose a restriction, and that restriction didn't impose burdens that were undue, then the restriction could stand. But where a restriction is unreasonable, or in the language of Casey, medically unnecessary, and it's going to impose burdens on access to abortion, then that restriction cannot be sustained under the 14th Amendment.
Can I walk through the burden a moment? there's two types of early abortions at play here. The medical abortion that doesn't involve any hospital procedure. A doctor prescribes 2 pills, and the women take the pills at home, correct?
Under Texas law, she must take them at the facility, but that is otherwise correct.
I'm sorry, what? She has to come back 2 separate days to take them?
That's correct, yes.
All right. So now from when she could take it at home, it's now she has to travel 200 miles or pay for a hotel to get those 2 days of treatment.
That's correct, Your Honor.
All right. Let me ask you something about that 2-day wait, okay, or that travel time. How many other states and how many other recognized medical people have testified or shown that there is any benefit from taking pills at the facility as opposed to taking the pills at home, as was the case?
There's absolutely no testimony in the record and no evidence, in any of the amicus briefs that there's a medical benefit to having a medication abortion at a multi-million-dollar surgical facility. The American Medical Association and every other mainstream leading medical association to consider these requirements has concluded that they are not medically justified for a variety of reasons, including that they impose these onerous burdens on medical abortion, which is the earliest form of abortion, and that these burdens are also imposed on early surgical abortions, procedures prior to 16 weeks, and as a result, women are going to be delayed later in pregnancy. And there's evidence in the record that following implementation of the admitting privileges requirement in the 6-month period following, there was an increase in both the number and the proportion of abortions being performed in the second trimester. So by delaying women's access to abortion, these requirements are actually increasing the risks that women face.
If the Chief may permit me to finish my two-part question.
Sure.
The second is the DNC. This dilation in, what's it called, dilation in?
Curettage.
Curettage. What is the risk factor for a DNC related to abortion and a non-abortion DNC? DNCs are performed in offices for lots of other conditions besides abortion. Is there any evidence in the record that shows that there's any medical difference in the two in the procedures that would necessitate an abortion being in an ACS or not? Are abortions more risky than the regular DNC?
No, Your Honor. The evidence in the record shows that the procedures are virtually identical, particularly when DNC is performed to complete a spontaneous miscarriage. So when a woman miscarries and then follows up with her doctor, the doctor will typically perform a DNC, and that's virtually identical to an abortion, but it's not subject to the requirements of HB2.
So your point that I'm taking is that the two main health reasons show that this law was targeted at abortion only.
That's absolutely correct. Yes, Your Honor.
Thank you, counsel.
I'm sorry. Is there any other medical condition, like taking the pills, that are required to be done in hospital, not as a prelude to a procedure in hospital, but an independent, I know there are cancer treatments by pills now. How many of those are required to be done in front of the doctor?
None, Your Honor. There are no other medication requirements and no other outpatient procedures that are required by law to be performed in an ASC.
Thank you, counsel. General Verrilli?
Mr. Chief Justice, and may it please the Court, the effects of the Texas law at issue in this case are much more extreme than those of any abortion law that this Court has considered since Casey. This law closes most abortion facilities in the state, puts extreme stress on the few facilities that remain open, and exponentially increases the obstacles confronting women who seek abortions in the state. And it does all of that on the basis of a medical justification that cannot withstand any meaningful scrutiny, that the American Medical Association has told you is groundless, and that the district court found will actually operate in practice to increase health risks to women and not decrease.
Is this true of every provision of the ASC law?
No, I don't think it is true about every provision in the regulations, Justice Alito.
Well, not the regulations. Yes, in the regulations. Yeah. Every single provision. Then why was the whole thing held to be unconstitutional?
So I agree with the premise of Your Honor's question. There are some parts of the regulation that I think operating alone wouldn't have the substantial obstacle effect. In fact, some parts of the regulation actually restate and reauthorize regulations that were already on the books. And so I suppose one could say that with respect to that set of regulations that the district court could have severed them under the severability clause. One could say that. Of course, they're already in the pre-existing regulations.
But there are things that go. I haven't checked everything, compared the prior abortion clinic licensing law against the ASC requirements. But there are some where there's an increase in what's required. It seems pretty reasonable. Under the old law, there had to be a nurse, but not necessarily a registered nurse. Under the new law, there has to be a registered nurse who has a CPR certificate. So you think that's unreasonable to say that there has to be a registered nurse who knows how to do CPR?
So I don't want to state an opinion one way or the other about that, but I do want to. But I think getting to the point of Your Honor's question, I think the problem the district court confronted here, and I think the reason the district court acted reasonably, despite the presence of the severability clause, is the severability clause provides an instruction that every provision, every clause, every word, every application to every individual should be severed. And the problem is a problem of the kind that the court noted, I think, in the IOT case. For a court trying to apply that, the court's got to go in and decide which collection of the many, many requirements there ought to stand and which shouldn't. And it's going to be invading the state's regulatory power.
It's work. But maybe the district court should have done that work. I mean, I read through this, and I was surprised. I read through these regulations. I was surprised by how many are completely innocuous. And many of them have nothing to do — they have to do with basic safety. They don't even have anything to do particular with abortion. So the entrances to the clinic have to be at grade level. You have to have an elevator. The corridors have to be wide enough so that you could bring in a stretcher if somebody has to be taken to the hospital. And things of that nature. I don't know why things couldn't have been severed out if there were some that were.
I think some could have, and if the court believes a remand is appropriate for the remedy to be more carefully tailored in the way that the court did in the IOT case, we think that would be appropriate. But we do think that the basic point remains that this is a substantial obstacle. And I would like to address 2 points that arose during petitioner's argument. First, closures, and then capacity. With respect to closures, here's what I think the record will show you. Taking the ASC requirement first, there's a stipulation, JA 183, that all clinics that weren't already closed as a result of the admitting privilege requirement would not be able to meet the ASC requirements, and therefore would have to cease operations. Justice Kagan noted they did cease operation during the period in which the law wasn't stayed. There's evidence in the record with respect to the 7 clinics that are operated by Whole Women's Health that it was physically impossible to meet the ASC construction requirements because they couldn't fit on the real estate footprint that they had. They couldn't meet them. There's expert testimony in the record from Dr. Lane Farrar, the economist, that the cost of retrofitting these clinics to meet the requirements would be between $1.6 and $2.3 million, which would be prohibitive, that the cost of building a new facility would be at least $3.5 million, which would be prohibitive, and that the additional operating cost of an ASC would be between $600,000 and $1 million a year more. So I think with respect to those, there's ample evidence. With respect to the admitting privileges requirement, we know that 11 of the 20 clinics that closed between the date when the law was enacted and the effective date of the admitting privileges requirement closed on the date that requirement became effective. It seems to me the only reasonable inference you can draw with respect to those 11 is that the law caused the closure. With respect to the others, I don't think there's evidence with respect to each one, but with respect to several, there is evidence that they closed in advance of the effective date because they were otherwise going to have to pay a licensing fee to stay open for another year, which they knew they were not, and they knew they weren't going to be able to stay open, and they didn't want to flush the money away. So I think there's ample evidence in the record with respect to causation. Now, with respect to capacity, I really think this is key because I do think this is the locus of the substantial obstacle problem here. With respect to capacity, before this law took effect, there were approximately 65 to 70,000 abortions a year annually. The ASC clinics that will be able to remain open, the ASC facilities that will be able to remain open, performed about 14,000 a year. That's what the record tells you. It's Dr. Grossman's expert testimony. It's in the JA from pages 225 to 259.
About 20%.
20%. So they'd have to increase 4 or 5-fold in a very short period of time against the backdrop of having to meet the problems that the admitting privileges requirement causes. Now, I understand that the Fifth Circuit said that was ipsy-dixit, but with all due respect, that's not binding on you, and it's just wrong. And if you look at the expert testimony at the JA pages I identified, you'll see that what Dr. Grossman said first was something that is just common sense, that these these facilities aren't going to be able to increase by 4 or 5 times. And second, he didn't just rely on common sense. He looked at the period of time between when the admitting privileges requirement resulted in the closure of 20 clinics. He looked at that period of time, and he studied the number of abortions that occurred at the remaining ASC facilities during that period of time. And one would expect, given that half the facilities in the state closed, that there'd be a substantial increase.
Do you think the district court would have had discretion, the district court having substantial equitable powers that appellate courts don't, to say, we're going to stay this requirement for 2.5, 3 years to see if the capacity problem can be cured? Could a district judge do that?
You know, I apologize, Justice Kennedy. I haven't given that question thought, and I'm loath to opine on that without having given it thought. But I do think that
district judges often think they can do anything.
Right. But I do think, as I said, with respect to the capacity problem, the key thing here is that when in addition to these ASC clinics not providing more abortions, once half the clinics in the state closed, you had, and this is again in Dr. Grossman's testimony, significant increases in the overall number of abortions, particularly in the parts of the state that were far away from the major cities. The northern.
There is no evidence. There's no evidence of the actual capacity of these clinics. And why was that not put in? Particularly since, if we look at the Louisiana case, we can see that it's very possible to put it in. And some of the numbers there are quite amazing. There's a doctor there performed 3,000 abortions in a year. So we don't really know what the capacity of these ASC clinics are.
Well, I think you have expert testimony in that regard.
Yeah, but what is it based on? It's not based on any hard statistics.
Well, it is. It's common sense that you can't.
Common sense,
but it's beyond that. As I said, Justice Alito, they studied the period of time in which half the clinics in the state were closed, and you would expect if those clinics, if the additional ASCs can handle the capacity, they would have, and they didn't.
He said that the percentage of abortions at the ASCs went down by 4.4%, and there was an increased demand for abortion. But there's no statistic showing that there actually was an increased demand for abortion in Texas.
I thought that the Grossman affidavit, which I have, I grant you, it's going on the briefs, but it said affidavit page 9, table 2, says that the number of abortions that are on average performed annually at the remaining clinics is 2,000. So let's multiply by 2 and you get 16. Let's multiply by 3, you get 24. There were 70,000 approximately women who needed these procedures. So I had taken that. Is that accurate?
Yes.
Okay.
In the short time I have remaining, I'd like to finish with one point, if I could. I think ultimately the question before you is whether the right here is going to retain real substance and whether the balance struck in Casey still holds. If that right still does retain real substance, then this law cannot stand. The burdens it imposes, the obstacles, are far beyond anything that this Court has countenanced, and the justification for it is far weaker than anything that this Court has countenanced. It is an undue burden. It is the definition of an undue burden. And, Mr. Chief Justice, in response to your question, undue means excessive or unwarranted. Could be excessive or unwarranted as compared to the obstacle it imposes, certainly, but also as compared to its need.
I would have thought
Casey and Gonzales also said substantial obstacle. And I would have thought that's something you could look at in an objective manner. And I have to say I don't understand why you're arguing the opposite. I think whether it's a obstacle or a burden would exist without regard to the strength of the state interest. The strength of the state interest, it would seem to me, is evaluated on whatever test there is with respect to that legislation, and then you look at what the impact was.
Well, I think it's actually in the interest of government to look at it the way that we're suggesting it ought to be looked at, and if you don't, I take a minute to explain why. And I think, Mr. Chief Justice, that is because, it is one thing to say that you're going to impose a requirement that does work as much as to be the kind of obstacle that these requirements do, when you have a justification that's frankly flimsy and the American Medical Association has told you is groundless. But if the government were able to come in, if it were us or if it were state, were able to come in and say, well, actually, this requirement is going to make a difference in saving hundreds of lives, that might be a burden that you would think would be acceptable given the medical benefit. That's why we think that the test that makes sense, the best understanding of undue burden, the understanding of undue burden that works best for the government is the one we're suggesting. But I think whichever way you look at that, whether you look at it our way, whether you look at it as two separate inquiries, this law, HB 2, can't pass it for the reasons I said. And I think, therefore, that if you do find that this law is upheld, what you will be saying is that this right really only exists in theory and not in fact going forward, and that the commitments that this Court made in Casey will not have been kept. Thank you.
Thank you, counsel. Mr. Keller?
Thank you, Mr. Chief
I suppose
Justice.
I should, before you say, we'll afford you an additional 8 minutes. I think that's roughly.
An extra thank you, Mr. Chief Justice, and may it please the Court. Res judicata bars the facial challenges. In any event, Texas acted to improve abortion safety, and Planned Parenthood provides this increased standard of care and has opened new ASCs. Abortion is legal and accessible in Texas. All the Texas metropolitan areas that have abortion clinics today will have open clinics if the Court affirms, and that includes the 6 most populous areas of Texas.
How many women are located over 100 miles from the nearest clinic?
Justice Ginsburg, JA 242 provides that 25% of Texas women of reproductive age are not within 100 miles of an ASC, but that would not include McAllen that got as-applied relief, and it would not include El Paso, where the Santa Teresa, New Mexico facility is.
Yeah, that's odd that you point to the New Mexico facility. New Mexico doesn't have any surgical ASC requirement, and it doesn't have any admitting requirement. So if your argument is right, then New Mexico is not an available way out for Texas, because Texas says to protect our women, we need these things. But send them off to New Mexico, where they don't get either. No admitting privileges, no ASC. And that's perfectly all right. Well, if that's all right for the women in the El Paso area, why isn't it right for the rest of the women in Texas?
The policy set by Texas is that the standard of care for abortion clinics should rise to the level of ASCs for clinics and admitting privileges for doctors. Texas obviously can't tell New Mexico how to regulate, but the substantial obstacle inquiry examines whether there is the ability to make the ultimate decision or elect the procedure. And when
then why should it count those clinics?
Well, here, the evidence in the record showed that this particular clinic was 1 mile across the border, that was still in the El Paso metroplex, and women in El Paso often use that facility to obtain abortions. So that would go into the contextual analysis of this particular as-applied challenge. This doesn't go to the facial challenge, but the as-applied challenge on whether women in El Paso do have access to abortion. In any event, over 90% of Texas women of reproductive age live within 150 miles of an open clinic
Mr.
as
Keller,
of today.
The statistics that I gleaned from the record were that 900,000 women live further than 150 miles from a provider, 750,000, 750,000, further than 200 miles. Now, that's as compared to just in 2012, where fewer than 100,000 lived over 150 miles, and only 10,000 lived more than 200 miles away. So we're going from like 10,000 to 750,000 living more than 200 miles away?
Well, Justice Kagan, first of all, I believe the statistics at J242, which is their expert testimony, would not account for McAllen or El Paso. But in looking at the fraction of women affected, and that would be the facial challenge standard, that at a minimum, a large fraction of cases there would have to be invalidity even if there wasn't an undue burden. The travel distance of, even in Casey, the district court found over 40% of Pennsylvania women were going to have to travel at least 1 hour, sometimes over 3 hours, and there was a 24-hour waiting period. Texas reduces that waiting period to 2 hours for traveling over 100 miles. And in Casey, that was not a facial substantial obstacle. Here, that relevant fraction is lower, and under Casey, then the facial challenge would not succeed. And when petitioners have a heavy burden and they haven't shown any capacity evidence.
When there's a need, meaning where are you taking into account in the undue burden analysis the value of the need being imposed? Meaning, even if I grant you that in some circumstances travel time is necessary because you just can't get any kind of abortion clinic to go into a particular area, so you might have to impose a burden that might be undue in other circumstances. Where do we evaluate the benefit of this burden? What's the need? Your brief seemed to be telling us that there's no role for the court to judge whether there's really a health benefit to what you're doing.
Well, there would be three elements of the doctrine. There's the rational basis test.
I'm not talking about the doctrine. I'm talking about the question I asked, which is, according to you, the slightest health improvement is enough to impose on hundreds of thousands of women, even assuming I accept your argument, which I don't necessarily because it's being challenged. But the slightest benefit is enough to burden the lives of 1 million women. That's your point?
Well, and what Casey said is the substantial obstacle test examines access to abortion. Now, if a law had no health benefits, presumably it would be irrational. But even their expert, and this is at JA 256 and 258, acknowledged that some doctors do believe that there are benefits for the ASC and admitting privileges requirement.
What is the benefit of the medical, the 2 pills that you take? What is the benefit of having an ambulatory surgical center to take 2 pills when there's no surgical procedure at all involved?
2 responses, Justice Ginsburg. First, the complication rates are greater, and when there's a complication rate from a drug-induced abortion, then a surgical abortion is needed as a follow-up. In the first lawsuit—
On the complication, that complication is likely to arise near the woman's home, much more likely to arise near her home, which the 30-mile has nothing to do with.
Well, first of all, the 2 travel distances, that was about the drug protocol. That's a different part of the bill. That was in petitioner's first lawsuit, and they have not raised any challenge to that in this lawsuit. In any event,
I'm not talking about the prior lawsuit. I'm talking about this lawsuit. You need to have access to a hospital within 30 miles. 30 miles of what? 30 miles of the surgical center when the woman lives at a much greater distance, and if she's going to go to any hospital, it will be in her local community, not near the surgical center.
Of course, most abortions are surgical abortions in the state.
Well, I'm asking you just about the medical.
That's right. And also—
I can't imagine. What is the benefit of having a woman take those pills in an ambulatory surgical center when there is no surgery involved?
Well, there would be surgery and a complication, and all abortion clinics in Texas perform surgical abortions, and that's why petitioners probably didn't defend that aspect of the judgment.
If there's a complication, it is not going to occur on the spot. I mean, you would have to concede that in the case of the medical abortion, the complication generally arises after the woman is back at home, and then the nearest hospital has nothing to do with the surgical center.
Although when the significant majority of women are living within 50 miles of a clinic. In most situations, they are going to be in that facility, and it is beneficial to have continuity of care, to check for clinical competence, to prevent miscommunication and patient abandonment, to have the admitting privileges requirement. In any event, the facial challenge is certainly barred by res judicata. It was litigated.
Before you get is an underlying premise of your argument, Mr. Keller, and of the State's position, that the thrust, the impetus, the effect of this law is to increase surgical abortions as distinct from medical abortions, and that is within the State's authority to do? Because my reading indicated that medical abortions are up nationwide but down significantly in Texas.
Well, it would certainly be permissible to regulate both surgical and drug-induced abortions. And in drug-induced abortions, since there are greater complications, in the first lawsuit, the Fifth Circuit noted expert testimony that was a 6% rate.
But I thought an underlying theme, or at least an underlying factual demonstration, is that this law has really increased the number of surgical procedures as opposed to medical procedures, and that this may not be medically wise.
Yeah. Insofar as
you might say that this is within the authority of the State to do, but
given the higher,
and I want to know what your position is on that.
And Justice Kennedy, given the greater complication rates from drug-induced abortions, the legislature would be permitted to act in that way. But in any event, petitioners have not challenged that particular part of the district court's holding that gave them as-applied relief on the drug-induced abortion part. In the Fifth Circuit, they haven't raised that. What they're trying to do on the effects prong is say that the remaining clinics will lack capacity, but the Fifth Circuit correctly noted that there's no capacity evidence in the record. They didn't even try to take discovery from the non-petitioner clinics. And indeed, Grossman's ipsa dixit was in fact ipsa dixit. What he did is he looked at the number of abortions and percentage that were being performed, and a year earlier, ASCs had actually performed more abortions. And so the inference that they were at capacity cannot be drawn.
What evidence would you have put in on the capacity issue if you had been afforded that opportunity?
Well,
evidence that would rebut the statistically significant showing on the other side about capacity, and also the circumstantial evidence about the timing of the closures.
Well, this is not in the record, but in petitioner's first lawsuit, this is Exhibit K to their application to vacate the stay in this court in the first lawsuit, the Abbott litigation. They went clinic by clinic in a chart, excuse me, and they tried to estimate the number of abortions that could be performed in those facilities. The district court didn't even make a fact-finding there. But the Houston Planned Parenthood ASC, they estimated could perform 9,000 abortions annually. 9,000. That's 175 a week is what their chart says.
Before the act?
Well, yes, because the Houston Planned Parenthood operates 5 of the 9 ASCs. Planned Parenthood is not in this lawsuit. They were in the first lawsuit. They have complied with the law. They have doctors with admitting privileges, and they have facilities in each of the 5 most populous Texas cities. And so if one ASC can perform 9,000 abortions annually, and there are going to be at least 8 other ASCs in Texas, plus the 10th facility, the McAllen facility that obtained as-applied relief, it does not stretch credulity to believe that those remaining facilities would suffice to meet demand for abortion.
And you asked to put in this evidence, and then the court said, no, we will not let you put in the evidence.
We didn't put in the evidence because petitioners bore the burden.
I said, did you ask to put in this evidence?
No.
No. Thank you very much. Okay. I'd like to go back to the question that Justice Ginsburg was asking, which is about what is the benefit of this procedure. There are 2 laws. I'm focusing on the first law. The first law says that a doctor at the abortion clinic must have admitting privileges in a hospital 30 miles within that nearby, right?
Correct.
Okay. Prior to that law, the law was that the clinic had to have a working arrangement to transfer such a patient. Correct? I'm just reading it from this.
That's correct.
Okay. So I want to know, go back in time to the period before the new law was passed. Where in the record will I find evidence of women who had complications who could not get to a hospital, even though there was a working arrangement for admission? But now they could get to a hospital because the doctor himself has to have admitting privileges. Which were the women? On what page? Does it tell me their names, what the complications were, and why that happened?
Justice Breyer, that is not in the record.
Fine. So Judge Posner then seems to be correct when he says he could find in the entire nation, in his opinion, only one arguable example of such a thing, and he's not certain that even that one is correct. So what is the benefit to the woman of a procedure that is going to cure a problem of which there is not one single instance in the nation, though perhaps there is one, but not in Texas?
Justice Breyer, the National Abortion Federation previously recommended that women use abortion doctors.
I didn't ask that. I'm sure there are people who had all kinds of reasons that would like to have this and so forth. And I'm just asking you where we have a judicial duty to say whether this is an undue burden upon the woman who wants the abortion. There are two parts. Is she burdened? And what is the benefit? And now on the first one, I've asked you to give a single example of an instance where there is a benefit, and you say, I think quite honestly, there is no such burden. So let's turn to the second. The second one, according to the amicus briefs here, which I guess I could validate, that even without the surgical center, leave it out, there are risks, quite correct. Those risks are roughly the same as the risk that you have in a dentist office when you have some surgery, where you don't have an ambulatory surgical center. They are 28 times less than a risk of a colonoscopy, where you don't have ambulatory surgical center. They are like hundreds of times less than you've seen these briefs. Okay. So I read them and you read them. And so what is the benefit here to giving, the woman, I can't say it's zero here, this ambulatory surgical center, when the risk is minuscule compared to common procedures that women run every day in other areas without ambulatory surgical centers?
That has never been the test under Casey about substantial obstacle. And this court in Simopolis, even before Casey, upheld an ASC requirement, and there Virginia did not require that brain surgery be performed in a hospital or an ASC. That's at 5043 of the Simopolis oral argument transcript. That's because in looking at the laws, it's whether the legislature has a legitimate purpose in acting. Legislatures react to...
Well, can the legislature say anything, General? I mean, if the legislature says we have a health-related abortion regulation here, we've looked around the country and we think that there are 10 great hospitals in the country, Massachusetts General, Brigham and Women's, and we're going to make all our abortion facilities conform to the standards of those hospitals. And that will increase medical care. Now, it's true we don't make anybody else doing any other kind of procedure conform to those standards. But we think it will increase health benefits if abortion facilities conform to them. Would that be all right?
Under this court's precedent, abortion can be treated differently. That's Simopolis, that's Missouri. And
So every abortion facility has to hit the standards of MGH. That would be all right.
There would have to be medical evidence. It is at a minimum disputed. And here, their experts have conceded that doctors believe this. This is precisely where there's a medical disagreement, even if you don't accept our medical testimony, although it was admitted into the record.
I'm sure that there's medical evidence that if every facility was as good as Massachusetts General, they would be better facilities. I'm sure that you could find doctors to say that because MGH, it's a great hospital. But that would be okay, even though it's not applied to any other kind of facility doing any other kind of procedure. Even though we know that liposuction is 30 times more dangerous, yet doesn't have the same kinds of requirements.
That was the holding in Simopolis. And in Missouri, the court...
Well, do you then,
would
where
it not
do you
be the
put
case
into...
that, would it not be the case that a state could increase the standard of care as high as it wants, so long as there's not an undue burden on the women seeking abortion? So, if they could increase the standard of care up to the very highest anywhere in the country, and it wouldn't be a burden on the women, well, that would be a benefit to them. Would there be anything unconstitutional about that?
No, provided that women are able to make the ultimate decision to elect the procedure.
But doesn't that show that the undue burden test is weighed against what the state's interest is?
Justice Kennedy,
are these two completely discrete analytical categories? Undue burden, and we don't look at the state's interest?
What Casey noted was that the undue burden test is there a purpose or an effect of a substantial obstacle to access? And that's a question about access. As to whether what the state's interest would be, that would be going to a rational basis review or maybe a purpose-based analysis, but you need the clearest proof under the Court's general doctrine about unconstitutional purpose to infer that there's an unconstitutional purpose when there's a legitimate interest in promoting patient health, which is what Texas did here. And even Roe versus Wade said that states can ensure maximum safety for patients.
What is the legitimate interest in protecting the health? What evidence is there that under the prior law, that the prior law was not sufficiently protective of the woman's health? As I understand it, this is one of the lowest risk procedures. And you give a horrible from Pennsylvania, but absolutely nothing from Texas. As far as we know, this is among the most safe, the least risk procedures, an early-stage abortion. So what was the problem that the legislature was responding to, that it needed to improve the facilities for a woman's health?
In Petitioner's first lawsuit, Planned Parenthood admitted that over 210 women annually are hospitalized because of abortion complications. Here, JA 266.
As compared to childbirth, many, much riskier procedure, is it not?
Well, the American Center for Law and Justice and former abortion providers' amicus briefs dispute that. But regardless, there is evidence.
Is there really any dispute that childbirth is a much riskier procedure than an early-stage abortion?
Justice Ginsburg, those amicus briefs point out that when you look at record linkage statistic instead of complication reporting, there may be a difference. And the reason why reporting is important is there's evidence in the record here that abortion complications are underreported. That's at JA 844 and 870 to 72. In fact, Petitioner Whole Woman's Health
underreported. Most of the complications you're talking about were reported at hospitals, correct?
Well,
yes, there's some evidence of not reporting other things outside the hospital, but you know the number of hospitals are accurately reporting.
Well, abortion clinics have to report complications in Texas. And Petitioner Whole Woman's Health, and this is a JA 606 to 700.
Complications within their clinic.
That's right. And a JA 606 to 700, Petitioner Whole Woman's Health
What's the percentage of 210 from 70,000? My math is pretty horrible. But it's pretty small.
And the statistic at JA 266 is that it is lower than 1%. However, when there are 2 to 3 women...
I don't mean to negate that one should try to avoid injury to anyone, and don't take my question as that. But there are people who die from complications from aspirin. It may be unusual, but there's a certain percentage that do that. Yet we don't require that people take aspirins in ACS centers or in hospitals.
But in examining...
There has to be some tie between the benefit and the burden, doesn't there?
Well, in examining not effect, but the purpose, the constitutional analysis would be, did the Texas legislature have an invalid purpose? And
well, don't you think that you can read that from the fact that there are so many other medical treatments whose complication rates are so disproportionately higher, and the legislature is only targeting abortion, when there is nothing about the figures before it that show a risk so unusual that it needs greater attention.
But that would have been Simopolis, it would have been Zurich, and this is why petitioners are trying to upset the balance that was struck in Casey.
See where this fits in. I mean, to the argument, I don't question their purpose. I won't question their purpose.
Good. Thank you, Justice Breyer.
But what their purpose is that they're worried about these complications and they want to make life safer for the women. All right, let's take that as the purpose. You've said there aren't very many complications. Now, would you say if you reduce the number of clinics, as has been argued, maybe it isn't exactly that, but that, and you suddenly have at least 10,000, maybe a few less, and maybe a few more, women who have to travel 150 miles to get their abortion, maybe more, maybe stay overnight, maybe try to scrape together the money. You understand the argument. Are there going to be more women or fewer women who die of complications due to an effort to create an abortion? I mean, you read the briefs, and you've read the same articles I have. And, of course, the argument is if you lead to self-induced abortion, you will find many more women dying. So if the concern is this tiny risk of dying through a complication in a clinic, is this a remedy that will, in fact, achieve the legislature's health-saving purpose?
Justice Breyer, about self-induced abortion, the evidence in the record on that were two points of testimony, both from McAllen, where petitioners prevailed. As-applied challenges could be brought in areas, for instance, if there could be shown a substantial obstacle based on travel distance. The 4 clinics that closed in West Texas between El Paso and San Antonio, all of those closed before the admitting privileges requirement took effect. They were all Planned Parenthood facilities. In petitioners' first law...
As-applied challenge is a real problem with that, because suppose you bring in that as-applied challenge and you're successful, you can't have a creation of an ambulatory surgical center on the spot. I mean, these once these facilities are closed, they're closed, and they can't start up tomorrow. So the as-applied challenge, I mean, the woman's problem would be long over before this clinic, the kind of clinic they had before, could be restarted.
Justice Ginsburg, the McAllen Clinic reopened, and as Justice Kagan mentioned, clinics did reopen. The Lubbock facility, though, which is one of the facilities in West Texas, in petitioner's first lawsuit, they told this court in their application that that clinic was going to close regardless. Now, 7 of the 8 clinics that closed before the admitting privileges requirement took effect, and went from 41 to 33, 7 of those 8 were Planned Parenthood clinics. Planned Parenthood is complying with the law and providing that increased standard of care. And also the 11 clinics that closed the day that the admitting privileges requirement took effect, when it went from 33 to 22, I don't believe 6 of those clinics can be deemed to have ceased performing abortions because of that requirement. The Lubbock facility was going to close anyway. Killeen had admitting privileges. That's J401.
There was a stipulation that is no currently licensed abortion facility meets the ASC requirements. Each will be prohibited from performing abortions after the day the law goes into effect. That's a stipulation, not a question of what evidence there was for. Texas stipulated that no currently licensed facility meets ASC requirements, and each will be prohibited from performing abortions.
And that would go to the ASC requirement as opposed to the facial challenge to the admitting privileges requirement. But 4 of the facilities that reopened, 4 facilities reopened of those 11 when the admitting privileges requirement went into effect. That was Dallas, 2 at Fort Worth, 1 in Austin. It's JA 131, 715, 1111, and 1436. 2 of those were ASCs. Now, when it comes to the count of ASCs, there are 9 ASCs performing abortion today in Texas. 3 opened up after House Bill 2 was passed. So in examining the facial challenge to that requirement, when ASCs exist...
Were they opened as a result of the law, or were they planned to be opened before the law went into effect? Because I think that makes a difference to me. If they were planned to be open, it takes quite a while to dig up the money, get the investors, buy the land, do the building. It seems to me that they must have been planned for a while, and if they were, it was because there was a need independent of the number of abortions. Well, in other words, it's fortuitous that they've come into existence, but it was their need was not there, was independent of the reduced number of facilities elsewhere.
Well, the legislature provided 13 months to come into compliance. In addition, you could lease space. Texas has over 430. There were 433 general ASCs in Texas at the time.
Most of them don't choose to provide abortion.
That's correct. Of course, space could be leased in those.
So what you don't know is, do you have enough resources to open up an ASC if you're going to do abortions? Are you going to get enough developers to invest in your work?
Yeah. And the point being that there are going to be at least 10 clinics.
Can I ask about McAllen? There was testimony in the record that at least 4 doctors had from that spot had asked for admitting privileges. The Fifth Circuit's remedy only provided for one doctor, Dr. Lynn, who's past retirement age, to be the only doctor performing abortions in that clinic. Now, if the clinic had 4, I don't know how many it had, but it had at least 4 people before, it seems rather callous to say as a remedy that we're going to make that one doctor do the work of 4, or maybe more doctors who didn't get admitting privileges. Why is even the Fifth Circuit's remedy reasonable?
Because, Justice Sotomayor, that was the only named plaintiff for the as-applied.
But if yes, as applied, the ASCS law is affecting this clinic because it can't get its doctors certified. So why does it require a named plaintiff to relieve that clinic of the obligation of going without admitting privileges?
Well, that was the only one of the 4 doctors that joined this lawsuit, because most of the doctors and clinics in Texas are not part of this lawsuit. But you just lift the requirement because you know that it's the only clinic in the area. Well, so if any doctor who's licensed appropriately can get admitting privileges, they should be permitted to work in that clinic. Why does Dr. Lynn have to become an indentured slave to ensure that women in her area are provided with their fundamental right to choose? Justice Sotomayor, it would not be an indentured situation. If there were new facts that came into being that doctor ceased to perform abortion, then another doctor could bring in a future as-applied challenge.
Right. General, could I ask? Could I go back to a question that something that you said earlier, and tell me if I'm misquoting you. You said that as the law is now, under your interpretation of it, Texas is allowed to set much, much higher medical standards, whether it has to do with personnel or procedures or the facilities themselves. Higher medical standards, including much higher medical standards for abortion facilities than for facilities that do any other kind of medical work, even much more risky medical work. And you said that that was your understanding of the law. Am I right?
Correct. And this court's in Scottus.
And I guess I just want to know, why would Texas do that?
When there are complications from abortion that's in the record, Texas can enact laws to promote patient safety.
No, I know, but the assumption of the question, and I think you haven't challenged this assumption, is that there are many procedures that are much higher risk. Colonoscopies, liposuctions, we could go on and on. And you're saying that's okay, we get to set much higher standards for abortion. And I just want to know why that is.
Justice Kagan, this bill was passed in the wake of the Gonzales scandal that prompted Texas and many other states to re-examine their abortion regulations.
But of course, Texas's own regulations actually have made abortion facilities such that that can never happen because you have continual inspections. I mean, to your credit. So that was really not a problem in Texas. Having a kind of rogue outfit there. Texas has taken actions to prevent that. So, again, I just sort of am left wondering, given this baseline of regulation that prevents rogue outfits like that, why it is that Texas would make this choice. And you say you're allowed to make this choice, and we can argue about that. I just want to know why Texas would make it.
I think the amicus brief for the 121 Texas legislators that canvasses the medical evidence and canvasses statements confirms that there were complications, that these laws do have benefits. Indeed, even bill opponents said
you're not really contesting that there are greater complications in abortion facilities than there are with a great deal of medical procedures that are not subject to the same standard of regulation.
Yeah, brain surgery, for instance, just like Simopolis, would almost certainly have it would have higher risks of complication. But
General,
the court
as to rogue facilities, which Justice Kagan just mentioned, one of the amicus briefs cites instance after instance where whole woman's facilities have been cited for really appalling violations when they were inspected. Holes in the floor where rats could come in, the lack of any equipment to adequately sterilize instruments. Is that not the case?
Stories similar to that are also raised in the 121 Texas legislators' amicus briefs.
These are not stories. These are, as I understand it, actual reports of inspections of those facilities.
The amicus briefs do discuss that, and the complications from whole woman's health were underreported to the state. That's JA 606.
Texas, under the prior law, has the right to make random inspections. The problem in Pennsylvania was this filthy clinic hadn't been looked at by anyone from the state in 16 years. But Texas can go into any one of these clinics and immediately spots a violation. It says you can't operate till you come up to speed. So Texas had, as Justice Kagan pointed out, its own mechanism for preventing that kind of thing from happening.
Texas did have existing regulations, but increasing the standard of care is valid, particularly not only in light of
It's valid only if it's taking care of a real problem.
And there were abortion complications and underreported.
Well, no, a real problem, meaning Gonzales, the governor of Pennsylvania, said was a regulatory failure, and only in that this clinic had not been inspected for 15 years. The doctor was fabricating his reports. That could happen almost in any setting. Anyone who intends to break the law is going to break the law, whatever the regulatory rules are. You're going to have doctors, as happened our laws, who were performing abortions without permission in their offices or without licenses. And I don't want to suggest that we should presume that's going to happen, but it will happen.
But the constitutional standard for whether a state can make abortion safer can't be that it can only prevent a Gonzales situation.
Well,
and there are complications.
But you have to see, as Justice Breyer asked you earlier, why are the problems? Isn't this a self-created problem? What happened in Texas, independent of Gonzales, that raised a Gonzales-like situation in Texas that made legislatures so concerned after so many years about taking care of this greater risk in abortions as opposed to all the other procedures that are performed in non-ACS facilities?
Because there are complications in abortion, and this was
there is complications in colonoscopies, and colonoscopies are what, 15 times 28. Justice Breyer just corrected me. 28% higher.
But legislatures react to topics that are of public concern. In Gonzales, the court noted that after Dr. Haskell's procedure for partial birth abortion became more of a nationwide concern, states reacted. When the legislature sees that there's a problem, and maybe that there wouldn't rise to the same level of a Gonzales problem, but the legislature can still act to make abortion safer, which is precisely what Texas did here. If I can address my friend's contention of the record as to what clinics closed preemptively. There's evidence in the record that Killeen, McAllen, and El Paso, 3 clinics, closed preemptively. They brought as-applied challenges in McAllen and prevailed. They brought their as-applied challenge in El Paso and did not prevail. And the Killeen clinic did not seek as-applied relief. Indeed, if there are any future concerns as-applied challenges can be raised. For instance, the wide swath of area in West Texas does not have an abortion clinic today. There was no as-applied relief sought in this case. And if it would turn out that there were going to be an issue in that area, a future as-applied challenge could address that concern.
Well, that's the problem. Once the clinic closes, you said McAllen reopened, but that was very swift. Once a clinic closes, the equipment are gone, the doctors are gone. You can't reinstate it tomorrow. It won't be there. There will be no remedy for that woman who succeeds in the as-applied challenge.
Mr. Chief Justice, your time has expired, if I may address it. Except even there, the clinic was not just closed for a single day. It was closed for a longer period of time. There was an El Paso clinic that actually reopened also months later. So an as-applied challenge could allow a clinic, if an undue burden, if a substantial obstacle were shown because of driving distances or capacity in the future in that discrete instance. But when we're in this facial challenge posture, petitioners bear the heavy burden to show at least a large
self-evident in any area that this area of western Texas is as big as California, no? Bigger?
Well, I'm not sure about California, but it certainly is a large size.
Area.
Absolutely.
Why isn't it self-evident if you have a law that says you can only be an ACS provider, and who's going to come in and say, I can't be an ACS provider, but it's an undue burden on me, or it's an undue burden that's self-evident on the women in that area?
Well, the right is possessed by the women, but clinics and doctors can bring
So why
challenges.
don't we take this lawsuit as those women saying just that?
Because there was
you can't have a law that has marginal, if any, medical benefit be applied to this procedure anywhere where there's an undue burden on women.
Planned Parenthood had 4 clinics in West Texas. They all closed before any part of HB2 was actually put into effect. They could have brought an as-applied challenge. They didn't. Planned Parenthood did not join this lawsuit. They were part of the first lawsuit. And indeed, the facial challenges here are barred by res judicata, and there are significant record gaps.
May I ask you one question? Earlier in your argument, you were quoting how many women are within a reasonable range of the clinic. But don't we know from Casey that the focus must be on the ones who are burdened and not the ones who aren't burdened? There is, in the district court said, this is not a problem for women who have means to travel, that those women will have access to abortion anyway. So in Texas or out of Texas. So Casey was quite precise in this when it's talking about husbands and notification. You don't look to all the women who are getting abortions. You look only to the women for whom this is a problem. And so the only women we would be looking at is not all the women who live in Austin or in Dallas, but the women who have the problem, who don't live near a clinic. Isn't that the clear message of Casey and the husband notification?
When a law is regulating women, as it would in the spousal notification provision, that might be different. But when we're talking about doctor and clinic regulations, when the law is going to have a relevant effect is going to be for every doctor and every clinic, which is precisely why the Fifth Circuit noted that that was the proper denominator, all women of Texas reproductive age, and petitioners have not challenged that denominator holding in their open
But this
brief.
is about, what it's about is that a woman has a fundamental right to make this choice for herself. That's what that's the starting premise. And then this is certainly about, Casey made that plain, that the focus is on the woman, and it has to be on the segment of women who are affected.
Yes, and the right held by women to make that ultimate decision is not burdened, and at a minimum, a large fraction of cases in Texas, when each metropolitan area will still have a clinic even after the law goes into effect, and future as-applied challenges could address any possible concerns about West Texas or otherwise.
Thank you, counsel.
Thank you, Mr. Chief Justice.
Ms. Tody, you have 5 minutes remaining.
Thank you. A few brief points. First, the record cites from earlier evidence that HB2 caused clinics to close in Texas. The plaintiffs testified that HB2 caused clinics in Killeen, Austin, Beaumont, McAllen, and El Paso to close, and that testimony is at JA 339, 715, 722, and 731. Respondents stipulated at JA 183 and 184 that the ASC requirement would cause any licensed abortion facility still operating on the day it took effect to close. Plaintiffs' Exhibit 28 at page 2, which is not in the joint appendix but was admitted in the record at 2808 and 09, demonstrates that for the 5 years prior to the enactment of HB2, the number of abortion clinics in Texas remained fairly constant. And finally, at JA 229 and 1430, there is at 229 testimony from Dr. Grossman, and at 439, our response to the Fifth Circuit's directive showing that 11 clinics closed on the day that the admitting privileges requirement
That's the last evidence was from Dr. Grossman?
JA 229 is from Dr. Grossman.
At page 232, he said, I am not here offering any opinion on the cause of the decline in the number of abortion facilities.
That's correct. Dr. Grossman did not offer an opinion on that, but his testimony supplies the fact from which the district court drew the inference that 11 clinics closed on the day that the state first enforced the admitting privileges requirement. The district court referred from that fact that enforcement was the cause of the closure, and respondents offered no alternative explanation for why there would be such a precipitous drop in the number of abortions.
Can you tell me why Planned Parenthood left the western area? The general says that Planned Parenthood, that ACS and the admitting privileges had nothing to do with the closures in the western area of Texas.
Well, the two clinics in El Paso, which is in that western region of Texas, that would be forced to close as a result of these requirements, are not operated by Planned Parenthood. Planned Parenthood doesn't have any clinics in Texas. The plaintiff in this case and another independent provider operate those clinics.
And as to the clinics where there is direct evidence, does the direct evidence show whether the cause was the admitting privileges requirement or the ACS requirement or both?
With respect to it does specify, and some specify the admitting privileges requirement, and some specify the ASC requirement, and some specify both. So with respect to whether abortion can be regulated differently than other medical procedures, abortion can certainly be treated differently if there's a reason to treat it differently, but Texas may not impose unnecessary medical regulations that burden women's access to abortion. In Simopolis, the court found that the regulations of second trimester procedures at issue in that case were consistent with prevailing medical standards at the time, and that was critical to the court's decision. That is not the case here. There is extensive testimony in the record that these requirements are not medically justified. They are not consistent with prevailing medical standards, and there are amicus briefs from leading medical associations, including the AMA and ACOG, confirming that.
Do you think that federal district judges or this court is well qualified to determine whether there's a different risk with respect to abortion as compared to other procedures that may or may not have to be required, may or may not have to be performed in an ASC?
Your Honor, district courts are quite competent to determine the credibility and the reliability of expert testimony. That's something that's within the core competence of a trial court. And the trial court in this case determined that there was no credible or reliable evidence supporting Texas's contentions about the medical justification for these laws. And further, had Texas truly believed that these laws provided some important benefit for outpatient surgery, it would have made them generally applicable. All outpatient surgical providers would have to have admitting privileges or practice in an ASC, but that's not the case. Texas law expressly authorizes other surgical procedures, including those performed under general anesthesia, which early abortion is not, to be performed in a physician's office. And even other physicians that operate at an ASC aren't required to have admitting privileges. The facility is merely required to have a transfer agreement. So these regulations target one of the safest procedures that a patient can have in an outpatient setting for the most onerous regulations.
Thank you, counsel. Case is submitted. Justice Breyer has our opinion this morning in Case 15-274, Whole Women's Health versus Hellerstedt.
We here consider the constitutionality of two statutory provisions of Texas law, both of which regulate facilities where abortions are performed. The first provision concerns hospital admitting privileges. Before that provision was enacted, Texas law required an abortion facility to maintain a written protocol for managing, among other things, the transfer of patients requiring emergency care to a hospital. The law before us adds a requirement that a doctor performing or inducing an abortion have active admitting privileges at a hospital within 30 miles of the facility where the abortion is performed. The second provision says that, quote, the minimum standards for an abortion facility must be equivalent to the minimum standards for ambulatory surgical centers. We have to decide whether these two provisions are consistent with the federal Constitution as interpreted in our 1992 case, Planned Parenthood versus Casey. We find that they are not consistent with the constitutional standards set forth in Casey, and we hold both provisions unconstitutional. The Federal District Court, after a trial, found the two provisions were unconstitutional. They constituted an undue burden on a woman's right to choose. The Court of Appeals for the Fifth Circuit reversed. We, in turn, agree with the District Court, and we reverse the Court of Appeals. The Fifth Circuit upheld the two provisions in question for several different reasons, independent reasons often, and we explain at length, in our opinion, why we reject each of those reasons. I shall here summarize our basic reasoning. First, the Court of Appeals pointed out that some of the doctors who brought this lawsuit had been part of an earlier case in which they also challenged the constitutionality of the admitting privileges requirement. They lost the case. For that reason, the Court of Appeals held this lawsuit is barred by principles of res judicata, which is a legal doctrine that says, in essence, you only get one bite at the same apple. The question, however, is whether what we have here really is the same apple. Seeking the answer to that question in well-established legal principles, we conclude that it is not the same apple. The restatement of judgments points out that, quote, material operative facts occurring after the decision in a first action may provide a basis for a second action, even if the second action in other respects resembles the first. Suppose a group of prisoners claim that a state is violating the Constitution by making them drink unhealthy water, and they lose the claim, not enough evidence. But then suppose quite a few of them die of water contamination. Because of that new critically important evidence, they could bring a second action, similarly attacking the constitutionality of the state's actions, even if the second action was in other respects, like the first. The plaintiffs here brought their first case before the Texas law took effect. They brought this second case after it had actually taken effect and clinics had actually closed. So we think it's rather like the prisoner hypothetical. Second, the circuit court thought that the physicians should have brought their challenge to the surgical center requirement earlier. At the time they first challenged the admitting privileges requirement, the court concluded that that same doctrine about the apples, res judicata, means that because they could have brought the surgical center challenge then, they can't bring it now. In our view, however, res judicata does not require those who wish to challenge one part of a complicated regulatory law, say like the long law that regulates securities or drugs. It doesn't require them to challenge every part of that complex statute at the same time. The provisions that are challenged here are distinct regulatory requirements, and so the doctors are free to challenge the surgical center requirement here in this new action as they have done so. Third, Turning to the constitutional merits, we think the Fifth Circuit applied the wrong legal standard. That court said, quote, medical uncertainty underlying a statute is for resolution by legislators, not by courts. In Casey, however, the plurality wrote in its governing opinion that, quote, a statute which, while furthering a valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice, cannot be considered a permissible means of serving those legitimate ends, and it added unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion imposes an undue burden on that right. And in Gonzales v. Carhart, we pointed out the court retains a, quote, independent constitutional duty to review factual findings where constitutional rights are at stake. We follow, as we must, Casey and Gonzales here, and in doing so, we decide whether there is undue burden, looking to the existence or non-existence of medical benefits, as well as the burden the law imposes on a woman's access to abortion facilities. Fourth, we find adequate legal support in the record for the district court's conclusion that the admitting privileges requirement imposes an undue burden on a woman's right to have an abortion. The purpose of the requirement is to help ensure that women have easy access to a hospital should complications arise during an abortion procedure. But the district court described abortion procedures in Texas as already extremely safe, and it found that when compared with prior law, which you will remember already insisted upon a written protocol for transferring patients to a hospital in case of need. In comparison to prior law, the court said the admitting privileges requirement brought about no health benefits. The record backs this finding up with peer-reviewed studies, with detailed expert testimony, which we describe in our opinion. Indeed, when directly asked at oral argument whether Texas knew of one single instance in which the new requirement would have helped even one woman obtain better treatment, Texas responded that there was no evidence of such a case in the record. At the same time, the district court found that as of and soon after the time Texas began to enforce the new requirement, the number of facilities providing abortions in Texas dropped from about 40 to about 20. The record contains sufficient evidence of a causal connection between the new law and those closures. The closures mean fewer doctors, longer waiting times, increased crowding, and significantly greater travel distances, all of which, when taken together, burden a woman's right to choose. In sum, the admitting privileges requirement places a burden upon a woman's right, which, given the lack of health benefit, is undue. Fifth, the second provision of Texas law requires an abortion facility to meet Texas minimum standards for ambulatory surgical centers. We conclude that this provision, too, imposes an undue burden upon a woman's right to choose. Before enactment of the provision, abortion facilities were required to meet, and they still are required to meet, a host of health and safety standards involving, for example, staffing, physical facilities, infection control, medical procedures, clinical procedures, patient rights, and others. The surgical center provision requires, in addition, that a facility maintain, for example, personnel trained in cardiac life support, an operating room with a clear floor area of at least 240 square feet, a post-operative patient holding room, a post-operative recovery suite, a one-way traffic pattern, and they must meet special surgically related standards concerning ventilation, air conditioning, piping, plumbing, and others. The district court found that requiring abortion facilities to meet these requirements will not provide women with better care or more frequent positive outcomes, and the record adequately supports this conclusion. It shows, for example, that abortions in Texas prior to the new law were safe, with a total of 5 deaths occurring over 10 years, or about 1 per 120,000 to 140,000 abortion procedures. By way of comparison, childbirth, ordinary childbirth, is 14 times more likely to cause death. Colonoscopy has a mortality rate 10 times as high. And liposuction has a mortality rate 28 times as high, but Texas allows these latter procedures to take place at home or in a doctor's office. The record further supports the district court's conclusion that many of the surgical center requirements, such as standards designed to maintain sterile operating facilities, have nothing to do with medical abortions, where complications, should they arise, normally arise after the patient has left the facility. At the same time, enforcement of the surgical center requirements will place a substantial obstacle in the path of a woman seeking an abortion. The cost of compliance is high. To the court where the court found it would reduce the number of abortion-providing facilities in Texas. Remember, it started at 40 to 7 or 8. The district court wrote that the proposition that these 7 or 8 providers could meet the demand of the entire state stretches credulity. The Court of Appeals said that that was clearly erroneous, but the finding rested upon the uncontested statement of an expert witness that the number of abortions the 7 or 8 clinics would have to provide would have to rise from 14,000 annually to 60 or 70,000. That's an increase by a factor of 5. And we think it's adequately supported, that conclusion, in the record. Suppose someone told you that a certain grocery store now serves 200 customers a week. A certain apartment building now provides apartments for 200 families. A certain train station now welcomes 200 trains per day. Well, it is conceivable that the store or the apartment building or the train station could just as easily provide for 5 times as many for 1,000 customers, families, or trains at no significant additional cost, crowding, or delay. But most of us would find this possibility highly improbable. In this case, Texas, looking outside the record, pointed to one new clinic that is able to serve 9,000 women annually. But were we to look outside the record, which we normally would not do, we would also have to note the construction of that clinic, the largest in the nation, seems to have cost $26 million, a fact that militates against, not in favor, of the ability of the 7 or 8 clinics to serve a large fraction of Texas women seeking an abortion. The upshot is that we find adequate legal support for the district court's finding that the surgical center requirement, like the admitting privileges requirement, provides few, if any, health benefits for women, poses a substantial obstacle to women seeking abortions, and constitutes an undue burden on a woman's constitutional right to do so. Sixth, finally, Texas argued here that in any event, we should not hold the 2 provisions of Texas law unconstitutional on their face, i.e. across the board, because of the statute's severability clause. Rather, the court should proceed clinic by clinic, examining each application of the provisions to see whether they impose an undue burden as applied in each particular case. In our view, however, the severability clause does not compel us to proceed clinic by clinic. We have determined that the provisions are facially unconstitutional based on the undue burden they impose on the large fraction of women they affect. Having reached that conclusion, proceeding application by application would impose enormous costs, both on courts and on litigants. It would also allow legislatures to insulate statutes from facial review. We consequently reject that approach. We elaborate further upon these and other matters in our opinion. For the reasons stated, and those contained in our opinion, we hold that the 2 provisions of Texas law, the admitting privileges requirement and the surgical center requirement, are unconstitutional, and we reverse the Fifth Circuit's determination to the contrary. Justice Ginsburg has filed a concurring opinion. Justice Thomas has filed a dissenting opinion, and Justice Alito has also filed a dissenting opinion, which the Chief Justice and Justice Thomas join.
We are supposed to be a neutral court of law, and that means that we have an obligation to apply the same legal rules regardless of parties and regardless of the nature of the case. Over the years, members of this Court have expressed strong and conflicting views about the constitutionality of laws regulating abortion. But when it comes to ordinary legal rules that apply in all cases, there is no justification for treating abortion cases differently from other cases. But with respect to that is what the Court has done in this case. The Court of Appeals held that the parties that brought this case were barred from doing so by the doctrine of res judicata, and the Court was correct. Now, that holding did not mean that these provisions of the Texas abortion statute would escape constitutional review. It meant only that these petitioners, these parties, could not bring another case challenging those provisions in the same way they challenged them in the first case. Other parties could challenge those provisions. Women seeking abortions in Texas could challenge the provisions. Other clinics could challenge the provisions. Other doctors could challenge the provisions, but not these petitioners. Res judicata, or to use the more modern terminology, claim preclusion, is a dry legal doctrine, and I am not going to go into a lot of details this morning. But I do want to say a couple of things. First, although the doctrine is dry and technical, it is important. In simple terms, it means this. If a party brings a claim in court, has a fair opportunity to make its case, and loses, and the judgment becomes final, the party cannot file another case raising the same claim. If we did not have this rule, litigation would never end. You know the old saying, if at first you don't succeed, try again. Well, that would be the rule, and that's the rule that the Court basically adopts in this case. If at first you don't succeed, sue again. The petitioners in this case filed an earlier case in which they targeted a provision of the Texas law requiring a doctor who performs abortions to have admitting privileges at a nearby hospital. They brought what is known as a facial claim, and what that means is that they claimed that the law is unconstitutional across the board. Petitioners had a fair chance to litigate that claim. They won in the district court, but they lost on appeal in the Fifth Circuit. They could have asked this Court to review the Fifth Circuit's decision. They decided not to do that, and the judgment against them became final. Then they went back and they filed a second lawsuit, but they did not try to relitigate their facial claim. If they had done that, they would have been subject to sanctions for abusive litigation. Instead, they raised a different claim, namely that the admitting privileges requirement is unconstitutional as applied in some parts of the state. The district court then did what petitioners had not dared to do. It revived the facial claim on which it had previously been reversed, and it again entered judgment for the petitioners, declaring that the requirement is unconstitutional across the board. This was obviously wrong, and the Fifth Circuit so held, but the Court now reverses. On what basis? The Court says that circumstances changed between the time of the first and the second cases. What this really means is simply that the Court thinks that petitioners had better evidence at the time of the second case than they did at the time of the first. This is contrary to a cardinal rule of res judicata. A party that loses the first time does not get a second chance just because that party has better evidence. If that were the rule, litigation would never end. A final judgment would not finally resolve the dispute, as it is supposed to do. Instead, it would just signal to the losing party to start looking for more and better evidence and then sue again. Now, Justice Breyer said that the Court's holding on res judicata in this case is supported by established legal principles. I invite you to read the Court's opinion and search for those established legal principles. You will not find any. The doctrine of res judicata predates the founding of this country. That's why it's in Latin. The Court does not cite a single decision of this Court that supports its decision. It does not cite a single lower court decision that supports this decision. The established legal authority boils down to a comment in the second restatement of judgment. Now, the Court ignores the fact that if you look at the actual rules in the second restatement of judgment, you come to the conclusion that the Court of Appeals was right. But the Court picks out a comment to one provision in this scholarly work and distorts the meaning of that, and that is the basis for its holding with respect to res judicata of the admitting privileges claim. Now, I'll say just a word about the other claim, the ambulatory surgical centers claim. This is not a case in which the two provisions just happen to be two provisions of a lengthy code like two provisions of the Internal Revenue Code. These are two very closely related provisions that are attacked by the petitioners as a package. Their claim is that these two provisions together cause the closure of clinics. They have made no effort to separate the effects of the two provisions. They describe them as delivering a 1-2 punch. Well, if the parties in lower courts apply the Court's res judicata holding here, in other cases, the law will be revolutionized. But perhaps they will recognize that this is an abortion case, and therefore the ordinary rules do not apply. I will not say more about res judicata, but I will add a few words about another holding that shows with unmistakable clarity that the Court refuses to apply neutral legal rules. The Texas statute contains what is known as a severability provision, and the issue of severability comes up when we hold that part of a law with numerous provisions is unconstitutional. What happens in that case to the parts that are valid? What matters is the intent of the legislative body that enacted the law. If the legislature thought that all the provisions are so bound up with each other that if one goes, the rest can't function as they should, then the entire law is out. But if the legislature thinks that the unconstitutional provision or provisions can be severed from the rest of the law, there is no ground for throwing out the valid provisions. The Texas law here involved in this case contains the strongest severability provision that this Court has ever seen. It is hard to imagine how a stronger one could possibly be drafted. It says that every single word in the statute and every single application of the statute is severable. The legislature made it perfectly clear that if any part of the law was found unconstitutional, it wanted to save as much of the rest as possible. The Court totally disregards the severability provision in this law. The Texas statute says that abortion clinics have to comply with all the regulations that govern ambulatory circular centers, ambulatory surgical centers. These regulations are voluminous. This is a printout of them. The Court holds that every single one of these regulations must go. Now, this morning, Justice Breyer cited 3 or 4 that supposedly impose a great financial burden on abortion clinics, and that may or may not be the case. But the Court's holding is not limited to those few provisions. Every single provision is held to be unconstitutional. Many of these are innocuous. Here are some examples. Patients must be treated with respect, consideration, and dignity. Is that unduly burdensome? Is that unreasonable? Nevertheless, it's gone. Patients must not be given misleading advertising regarding the competence and or the capabilities of the organization. That's gone. Centers must maintain fire alarm and emergency communication systems. That's gone. They must eliminate hazards that might lead to slipping, falling, electrical shocks, burns, poisoning, or other trauma. Gone. Why? There's verbiage in the Court's opinion, but it comes down to this, and this is what you just heard. It would just be too much work to go through all these regulations and figure out which are okay and which are not. So they all have to go. This is an abuse of our authority. We have no authority to strike down perfectly valid provisions of state law. And the work that should have been done is not work that this Court needs to do, going through all of these regulations one by one. It's work that the petitioners should have done in the district court and that the district court should have done. It should have identified the provisions that supposedly impose the undue burden and the rest should have been allowed to stand. Because the majority in this case has not done what a court of law must do, apply the law in a neutral manner regardless of the parties or the nature of the case, I respectfully dissent.